All right, everybody. Welcome back to Matrix Media. Thanks for coming in. I really appreciate it. Today, we're going to be covering a live trial, day 2, Abby Zwerner versus Dr. Ebony Parker. This is about a school shooting. A 6-year-old student shot the teacher, Abby Zwerner, Abigail Zwerner. This is in the state of Virginia. And she is suing Ebony Parker, Dr. Ebony Parker, who is the assistant principal of the school. And basically she's the only one, because she did nothing. Several people, 4 different people told her about a gun in a backpack, a confirmed gun in a backpack by the student. She gave no permission to search. She gave no permission to do anything, basically. And she did nothing herself. So turns out the teacher ended up being shot by the student and caused some very long-term damage and effects to her. And she was only 25 years old at the time. She just started her teacher career. Her whole career is gone due to the negligent acts of Dr. Parker. So we're going to check that out today and watch day 2. I've got to go to work this morning, so I'm going to get you guys going, be here for a little bit, and then I'll be back later on to check in and the live stream for you guys. And then I'll be doing a 6 o'clock live stream as well. We'll be covering something different, probably some just live court. All right, let's get into it. Check it out.
Honorable Judge Matthew Hoffman presiding. As always, there'll be no talking. While His Honor is on the bench, you may be seated.
Good morning.
Morning, Your Honor.
All right, what are we taking up first?
Your Honor, the parties conferred last night and again this morning regarding the substance of Dr. Scheffelbarger's anticipated opinion testimony. She's the administrating expert on the behalf of the plaintiff, and we, as Ms. Douglas pointed out earlier, tried to reach agreements as it relates to sort of the scope of her testimony akin to the scope of defense counsel's experts' testimony that may be opining on the same topic areas. Here's where we are. We have specifically highlighted for defense counsel within the expert disclosure of Dr. Scheffelbarger, which I have and I can provide to you if it's helpful in a highlighted form, or if you have your own copy, I can point you to those portions.
I just want to make sure I've got page 3 and 4 of your expert designation.
And that is exactly where we're focused.
Okay.
And would Your Honor like me to point out what we're talking about? So on page 3, essentially the third paragraph down, there's a sentence that begins with, "It is a fundamental expectation." It's the third sentence down. So we intend to elicit the testimony of Dr. Scheffelbarger related to that opinion all the way to where the sentence ends with the word enforcement.
So is that on her? Is that your designation or her opinion that you're talking about?
It is her written letter opinion.
Okay, so are we under opinions, paragraph 4 of her opinion?
We are, yeah, so if you, on subheading 4, if that's what you're looking at, then there's a subheading summary.
Yes.
If we flip to the next page,
Okay.
there is a paragraph, 2 or 3 paragraphs down, it's kind of in between. It starts with, "It is even more concerning." There's a paragraph there at the top that starts with that language.
Yes, okay.
And then the very next sentence starts with the language, "It is a fundamental expectation." So beginning with that line, "It is a fundamental expectation," through the end of that sentence, which ends with the word enforcement. That is an area of opinion testimony that we intend to elicit. And then there is the last sentence, second to last sentence within that very same paragraph, which starts with, "She should have conducted." And then that sentence ends with, "at that time."
All right.
Now, the next sentence is effectively part of the agreement reached with counsel, so I'd like to elicit or explain that, Your Honor. There was discussion in pretrial motions about the issue of causation, and we alerted the court in the event that defense counsel intended or anticipated making any type of motion to strike or motion that we had not met a burden because we didn't elicit expert testimony on the issue of causation. That is why we had preemptively designated those opinions in the event that the court or the parties deemed it appropriate or necessary. We've now conferred, and the parties agree that this case will not have a motion to strike or a deficiency motion on the grounds that an expert didn't opine on the issue of causation. And as a result of that, neither Dr. Scheffelbarger nor the experts who may be proffered by defendants will be opining on the issue of causation or proximate causation.
All right.
So then we get into the paragraph, 2 paragraphs down. The paragraph starts with the heading or the title "at 140," but the sentence that I'm going to call the court's attention to is halfway through. It starts with the words, "It is inconceivable." that a school administrator whose primary responsibility, and then it goes on from there, and ends with,
Is that which sentence is that?
sure, it is inconceivable that a school administrator whose primary responsibility is to ensure a safe and secure environment would, after being informed, and then it continues and ends with the word parent.
All right.
Then when we get into the next area, the subheading conclusions at the bottom, Your Honor, essentially the top, really everything until period, everything on that paragraph, the portion that we don't intend to elicit, but that we'd like to alert the court of, is that there's a section there at the bottom that says would be expected to take immediate decisive action to safeguard students, staff, and the broader school community. And Your Honor, I'll put again on the record that we do believe that there is a special relationship duty that's been triggered by the facts that are before the court, and we do intend to make a motion later on as it relates to that, and that is because of the class of persons that Dr. Parker as a public official had responsibility to. And so our intention as it relates to her testimony on that regard, in light of Your Honor's previous rulings, is to effectively ask her about the safeguarding, but not ask her to specifically identify who she's safeguarding in that context, if that makes sense to the court.
Okay. All right, so are these agreed upon things she can testify to, or do I need to make a ruling on those 4 things?
Those are
Yeah, they
that
need
last.
to be heard on.
Okay.
Well, let me finish and then they can be heard. Then there's the last sentence, Dr. Parker's failure to act on the critical information presents, and then it goes on that last page into the word duty of care. There were discussions amongst counsel about using the term gross negligence because it appeared in some of the actual designations. Parties have agreed that we won't be eliciting, and we're going to inform our experts not to use that legal term, gross negligence, but that we recognize that there may be what we've been calling buzzwords that are contained within the jury instructions in terms of what amounts to gross negligence, whether it shocks a conscience, whether it's indifferent, that may come up during the course of the testimony, and that's sort of good for the goose, good for the gander.
All right. Maybe we can take those up as they come.
Yes, Judge. Thank you, Your Honor.
All right.
Morning, Your Honor.
Good morning.
Judge, I'd like to address a few of the issues that were raised by opposing counsel, and then Ms. Douglas can supplement. She may have additional argument that she'd like to raise that's more specific and tailored to these arguments. But at the threshold, I want to note that with respect to Dr. Shufflebarger's anticipated testimony, the defense would stand on its prior objections based on the motions in limine that her testimony is predicated on the false assumption that the underlying handbooks in internal private protocols implemented by Richneck Elementary School do not establish the standard of care and do not establish the existence of a legal duty. And moreover, it would fail for Rule 403 balancing because first of all, it would have no probative value in this case, and any probative value would be vastly and substantially outweighed by the risk of unfair prejudice and misleading or confusing the jury about the appropriate issues in this case. I stand on those prior objections, Judge. But that being said, to the extent that her testimony may come in, Judge, I would ask that the court issue a proper limiting instruction at the appropriate time so that we can mitigate the risk of the jury reading these instructions, hearing Dr. Shufflebarger's testimony, and conflating those principles by thinking that because there is a handbook that has these directives included in it, these are private rules, they don't establish the standard of care or the existence of a legal duty. So I stand on our prior objections. I incorporate them here expressly by reference. But nevertheless, to the extent that this evidence may come in, I'd ask for a proper limiting instruction. 2 other points, Judge. I heard from opposing counsel mention...
Let me catch up with you.
Yes,
Hold on
Judge.
1 second. All right, so for reference, defense filed its first motion in lim back on October the 2nd of 2025, and inside that motion in lim, there were designated a number of motions in lim. We are specifically referring to motion in lim number 3 as filed in that document that lists 2 objections that Dr. Shufflebarger's testimony improperly implies Newport News' internal policies and procedures. We'll call those internal policies and procedures objections. All right, and then there is Roman numeral 2, unfounded factual obligations. I'm sorry, assumptions. Right, and so you are obviously, those are continuing, correct?
Yes,
that I
Your Honor,
need to
that's
rule on. All right. And then you're saying that, assuming that I do overrule you on those 2 points, then you are going to proceed with another argument. Is that correct?
Yes, I would specifically just ask the court to issue or allow us to issue a proper limiting instruction, as we have done with the other similar rulings with respect to the handbook and internal policies generally.
All right, and what is your framework for that? I mean, what are you planning on offering for that?
I think at this stage, there's something that I would like to coordinate with opposing counsel at the appropriate time. We have not discussed the specifics, but I imagine a cautionary instruction would be something to the effect of, ladies and gentlemen of the jury, you've heard evidence of internal policies and procedures implemented by Richneck that were in place at the time of the incident. Under Virginia law, these do not establish the existence of a legal duty. These do not establish the governing standard of care in this case. Nevertheless, you may consider it for another purpose. And there are some specific purposes that are authorized in the case law, and we can hash that out with opposing counsel.
All
But
right,
at this
so-
time, we have not worked that out.
So if I understand your argument, you are concerned, and this would be Roman numeral 1, that a jury may misunderstand that the internal policies and procedures are the standard of care, correct?
That's correct.
But you don't disagree that they are a factor in determining what the standard of care is. You just don't want it to be the standard of care.
I would argue that, in essence, Judge, that's correct. But also, I would re-emphasize that if this is coming from an expert, and given her credentials, it would bolster and enhance the credibility and weight of that testimony, and so it increases the risk of this misleading the jury and then giving them undue weight and further reinforcing the improper conflation of issues.
Okay. All right, so then basically you're asking me to rule on your first two objections, or your two objections listed in the motion in lim as filed, and then if those objections are overruled, we will take up a limiting instruction at the end of the trial.
That's correct, Judge.
Okay, all right, just want to make sure we're all talking about the same things.
Yes, Your Honor, thank you.
Okay,
The other point which was drawn to my attention just now was I heard opposing counsel assert that they believed that there was a special relationship duty that arose. And perhaps that was a misstatement, I'm not sure. But there were 4 claims that were part of the original lawsuit in this, Judge. The court had dismissed the count arguing a special relationship theory. So to the extent that counsel is relying on any legal duty that would arise from the evidence here, that the jury can rely on to render a verdict in this case, I would argue that is improper. The court has already addressed that, has dismissed that alternative legal theory. This would be improper at this stage to raise it. And so, and it's well established, I would stand on my prior arguments that led to that motion to dismiss on summary judgment, that there is no special relationship that applies here, either de jure or de facto, and that is what the court ruled.
all right, I will probably take that issue up again after I hear from Ms. Douglas on
Thank you,
the
Judge.
other ones. All right.
I think Mr. Hogan addressed all of my.
Okay, but that was everything? Okay, all right, very good. So, I am going to overrule the motion in lim for the 2 arguments on internal policies and procedure objections and unfounded factual assumptions, and I'm going to allow her testimony and overrule those objections. However, I will grant a limiting instruction, and we will work on that language at the end, towards the end of the trials, and that will also be based on what she actually does testify to, I think. All right, so now I am going to ask that you address again the argument about eliciting testimony about a special relationship, because that issue is not going to be before the jury.
Yes, Judge. I think and we recognize that the court ruled on this issue at the summary judgment phase of this case, and I think what that recognizes, at least procedurally, is that a special relationship was alleged, and it was alleged sufficiently on the pleadings, and the court, in a mixed question of law and fact at the summary judgment phase, determined that there wasn't sufficient evidence to support a determination of a special relationship at that time. Now, in a circumstance of a trial, evidence is before the court, and that evidence may or may not differ from the evidence that Your Honor deemed sufficient or insufficient at the time that Your Honor ruled on the summary judgment issue. But because evidence is before the court at this point, and essentially at some stage there will be a request of certain duty instructions that go to the jury, I wanted to alert the court that that is an issue that we intend to ask the court to reconsider at that time, and it's specifically related to the evidentiary foundation, both that's been laid thus far and what we think will continue to be laid as it relates to the facts of this case, and as it's akin to the Bernadette case, and then akin to the Burns v. Gagnon case, although the Burns v. Gagnon case decided no special relationship. In the Bernadette case, it talked about an individual in a public official in a capacity, and the discussion in that case is the courts do not impose a special relationship on a public official to the people at large, and just generally speaking to every citizen that is around, and we recognize that. And Bernadette recognized that. And the difference in Bernadette was that there was a specific individual, or as the courts say, a class of individuals with whom there was an appreciated danger or risk. And in light of that, that public official then had a special relationship, not an assumed duty of care, but a special relationship with those individuals, that class of individuals, in order to take affirmative action. And the Burns v. Gagnon case, when observing that, said explicitly, we concluded that a special relationship existed, that is, talking about the Burdett case, between the deputy sheriff and a motorist because the sheriff knew or should have known that the motorist was in great danger of serious bodily injury or death. And so one of the issues that comes up as it relates, and it continues, and this is where the court contrasts, the Burns court contrasts it with the Burdett court, and says, in this case, by contract, there's no evidence in the record suggesting that Burns knew or should have known that Gagnon was in great danger of serious bodily injury or death. What we know at this point in the proceedings, specifically from the testimony of Ms. Farish yesterday morning, and then again throughout the afternoon in the testimony of Ms. Kovac, is that there was a certain appreciated danger of a firearm on campus that posed a danger, and that danger that we're talking about a firearm, we're not talking about a circumstance in which in Burns v. Gagnon there was a potential fight, right? Two different potential dangers in that circumstance. With the firearm, we're talking about a great danger of serious bodily injury or death. That is, frankly, Judge, that's why everyone's here today. And so, in light of that, and in light of the testimony that's come out as it relates to Dr. Parker's knowledge of it, we intend at some point in this trial to propose to the court, A, to reconsider that ruling, and then B, to issue an instruction on that. And that's one of the reasons we were hesitant and objected during opening statement of opposing counsel, which is we don't know what the duties are that are going to be advised.
So I was just looking online to see who paid for Dr. Parker's attorneys and attorney's fees and all that. And because I assumed the union or some kind of teacher board or something like that, school board, paid for her attorneys, which I was right. So Ebony Parker's attorneys in the civil case were paid for by the Virginia Risk Sharing Association, which is the insurance pool for the Newport News School Board. Her legal counsel was covered under the school division's insurance policy because she was employed by the school board at the time of the incident. The Virginia Risk Sharing Association is also expected to pay the $10 million judgment awarded to Abby Zwerner, the teacher who was shot by the 6-year-old student in the civil trial. However, there is a potential issue with the insurance coverage if Parker is convicted in her pending criminal case. So she's got a pending criminal case, folks, which is good. She needs it. And the charges are for 8 counts of felony child neglect. So I think this is very important. Now, it's odd that they did the civil case before the criminal case, because usually the criminal case will come before the civil case. Because if she's found not guilty on this criminal case, chances are the civil case will too. But at the same time, not necessarily, because the bar for a civil trial is much, much, much lower than a criminal case. A criminal case requires beyond a reasonable doubt. Okay, so you have to have zero doubt that that person they've convicted or told you that did this crime. You have to be convinced 100% they didn't do it. Okay, now with a civil trial, I think it's a preponderance of evidence or something like that. Let's see. Hold on. I'll check. What's the standard for civil trials? Yeah, the preponderance of the evidence, meaning the plaintiff must prove their case is more likely true than not. So it's a lower burden of proof than criminal cases, like I said, which require proof beyond a reasonable doubt. To meet the preponderance of evidence standard, the evidence must show a 51% chance that the plaintiff's claim is correct. Okay, and then in a criminal case, it's got to be 100%. So large difference there.
To the jury at the end of this case. And so we're not asking the court to reconsider it at this time. We recognize that the opinion testimony of Dr. Schuffelbarger isn't necessarily changed by the context of the court's ruling on that issue at this time, but we also didn't want to sit idly by and not alert the court of that intention in light of the fact that Your Honor found it relevant to the determination to make as it relates to Dr. Schuffelbarger.
So she's not going to use the phrase special relationship?
She is not.
Okay. So with that, I don't need to hear from you right now. I'm going to let you argue. And I'm not agreeing that I would permit that at all. That'll be saved for a later date. But I understand what you're doing and why, and I appreciate the heads up.
Yes, Your Honor.
So at this point in time, as long as she's not using the phrase special relationship, then I'm going to allow her testimony, and then we will take that whole issue that you just discussed up at the end after all the evidence has been in. And that's when I'll let you respond to all of that.
Your Honor, with your permission, could I address some specific arguments very briefly here? Because I think I now understand some portions of the argument that I think will assist the court when we need to address this in more depth at the appropriate time. May I do so, Judge?
All right, briefly. I want to get going here. And once again, your objections are completely preserved to this issue.
Yes, Your Honor.
I'm not holding, you're not being able to respond in full again
I
in
appreciate
any
that,
way.
Judge. I appreciate that, Judge. I just want to clarify for the court's benefit and for opposing counsel.
No.
I want to emphasize that what this will amount to if the court allows plaintiff's counsel to pursue a special relationship theory at this juncture, after having dismissed with prejudice the special relationship legal theory, would be permitting them to resuscitate and revive.
Right, and I'm not allowing them to do that. Your objections are preserved.
Yes,
Absolutely.
Your Honor. But also, I would argue that this would amount to an improper. It would allow them to amend their complaint in mid-trial, which would be a due process notice violation, and this would also implicate the prior arguments by the defense on our motion seeking a limitation of their theory of prosecution. This was precisely what we talked about in the pretrial conference, where there was a concern that plaintiff's counsel would try to backdoor, revive, dismiss claims. And I think that this is the path that they're heading on now. They are attempting to circumvent the trial court's ruling by saying, I understand, Your Honor, you dismissed this claim with prejudice, but let us pursue this alternative theory by another name. And it would be a de facto modification of the amendment of the complaint, which is completely impermissible, would deny Dr. Parker her due process rights. So I just want to put that on the court's radar, and we will address it in more depth at the appropriate time.
And your objection is contemporaneous, and I do note that for the record.
Thank you, Judge.
Okay. All right. Anything else we need to take up before we bring the doctor out?
There is, Your Honor.
Okay.
The actually, do you want to do that first?
Sure. We just have one exhibit to enter, Your Honor. It's Exhibit 119 from yesterday, defense exhibit.
And which one is that?
119,
That was a text message.
page
Your Honor.
131.
Oh, there it is. I do see it. I did admit that.
Okay, and just to get it in the record, I think we have the original copy for the record.
Okay, very good.
Also, just a note to the court that any video clips will be placed on a USB drive and given in total at the end of the case.
Correct. As and I guess are you going to save them as that item number?
Correct.
Perfect. All right. Fantastic.
So, on the topic of videos, a good segue. Last night we had sent opposing counsel clips that we intended to show during the testimony of now Detective Rulin, who was a first responder of the shooting, and those were body-worn camera footage. We've showed them to opposing counsel in order to try and streamline this once the evidence was starting to come in. They have, I think, a couple objections or a series of objections, so we thought it might be best to address those with the court before we impanel the jury and begin. The reason I say that is, for timing reasons, we'd like to call her before Dr. Scheffelbarger because she has somewhere to go.
Okay.
And so we'd like to address that now, if we could, Your Honor, and then bring the jury out.
All right. Do I need to see them?
I think you do.
Okay.
In light of the substance of them, Your Honor, we're going to ask our client to step out, and we'll probably ask her to stay out of the courtroom during the pendency of that witness's testimony, depending upon your court's ruling. But we wanted to alert Your Honor of that, so it wasn't as though she just wasn't here.
Okay. And are you agreeable in proceeding in that manner?
Yes, Your Honor.
Okay. Very well.
And if you don't mind, Your Honor, I'll walk her out to the room. She wanted me to show her to go. I'll be right back.
All right. So we are going to voir dire potential objections to videos.
Yes, Your
Okay.
Honor.
Very well. Right, and we are going to assume proper foundation has been laid, and then this is what they would play, and then I'll hear objections.
Correct, Your Honor. And for context, these have been stipulated as authentic as part of the stipulation.
Okay.
This is.
How many times was she shot? How many gunshots did you hear? One. Okay. Sorry, ma'am. We're gonna get up close and personal with you, okay? Please.
You're okay.
Stop actively bleeding right now.
Nothing will lower.
Okay. I'm gonna roll you over a little bit, okay? I wanna see if you're clean now. Okay. Go ahead and lift your arm a little bit. Okay. I have my mom. Are you okay anywhere else? Yep. 804.
I wish this court would show the videos. I hate when courts don't show the videos. What's the point of public access if we can't see the entire thing?
That's the first clip, Your Honor. There's 3 clips.
Okay.
So I don't know if Your Honor would like to take them one at a time.
So what number is this clip, or are we giving this clip?
110A.
Plaintiff's 110A. Did you want to go clip by clip, or you want me to watch all 3 and then you can respond? You have a preference?
I think it makes sense to do one by one, Judge,
All right.
because the argument's different.
Okay.
Judge, may it please the court. With respect to this particular video, I think there's a number of problems in why it should be rendered inadmissible. The first is that, first and foremost, under Rule 2403 of the Rules of Evidence, evidence is inadmissible even if it is relevant, if the probative value is substantially outweighed by the risk of unfair prejudice, misleading or confusing the fact finder, here the jury, or it is needlessly cumulative. This runs afoul of the needlessly cumulative prong, as well as the risk of unfair prejudice in misleading or confusing the jury. With respect to the cumulative nature of this video, Judge.
How is this misleading? This is literally what happened to the woman. How can that be misleading?
You will hear in the course of this trial, and we already have, fact witnesses testify that Ms. Zwerner suffered a gunshot injury. We've heard a medical expert come and take the stand and testify under oath in detail regarding the specifics of that injury. The jury has reviewed demonstratives depicting how she was injured, the seriousness of that injury. All this evidence has been established already. Numerous fact witnesses have also testified to the impact of that injury on Ms. Zwerner, as well as her family. And so we already have competent evidence before the jury on these points. This evidence would only be probative of establishing the nature of the damages, if any. And here, given the existence of competent evidence on that point already, any probative value is minimal at best. In contrast, the risk of prejudice to the accused is unfair and substantially outweighs that probative value. Because you can see, it's difficult to watch this video. It will have a strong impression on the jury. And of course, the jury is entitled to consider the evidence. They should understand and hear competent evidence that is probative of the material issues in dispute. And of course, damages are at issue. I acknowledge that. But this video is inflammatory. It is likely to incite sympathy. It is likely for the jury to render a verdict based on those improper grounds. The authority is well established. Those are improper grounds. And I also acknowledge that under Rule 2403, and the court's well familiar, the court may issue a limiting instruction to try to mitigate some of those risks. But I think that in this particular case, Judge, given that we already have competent evidence addressing these exact issues, this is so inflammatory that the jury would not be able to compartmentalize. You can't unring the bell once you see and watch this video. And given that circumstance, I think that it cannot be cured by a limiting instruction. The risk is too great, especially in this case. We will hear from other experts as well, I imagine, on medical damages and the nature of injuries. And so, again, this is cumulative. It fails Rule 2403 balancing, and it should be excluded. The final point, Judge, is to the extent that there are statements on that video attributed to Ms. Zwerner or anyone else, to the extent that is offered for its truth, I would object on hearsay grounds and ask that it be excluded and not considered by the jury.
All right, court overrules your objection. It's more probative than prejudicial. It's not cumulative, and it is not hearsay. Next.
110B, Your Honor.
Got him.
So we're gonna pick you up on camera and get you on the stretcher. Move your arm all right?
She has a bullet in her hand.
Okay. All right, well, you do just fine, okay?
Does she have something in her hand?
I have the shoulder here. 1, 2, 3, up.
Alright, I'm coming out. I'm getting the medic.
You allergic to anything? No?
All right. I'm not sure why we split that clip up, but
I understand, Judge. There's a third video that's slightly different, but I rest and stand on my prior arguments.
Yeah, and I would like that, I'm gonna overrule the objection, objection noted for the record, contemporaneous, and I would like those, that be one clip.
They're different in time. That's why we split them.
There's something cut in between, there's a cut in
Correct. And
between.
the thing that was cut in between was a conversation about the minor, which
Right.
is why I cut it.
So you can't show it as, well, I mean, you could just press the next clip,
I could just
correct?
press the next clip and we could admit them as exhibits, as a single exhibit number. I don't want to mislead the jury to think that those two
Right.
things happen in the same moment, though.
All right.
And if I may, Your Honor, it'll help with the witness to be able to go through one clip, play the next clip, and then
Okay.
the third clip.
All right, I'll allow that, contemporaneous objections. All right, and the court's ruling is the same as on Exhibit 110A. All right,
110C now, Your Honor.
wait, we just did 110B, I thought.
C.
C now, okay.
Easy, man.
You okay, Abby? Everything's gonna be okay. They're taking really good care of you.
What's that?
Yeah, tell her a story. Yeah, of course. Do you have any pets? Yeah, what kind of pets do you have? What's the cat's name? Yeah? How old is your cat? 3. I got a dog. His name's Addie. He's a turd right now, so you don't get seriously about
That paramedic's doing a wonderful job of keeping Abby talking, alert, and awake. That warmed my heart to hear her ask about animals, cats, dogs. How long did you have them? Oh, what's his name? That's a good EMT. That's a good paramedic. We need more people like that in our world.
that. You like runs and hides from us? No? I don't have a habit. Just relax. Are you married? No, we dating? Yeah. Does your boyfriend live with you? Your significant other is around? No? Kind of? Okay. I gotcha. Okay. Are you...
All right, I've seen the clip.
If I could just argue from council table.
You may.
With respect to this.
Speak up a little, please.
Yes, Judge. With respect to this particular clip, I stand on the prior objections based on 2403. But in addition, why I wanted to single this one out, Judge, is because this one has extensive inadmissible hearsay in it, more so than the other clips. It would be appropriate for Ms. Warner to take the stand and testify to some of the details she had here, but this cannot be backdoored. There's no applicable exception. They have the burden of establishing that. So I'd ask it be excluded.
You have a little more of an uphill battle on this one. You know, both the words and I guess the video itself. So I'll hear you.
Your Honor, the pertinent nature and the reason we selected this one in addition to the other two is first, it demonstrates a different period of time, all of which in terms of the timing needs to be considered by the jury in determining the adequacy of their verdict. Number two, and on to the issue of hearsay, there's a moment in the video in which Ms. Warner says, "Can you tell me a story?" And that is not a pertinent fact in this context of we need that for the truth. But what it demonstrates, even if it is offered for the truth, is what 8033 permits, which is it demonstrates her then existing state of mind, that she is trying to distract herself of the experience that she is enduring in that moment. And then all the statements and the conversations that flow from that, whether her cat's name is Jack or Jill, and whether the dog's name is true or untrue, is not the substance that's important. It's the fact that in that moment, the severity of the circumstance as depicted by the video and by the conversation, which is to try and distract her from her experiences as she's going through them, demonstrates what is an element to be considered by the jury, which is her mental anguish throughout this process, that it was taxing on her to the extent that she affirmatively requested, "Take me away from here and tell me a story."
At this point, it's more prejudicial than probative. Now, if she testifies and it can be used for another purpose, I might allow that. So at this time, through a witness other than Ms. Werner, I'm going to sustain the objection.
Yes, sir.
However, I give you leave to try to introduce it again after or during Ms. Werner's testimony.
Yes, sir.
All right. Exception noted. All right. Any other issues to take up?
No, Your Honor. With the court's permission and opposing counsel's permission, I'd like to go and inform the witness of the ruling so that
Yes.
she knows which two clips will be played.
All right. Any objection to that?
No, Your Honor.
Okay. All right. So we'll take hopefully a brief recess. Brief recess,
Brief
and then
recess.
you just let Deputy Hopkins know, and we'll come right out, have the jury set, and we'll start our day.
Yes, Your Honor.
All right. Perfect. Thank you all.
Please rise.
Your Honor, would you permit us to inform the jury that our client is present, just not present in the courtroom, or would you like to do that, or would you like us to be silent on that issue?
Do you have any objection to that? Okay. I'll just welcome them for the morning, and I'll let you start your, when I ask you to call your, well, actually, let me say a few words to them, then I'll let you do that, then you call your next witness. Okay.
Yes, sir. Thank you.
Thank you. Please stand for the jurors, always. Nine jurors in the box.
Thank you. Request a poll, Mr. All right. Good morning, ladies and gentlemen. I just want you to know we got here the same time you did, and we had some things that we needed to take up to make the day go smoother and quicker, and most importantly, not a lot of the up and down that I've told you about I really want to avoid for you folks. So I just want you to know that. Ms. Beniozen.
Yes, Your Honor. Our first witness will be Detective Rulin. She's in the courtroom, and with Your Honor's permission, I wish to.
You may.
Our client is here. Ms. Werner's here. She's just not in the courtroom for this portion of it, just given the nature of the testimony you're about to hear. Just want y'all to know that.
All right. And the court has permitted that. All right. Come on up.
Your Honor, we also, if there's any other witnesses who are present, that they be excluded besides.
All right. Are there any other subpoenaed witnesses in the courtroom? All right. Thank you.
Stand right here, face the clerk.
Do you swear that the testimony you're about to give will be true, the whole truth, and nothing but the truth? I do.
This way. Watch your step, stepping up.
May it please the court.
You may proceed.
Good morning.
Good morning.
Could you go ahead and state your full name for the court reporter, please?
My name is Detective Amber Rulin.
And Detective Rulin, what department do you work for?
I work for the Newport News Police Department.
How long have you been with Newport News?
I have been sworn since 2018.
And back in January of 2023, were you with Newport News Police Department then?
Yes.
And what was your role then?
I was assigned as a uniformed patrol officer.
And on January 6, 2023, did you respond to Richneck Elementary School?
I did.
If we can go to the IPVO. Oh, I do need to pull that. Forgetting my duties. This is just a little roadmap, Detective Rulin, and just to tell you what we're going to be talking about. I just want to talk to you about your observations at Richneck, and then my understanding is that you accompanied Mrs. Werner on her route to Riverside. Is that correct?
Yes, sir.
And so we'll be talking about that as well. Okay?
Okay.
To start us off, at the time, January 6, 2023, were you wearing a body-worn camera?
I was.
And was it activated when you responded to Richneck Elementary School?
It was.
And if I showed you footage from that, would you recognize it?
Yes.
Okay. If we could go ahead and show clip 110A. And Your Honor, I'd move the clip 110A, which was already subject to argument, into evidence at this time.
All right. Based on the court's pretrial rulings, your continuing objection, I am going to allow it.
Thank you, Your Honor.
Yes.
Permission to publish, Your Honor.
You may.
Is this your body-worn camera?
It is.
And do you recall this day now, having seen it?
Yes.
And I understand this may be difficult, and we're going to walk through the next part slowly, okay?
Okay.
All right, go ahead, read.
We're gonna take care of her, okay? Our minutes are on the way in. We need to look, see, did I sit? No. How many times was she shot? How many times did you hear? One. Sorry, ma'am, we're gonna get close and personal with you, okay? Please.
You're okay.
So I'm actively bleeding right now.
Nothing on the lower.
Okay. I'm gonna roll you over a little bit, okay?
This woman has no emotion. None.
Go ahead and lift your arm.
Doesn't bother her at all.
Okay. I have my mom. Are you in pain anywhere else? Yep. 8. What's your name? Abby Zwerner.
25.
Detective Rulin, that last statement from Ms. Werner was her age. And were you able to hear it when you were on scene?
Yes.
And you can hear it on the camera or the body camera that it's soft or faint. What do you recall about that, or what did that indicate to you?
Can you rephrase the question, please?
Yes. When she expressed her age at 25 years old and it was faint, did that tell you anything in terms of your observations and what you were doing to take care of Miss Zwerner about her potential injuries?
So I'm not a medical professional, so I'm unable to advise you if that meant anything for her medically. I did observe the injury to her chest, and there was the cloth covering the injury to her hand. I did not observe an exit wound, which is what I was checking for prior to the medics arriving.
And is that why you had rolled her over at one?
Yes.
Understood. Thank you. Soon hereafter, the medics did arrive, is that correct?
Yes.
And then when the medics arrived, you all took additional steps and actions at that time?
She was loaded onto the stretcher by the medics, and she was put into an ambulance where she was transported to Riverside Regional Medical Hospital.
Okay. I'm going to show you what's been marked as Exhibit 110B. And, Your Honor, I now move that into evidence. Preliminary.
Previous objections noted for the record and contemporaneous. All right, you may proceed.
110B.
Hey, can we pick up the camera and get you distracted?
She has a bullet in her hand.
Alright, well, you're doing just fine, okay?
Does she have something in her hand?
I have the shoulder, yeah. Once you pick up.
Ow. Alright, I'm coming out. I'm getting the knife.
You allergic to anything? No? I mean, ask what you want.
Detective Rulon, we just observed the loading that you just discussed. Can you walk us through what happens from this point in time once she's loaded on the, tell me the correct name for it.
It's either an ambulance or, as we call it, a medic. She was put into the medic by the medics and staff, and then I, as a law enforcement officer, got into the back of the medic and rode with her to Riverside Regional, where I remained with her until I was released.
And when you say released, really, you walked her into Riverside?
I walked with her in her stretcher to the trauma bay and to the subsequent room that she was put into. So wherever she went, I went.
And during the medic ride or the ambulance ride, did you observe her being provided treatment by the medics?
Yes.
And what, if anything, do you recall during those moments?
I don't recall exactly what they provided her medically.
I understand. Thank you very much for your time. Those are all the questions I have.
All right. Any cross-examination?
Any further defense, Judge? Thank you.
All right. May she be released?
She may be.
All right. Not subject to recall?
Not from us.
From defense?
Yes, Judge.
All right. You are excused, and you will not be called back. Please do not discuss, because this is an ongoing case, your testimony with anyone, but you are excused.
Thank you, Your
All
Honor.
right. Thank you. All right. Next witness.
Your Honor, our next witness is Deputy Thomas Blythe, and he's in the back. Okay. With the court's permission.
If you stand here, face the clerk, raise your right hand.
Do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. This way.
This way.
Watch your steps.
Good morning, sir.
Good morning.
Could you go ahead and state your full name for the court reporter?
Thomas Arthur Blythe.
And Mr. Blythe is a Corporal Blythe,
Retired, yes.
and retired from what department?
Newport, New Sheriff's Office.
And were you active in January of 2023?
I was.
And on January 6, 2023, did you respond to Richneck Elementary School?
I did.
And I'm going to ask you about your observations from Richneck Elementary School, and that'll be, if we can go read to the IPVO, it's just a little roadmap. That's all we're going to talk about, is your day at Richneck Elementary, okay?
Okay.
So can we start by, do you recall how you first heard of a call for a response? And I don't need to know what was said, just how you first heard of the call to respond to Richneck Elementary.
Came over the radio.
And where were you in time and space in relation to Richneck when you received that call?
I was about a 5 to 6 minute drive, maybe, with lights and siren going.
And when you arrived at Richneck Elementary, were you first, second, third in terms of first responders on scene? What were your observations?
I was technically first. Deputy Briggs was maybe 20, 30 seconds behind me.
And when you first arrived at Richneck, talk us through what you did in that moment.
We immediately went to the front door of the school, hit the buzzer, knocked on the doors, couldn't get in. Didn't see anybody moving around. Not what we expected to be responding to a situation like this. It seemed like an eternity for us was probably about a minute of banging on the door till I think a janitor or a security person opened the door for us.
And if we could go to Exhibit 9A, and don't publish that to the jury quite yet, just to the witness in the court. Publish it to the witness in the court, please read. Do you see, if we can pause it, do you see that image up on the screen?
Yes.
And is that an image of you as well as other uniform officers?
That's Deputy Briggs, first one through the door, and I'm right behind him.
Your Honor, I'd move Exhibit 9A into evidence.
Any objection?
No objection, Judge.
So admitted.
Permission to publish.
You may.
If we could start it from the beginning, Reed. So is that the moment that you were discussing? Janitor had let you all in?
Mm-hmm.
And that's you there at the left and two Newport News Police Department officers as well, is that
Yes.
correct? And when you walked into Richneck Elementary, were you being provided guidance from anybody on where to go? In other words, how did you know where to
We just
respond?
headed down the hallway. We naturally gravitated towards the office. I think there were some people in the doorway. We stopped briefly, looked into the office, saw there was a woman on the floor. Some people were attending to her. And then myself and at least the other two police officers, and I think Deputy Briggs was with us, headed down the hallway because we were trying to find out where the person with the gun was.
And have you now come to know that you were walking into room 11 or classroom 11?
Yes.
If we could show to the witness Exhibit 3, what we'll call 3A, which is Zwerner 6707. Just to counsel, please. Thank you, Reed. Do you recognize that photo in front of you?
That appears to be the classroom.
We move 3A into evidence, Your Honor.
Any objection?
No objection.
And it's just a photo, not a video, correct?
Just a photo.
All right, admitted.
Permission to publish.
You may.
Go ahead, Reed. And Corporal, can you walk us through what happened as you walked through this door, room 11?
As we stepped through the door,
Can I give you a little bit of, not legal advice, but a little bit of legal advice? Refrain from saying what you heard people say, but really just your observations, if that's okay.
stepped through the door, and there was a young child attempting to be restrained by a woman. Later found out was Amy Kovac, the reading teacher. We were quite taken aback. We didn't expect to see so young a suspect. She said that she had control of him, that the gun was in the back of the classroom and pointed that way. I immediately headed in that direction. When I found the weapon on the floor, I called out that there was a gun, and I stood by.
Can I pause you there, just to bring the jury along? If I can show you Exhibit 3C, which is Zwerner 6726. And just to the witness and counsel. Yes. Do you recognize this photo?
Yes.
And is this a photo of the classroom, room 11, on January 6th?
Yes.
And can you see a firearm within the photo?
It's laying on the floor next to that chair.
All right. Your Honor, I'd move Exhibit 3C into evidence.
C.
C.
All right. Any objection? Without objection.
Permission to publish?
You may.
And we can sort of see that in the bottom left there. Is that right?
Yes.
Corporal? And there's, if you can see in the photograph, if you can see in the photograph, there's a checkered backpack there on the right-hand side. Do you see that?
Yes.
Did you all later, at some point in time, come to know that to be the backpack of JT?
I did not. I was not involved with the backpack in any way.
Understood. And so there are, if we can jump to Exhibit 3E, just for the witness. And when you're, as that gets up, as a responding to a crime scene, usually there are other individuals that will come after you as a first responder to take these photographs. Is that correct?
Yes.
And ultimately, these photographs, as they appeared in the firearm, as it appeared, you were sort of guarding the location of it so that it would remain in that location until those individuals arrived.
Yes.
Excuse me. 6728.
I just moved to this view so you can see the entire picture when he shows evidence.
It's at the bottom of the screen. You can zoom out. Okay. You recognize that as a closer shot of the firearm?
It is.
And I'm also going to show you what's been marked as 6730, which is another photograph of the firearm. And that's a closer shot of the firearm, is that correct?
That's correct.
All right, so you're going to move both what we'll call 3E and 3F, which were those last two photographs shown in evidence.
All right, any objection?
No objection.
All right, without objection, permission to publish.
Permission to publish 3F, the most recent photograph.
And go back and show them E.
I will.
All right.
And that's sort of a ruler on the right-hand side or something to give us an idea of the size of the firearm. Is that
I believe
commonplace?
that's correct, yeah.
And then if we go back to 6728, which was the 3E, that gives us a broader vantage point of where it was within the classroom as well. Is that correct?
That's correct.
Those are all the questions I have for you, sir. Thank you.
Thank you. Any cross-examination?
Yes, Your Honor.
Yeah.
Good morning, Deputy Blythe.
Morning.
Counsel's asked you about your involvement in the investigation on the day of the shooting, correct?
Correct, yeah.
And you've mentioned that when you responded to Richneck Elementary School, you encountered some of the staff that worked there, right?
I encountered the janitor who opened the door. As we proceeded down the main hallway at the main T intersection there at the school, there was another janitor who said, "We have him."
Yes, sir.
And then we proceeded into the classroom, still trying to find the individual. And then we found Ms. Kovac attempting to restrain the child.
And let's talk about Ms. Kovac. During your response and handling of the situation, you ended up speaking to Ms. Kovac later during your investigation. Do you recall that?
Yeah, well, I wasn't actually doing an investigation. When I spoke to Ms. Kovac the second time, we had been sent to find a teacher and students that were supposedly hiding in a bathroom. In the process of that, I ran into Ms. Kovac, I believe, outside the nurse's office.
And I'm going to show you a display. Brian, could you pull up D57A1, marked for the defense for identification? And Deputy Blythe, I'm going to ask you to look at your screen. I'm going to see if you recognize. This is D57A1. This should not be published to the jury at the stage, just to counsel. And let me ask you, Deputy Blythe, during the time that you responded to Richneck Elementary School, you were equipped with police body-worn camera.
Yes.
And it depicted the events of that day and your interactions with the folks that you talked to, right?
Yes.
Deputy Blythe, do you recognize, you can see on that image, this is police body-worn camera from the day of the incident, right? This is January 6, 2023. Okay, and is this a fair and accurate representation of the Virgina Elementary School as you were going through the hallways?
Yes.
Your Honor, I'd ask permission to publish this to the jury.
I object, Your Honor.
All right.
First, it's outside the scope. Secondly, it's a body-worn camera, so there's going to be hearsay statements that are contained that A, haven't been shared, and B, ultimately are hearsay that are inadmissible in court.
All right.
Judge, I can address those in turn. First, with respect to beyond
Well,
this,
I've got to see it first. And I can't rule until I see him.
we can voir dire on this outside the jury's presence, Judge, or
I think we have to. All right, we did our best, folks, but at this point in time, we're going to have to, I'm going to have to see this video, make some evidentiary rulings. We can obviously clear the video.
JT.
What's up? All right. All right, proper foundation has been laid. No objection to that, correct?
No,
Okay. All right, thank you very much. All right, so I'll watch it and then I'll hear argument.
Yes, sir.
All right. All right, and what's up?
You want to call that up? Okay. Everybody all right?
Everybody's
Okay. Nobody's hurt.
no.
Okay.
They have him. Where JT? They have him.
Yeah, he's custody.
Okay.
Yeah. All right, I've got 3 ladies in here.
It's okay.
That door leads into this office.
Yes, it's a nurse. It was just him. As soon as he shot it, I was walking down the hall and I heard, I went right in. Abby was in, the teacher was Buddy. She came out. She came out, we moved the kids out. JT. Stood there and I took JT. I was the one who called 9.
All right, so obviously that's been edited, right? The video's been edited?
Yes, we took the original document, just 3 specific portions, but it's not been altered from its original form beyond segmenting it.
And what about the audio, though?
The audio, to comport with the court's pretrial ruling regarding confidentiality of minors' names, we had our tech professional just censor the minors' names. That's the
All right, I just
extent
wanted
of
to
the
make that clear what we were
Yes, Your Honor.
watching. All right, go ahead. You can stay there. Can you state your objections again now that you've seen that?
Yes, Your Honor. This is past the scope of, first of all, of Corporal Blythe's involvement in terms of what was elicited during direct examination. We talked about him arriving at the scene, locating and identifying the location of the firearm, and that's it. Now, when we get to this portion of the body camera, first of all, the question here is, what's relevant to the context of a body-worn camera in which 3 staff members are talking about? Candidly, I don't know what the relevance is of the substance of the testimony that is being elicited in the video, but to the extent there is any relevance to it, it's the statements themselves, presumably, that they believe are relevant. And those statements themselves are de facto hearsay statements by individuals who are not parties, and there is no exception to the hearsay rule that applies. To the extent they try to argue that it's an excited utterance or a present sense impression to that extent, the issue here is that excited utterance has to be within a certain time-limited period, and the courts have often said within a couple minutes or contemporaneous. And as Corporal Blythe has already testified, it took him about 5-6 minutes to get there. And then we're talking about his response time, and then we're talking about eventually him getting to this portion. And so A, I think it's irrelevant. B, it's beyond the scope of the direct examination. C, there are hearsay statements contained within, and if it's not for the hearsay statements, there's no pertinent issue that is being demonstrated in the context of this video without statements.
Please address those 3
Yes, Your
objections.
Honor. I'll address them in turn. First, with respect to relevance. Well, in reverse order. First, with respect to hearsay, I will gladly, after having Deputy Blythe identify this as his video, mute any volume. I don't need it for purposes of this clip, so that should negate any hearsay objection. And additionally, Judge, this video, this is not beyond the scope of direct examination. Counsel began his examination, Deputy Blythe, by saying unequivocally, I'm going to, quote, ask you about your observations at Richneck, quote, your day at Richneck Elementary School. That is very, very broad and expansive. Although they focused on just the initial portion of Deputy Blythe's arrival. Deputy Blythe has also testified that he spoke to Ms. Kovac, at least during the initial encounter, and later followed up and had additional interactions with her. This is all within the scope of Deputy Blythe's initial response. It's fair game. It is not beyond the scope of direct, and the court has wide latitude to allow exploration of legitimate issues the jury should hear about. Finally, with respect to relevance, Judge, this is highly probative. First and foremost, I anticipate, and I will intend to elicit from Deputy Blythe, that when he's encountering these individuals, this is going to be the main office. This will be Dr. Parker's office, where you could see on the video there is Dr. Parker present there. She's also there with Ms. Amy Kovac and Ms. Laura Harris. Those are 3 folks in the call, 3 folks who are in office, and it will show the layout of the office. I will ask Deputy Blythe about how, when he enters the front entrance of that office, it clearly shows that Dr. Parker, her computer faces away from the front entrance. And in order to speak and interact with Deputy Blythe, she has to adjust and stand and sit perpendicular to him. That's salient to the issues in this case, Judge, because we've heard testimony in the course of yesterday and the day before that when Mr. Sims was in the main office, and also when other individuals went into the office, the way they perceived Dr. Parker was affected by how she was postured, how she interacted with them, and it will influence whether or not the jury has to decide whether or not she was indifferent, whether she did not respond. And this will account for the fact that she was working, that she was focused on her work, is consistent with the defense theory that she was observing and diligently working, and that this is the layout of the office, this is the nature of it. Just because you come in and she doesn't turn and look at you does not reflect callousness and indifference.
All right, yeah, I understand. All right, so hearsay is taken care of by muting that, so that takes care of that. So, Mr. Benyazin, I'm going to agree with you that it is beyond the scope of your direct examination. They obviously have the right to recall him as their witness. I would the only reason, so I would sustain it on that. Do you have any, now that we know that he's not gonna play the hearsay, would you withdraw your objection so we don't have to call him back, or do you want him called back?
No, that's okay, Your Honor.
Okay. All right,
Standing on my objection, but I understand the efficiencies that we can accomplish.
Okay, I appreciate that, and I bet the deputy does too. All right, so legally, once again, I do find that it's beyond the scope, and I do find that it's relevant. So balancing those, however, the court appreciates the withdrawal of the beyond the scope objection at this time for the purposes you are offering, and you are only allowed to offer it for the reasons you've stated. Agreed?
Yes, Your Honor.
All right, very well.
And Judge, for efficiency's sake, with the same witness, I had several other clips from his body-worn camera that I want to address. They will primarily focus, I would proffer to the court, his interactions with Ms. Kovac and his discussion with her and prior inconsistent statements she makes to Deputy Blythe.
All right, that I'm assuming you're not going to agree to. Yeah, that.
Good assumption.
Yeah, that I think you'd have to do that in your case in chief.
I understand,
Yeah.
Judge, but I want to
Right.
alert the court. And so, very good. My understanding of the court's ruling is, with respect to these, this would require calling him in my case in chief. It's not off the table, though.
Correct.
Thank you, Judge.
Correct. All right. So, did you want to keep him on for the purpose that we've agreed on, or do you want to wait till?
That's fine. I'm happy to address this one individual clip.
Okay. All right. Very well. See if they're ready.
Response to Richneck Elementary.
You may proceed.
Thank you, Judge. Deputy Blythe, you've testified to your initial response to Virgina Elementary School on January 6, 2023. That's what we were discussing.
Yes.
And you testified that during your response, you were going in there to try to find certain individuals and get to handle the situation, correct? During your response, you were directed to seek out specific individuals, right?
After the shooter was in custody, yes, we had a call. There were people hiding in a bathroom that needed to be rescued.
Yes, sir.
Lack of a better term.
And during your response, you were equipped with body-worn camera, right?
Yes.
And the body-worn camera was depicting the events as they unfolded and the folks that you interacted with, correct?
Yes.
Deputy Blythe, if I show you a clip from your police body-worn camera, would you be able to recognize that?
Yes.
Brian, could you pull up clip D57A1 and display that for counsel? And given our prior discussion, Judge, I'd ask to publish it to the jury.
All right. Objections noted for the record, but publish permission granted.
And Brian, I would pause at this juncture. Judge, I just want to be clear, if I could address the jury and make note that this has been muted for certain evidentiary reasons, but I nevertheless want them to see and observe.
Objection, Your Honor.
Yeah, you can't explain it to them.
Sure.
But it is muted there, and I will allow you to ask them any questions, and then obviously in closing you can argue whatever you would like to argue.
Thank you, Judge.
All right.
Please continue. All right, if we could pause here, Brian. Deputy Blythe, what we just watched here, this was you entering the main office of Richneck Elementary School, correct?
At the time, I didn't realize it was the main office, but it appears to be.
It appears to be the office where you see here on the screen, that is Dr. Ebony Parker, correct?
I'd never seen her before today, but
I understand. But this
didn't
appears
recognize her as who she was, put it that way.
not at the time, but now that we're in court, this is obviously Dr. Ebony Parker, correct? Okay, and then also present in that room were two other individuals. You can see one of those was Ms. Kovac, who you had an interaction with during your response, correct?
Yes.
Now, I want you to just focus here. When we're looking at this image, this was the front entrance this was the main access point to get into this office, right? When you walked through, you had to go through that door in order to get there, correct?
I'm not sure if there's another door to the right or not. I'm not familiar with the office.
Understood. But as you entered the threshold of this doorway, you can see Dr. Parker is turned and faced kind of perpendicular to you, right?
Correct.
Okay. And so if she were facing forward, she would be faced away from you, obviously, right?
Yes.
In order to interact with you and talk with you, she had to turn, right?
Yes.
And you can also see that in front of her is a computer with a display on it, right?
Yes.
And her desk is facing away from the entrance that you used to access that office, correct?
Correct.
Thank you. I have no further questions of the witness, Judge.
All right.
I would move to introduce D57A1 at this time.
All right. Incorporate our prior discussion. Any other objections? All right. It is admitted then as defendant's 57A1. Are you going to have any redirect?
No, Your Honor.
Okay. Did you want him still under subpoena and available for recall?
Yes, Your Honor, and I'll be in coordination with you, Deputy Blythe.
All right, very well. Okay, so you are still a witness in this case, but so I'm not releasing you from the subpoena, but I am releasing you from court today. All right, so they have your number and can reach you in case you need to be called back at some later date. You understand?
Understood.
All right, and still as a witness, you're not allowed to discuss your testimony, okay?
Yes, sir.
All right, thank you very much.
Thank you very much.
All right, next witness.
Dr. Ann Shufflebarger is our next witness.
You get you stand right here, face the clerk, raise your right hand.
Do you swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Have a seat up here.
Thank you, Your Honor. Good morning.
Good morning.
You go ahead and state your full name, introduce yourself to the jury.
My name is Ann Shufflebarger.
And Ann Shufflebarger, are you a Dr. Ann Shufflebarger?
I am.
All right, and you are a doctor in what?
Education.
Thank you. Dr. Shufflebarger, I'm going to show you a little road map. It's just going to tell us what we're going to be talking about with you today. We can go to the Aikido. I want to talk to you first, if we can publish it, read, about your personal professional experience. Then we're going to talk about case retention, in other words, why are you here today to talk to us? And then I want to talk to you about your findings and observations in your professional experience.
Okay.
And so there's enough context. You have reviewed materials and come to findings and observations based upon your review of those materials.
Correct.
And that's specific to the events at Richneck Elementary, January 6th.
Correct.
We'll get to those kind of near the end.
Okay.
So first, tell us why you're here in terms of your background.
Okay. I have 38 years of experience working in public schools. I have been a first grade teacher, a reading specialist, worked in central office with both reading programs and overseeing school administration, and then I've been a building administrator, principal, and assistant principal, over all in Virginia Beach. And when I have retired, but since then I do part-time work, fill in when principals are out.
And so there's been a term used during the case about wearing different hats, you know, generally what that means?
Yes.
So you've kind of worn all the hats, or a lot of the hats that people are going to be talking about in this case. You were a first grade teacher like Miss Z.
Correct.
You were a reading specialist like Miss Kovac. Is that a yes?
That's a yes.
Just for him, sorry. You have been an assistant principal like Dr. Parker.
Correct.
And remind me, have you been a principal?
Yes, I was a principal.
All right, besides the earlier argued objections which are incorporated here, and any other objections at this time?
No, Your Honor, just a continuing objection based on the earlier arguments.
All right, very well.
They're on the record.
All right, thank you. I will qualify her as an expert in those areas.
Your Honor, yesterday there was another expert qualified, but I don't believe we've informed the jury what that means necessarily. Can we do that so that they can understand the context of why we might be asking their opinions as compared to others, or do you do that at the end?
Oh, we can do that at the end.
Yes, sir. Dr. Shufflebarger, when we hired you to come and offer your opinions and findings.
Correct.
And when I say we on behalf of Ms. Zwerner, is that correct?
Correct.
And we hired you, and you're being paid for your time in reviewing the materials and being here today. Is that
Correct.
right? I hope we're paying you fair.
Very fair.
Okay. So in your review of the materials, did you ultimately come to findings and observations that you particularly pointed out as it relates to the actions or inactions taken by Dr. Parker on January 6th?
I did.
I want to talk to you. We've heard evidence so far in this case that there was a moment in time in which there was an initial information or sharing of information about a gun or a weapon at Richneck Elementary. Are you following where I'm going?
Yes.
And that was revealed
Your
in the...
Honor, object to the leading.
If you ask open-ended questions, well,
Yes.
technically they are leading, so I'll sustain that.
Yes, Your Honor. What findings and observations did you come to as a review of your materials related to the first incidents of information conveyed to Dr. Parker?
My findings were that Dr. Parker did not take action that I think an assistant principal should have taken at that time.
And when you say should have taken at that time, tell us, in your opinion and in your experience, what actions we're talking about.
When an administrator receives a report of a suspected weapon, I was trained, and it's written out in most policies and procedures handbooks, that administrator is to take it as a credible threat until you assess the situation and find otherwise. And so when a teacher came and reported that student said that a student had a gun, and it was a student who an hour earlier there had been reports that he was having difficulty and was threatening students at lunch, action should have been taken at that time.
And do you have an opinion as to whether that action, lack of action, did it stop there? In other words, was that the last time that there was interaction with Dr. Parker about a weapon on campus?
From my reading of reports throughout the day, depositions and timelines and different things,
I don't know what's going on here, but they keep freezing up.
Moment, right? And
Their stream is awful this day.
What that is particularly. But that second moment, you say there's 4.
Mm-hmm.
What's your view as an administrator in that context, in Dr. Parker's situation, in terms of getting a second notice of a firearm on campus?
Hearing it the first time and not taking action, I don't know, what individuals were thinking at that time, but when it comes back up again, check the book bag, it's not there, but I'm getting reports that he has something in his pockets. That to me is a huge red flag. Take action. Get the kid secured, search, call law enforcement, alert the principal. There are many things that needed to be done, and none of those were done at that time.
And Dr. Schuffelbarger, I mean, we're talking about Dr. Parker's actions, but none of the other teachers called 911.
There's a chain of command in a school, and there are usually policies and procedures that guide that. Teachers are taught, report to an administrator. Administrators are the leaders and are trained to take care of that. And it's my understanding that teachers did report it. Several teachers did talk to her about that. And, there's even...
She did absolutely nothing.
Can I mention that? The staff handbook for Richneck Elementary?
We can hear the objection.
Your Honor, that's the exhibit that was provided late and outside of discovery.
And that is a continuing objection.
Yes, my understanding the court's not ruled on that.
I thought we were going to go ahead and allow her now that the foundation's been set, or did I misunderstand what you thought we were going to do?
I think maybe I misunderstand what we were going to do on that. I think that has not been discussed.
This is exhibit.
It is also beyond the scope of her designation. It was not, she submitted a report, and under the Crane rule, she's limited to the 4 corners of her report. She did not review that document, and it was not discussed in her report. I have a copy of her designation if the court would like to look at it.
I have that.
Your Honor, I think I can cure concerns and streamline some efficiency.
So you're going to withdraw the question?
I'm not going to withdraw the question because she hasn't really... I invited the objection preemptively because I saw Ms. Douglas out of the peripheral, and so I don't think that there's actually objectionable testimony that's been provided thus far. I would just ask...
She's actually asked you a question.
That's right, and so I'd like to just continue the questioning. In the event that we are going anywhere that counsel doesn't think we ought to go, we can of course take it up, but this is Exhibit 108, I think in particular, that we're talking about, that Your Honor permitted questioning as it relates to Mr. Sims yesterday, and so it has been taken up by the court, but ultimately I think we can roll through this and get through it.
So the answer to your question at this point is no.
Okay.
All right, go ahead.
All right, so Dr. Schuffelbarger, in review of the materials that you've been provided, are there different hats that people wear in the world of administrating school and education system?
Yes, definitely.
And in the hat of the assistant principal, the administrator responsible for crisis management plan, you following?
Correct.
Was that the hat that, in your review of the materials, that Dr. Parker was wearing?
Yes.
And in your review of the materials, when that person wearing that hat has received the second notice of information as it relates to a firearm on campus, What's your opinion as to how, if at all, she responded, or what her actions amounted to at that time?
From the things that I read, no action was taken. There was discussion about him putting it in his pockets and the size of the pockets, but no action was taken.
And from your perspective and in your expert opinion as a former administrator wearing that hat, what's your view and observation of what that amounts to? Is that?
That's failure to act in the course of safety for the school. That's endangers folks. When you hear something like that, I know I said it before, you're expected to take it credibly. Here's a second report that people think the student has a gun. Action needed to be taken to prevent possible safety issues.
And in your opinion, is that action should have been taken by Dr. Parker?
Yes.
And was that the last time, in your view, the materials that Dr. Parker was informed of a threat of a firearm on campus?
No, it was not. There was a third time involving a phone call between Mrs. West, who was a first grade teacher, and Mr. Sims, who was answering phones in the office. I know, depending on different things that I read.
We don't have to get into,
Okay.
because the jury's already heard them testify. We don't.
But there was a phone conversation, and Mrs. West asked, had the student been searched? Or had the book bag been searched? I'm sorry, had the book bag been searched?
And so in your review of the materials, there was sort of a third moment in time in which Dr. Parker was faced with a decision or a choice?
Yes.
And in your opinion, as an administrator and as an educator in this field, how do you characterize her response? Did that meet the standard? Did that breach the standard?
No, it breached the standard of care and of job responsibility.
And was that the last time, based upon your review of the materials?
No, there was a fourth time when two different teachers were at her office talking about a first grade student reporting that he had seen something and more concerns. And those staff members took it upon themselves to ask if they could check his person, check the student's person. And they were told, no, mom's coming in a little bit. No, we don't need to check at that time. And in my mind, that's quite a bit of inappropriateness, of a failure to act, because here comes more concern, more discussion, another report, and no action taken, and stopping others from taking action.
And so if we were to separate those moments in time, Dr. Scheffelbarger, in your opinion, and we were just talking about an initial report earlier in the day that you talked about, number one, is it your opinion that that and that alone and the failure to act under that circumstance breached the standard?
Yes.
And if we didn't even have that, and we're talking about the second moment in time, and if that was all that you had reviewed, is it your view that that and that alone would have been enough for her to fall below the standard?
Yes.
All right.
Guiding
It is
the test.
technically leading. I'll just ask you to rephrase.
Yes.
Now, were you on the second? I know you asked her about the first.
Yes.
This is the second incident that you're on at this point?
Yes.
All right. Thank you.
And as to the third and the fourth?
I feel like each time it's brought up again, another person is shared concerned, another student has shared that he's scared because of the conversation about it. When you look at that in totality, it's almost shocking, the lack of action there, how things were not followed up on. It really does breach the standard of care.
Dr. Scheffelbarger, are all the opinions and conclusions that you've provided held within a reasonable degree of your expertise and profession?
Yes.
Those are all the questions I have, Your Honor. Thank you.
All right. Thank you.
She's chewing on that one. Look at her. She didn't like that.
All right. Any
At all.
examination questions?
Yes, Your Honor.
Look at them lips
Hello, Dr.
puckered.
Scheffelbarger.
Hello.
Your tenure in the Virginia Beach public school system was entirely in education, correct?
Correct.
40 years?
35 full-time, 3 part-time.
So about 40 years?
Yes.
And you retired in 2022?
Correct.
In those almost 40 years, you never once had a elementary school student bring a loaded gun into the school, did you?
No, I did not.
And Dr.
Probably a good
Scheffelbarger,
thing.
You agree that an assistant
And if she
principal at
did,
the school is not
she
solely
would have acted on
responsible
it.
for school safety, correct?
No.
It's a team approach.
We know that for a fact.
Correct.
And it also involves the teachers in the classroom, correct?
Correct. The assistant principal is the leader of that team.
And the principal's involved as well, correct?
Correct.
And the teacher in the classroom is actually the first line responder. You've heard that term before?
Yes.
Now,
And
you've
they
seen the
did.
materials
They
that you
reported
read,
it 4
related to
times.
The case that Dr. Parker was involved with standardized testing that day,
Correct.
and there are strict rules that govern standardized testing, correct?
Yes.
And the assistant principal is the school testing coordinator,
Generally so, yes.
and the assistant principal is responsible for setting up the secure environment for the testing.
Correct.
And these tests are given online,
Yes.
and it involves the assistant principal being at her computer
To get things started, yes.
and throughout the testing
Checking in
process.
on it throughout the day. It doesn't require being at the computer all day.
But it requires being at the computer a fair amount
Certain times, yes.
because of the security of the testing tickets, correct?
Right, but an administrator can leave the office as long as they are locked up and secured so that other people cannot get to the testing tickets.
Understood. And this was going on concurrently on January 6th, correct?
Correct.
And there were other discipline issues going on
Yes.
January 6th. You read about those?
Yes, I have.
And Dr. Parker had to interject and get herself involved in those situations. You read that?
Correct, yes.
And that's in addition to wearing all the other hats that an assistant principal wears.
Yes.
And I think you agree with me that an assistant principal wears a lot of hats
I do agree with
in
you
a
on that.
management of an elementary school. You agree with that? Now, you told the jury about what Dr. Parker didn't do. You would agree that an assistant principal must use his or her judgment or discretion in determining whether reports about a student are credible.
But part of that involves assuming credibility and checking to see if it is indeed. You're to assume credibility until you check and assess to find otherwise.
Until you verify it's not a
Evidence
threat.
tells you otherwise.
Correct.
Okay, but that does involve the use of judgment and discretion. You would agree
Yes,
with
I
that?
would agree with that.
Okay. And the assistant principal can't be everywhere all the time, correct?
Correct.
And the assistant principal has to rely on other staff members and other teachers in determining whether reports are credible, correct?
To some degree, yes.
And you would agree that the first report that Dr. Parker received regarding JT was from Ms. Kovac.
Yes.
And Ms. Kovac investigated those reports before she went to see Dr. Parker, didn't she?
Correct.
Ms. Kovac is a seasoned educator, isn't she?
Yes.
Over 30 years.
Yes.
And she worked with JT daily.
Yes.
She knew him well.
Yes.
And Ms. Kovac stayed in the room with Ms. Zwerner and her class for a while to investigate the reports about whether JT might have a weapon.
Yes.
And Ms. Zwerner was also in the room while this was going on. You read that?
Yes.
They were the first line responders to the reports about JT having a weapon, correct?
Correct. First line responders as teachers are to report it to administration.
Right, but that's a different question. I'm
Okay.
asking you if Ms. Kovac and Ms. Zwerner, who were were in the room when this happened, were the first line responders to the information reported by the two students.
Karen, I'm just going to object to preserve our motion in limine regarding argument as it relates to duties owed by individuals who are not the defendant in this action. I think we're venturing into an area of asking what is an obligation there, which Your Honor's ruled is not an issue for the court and has not been pled.
Your objection's noted, and it's, made contemporaneous, but I don't think we were into the grounds that I have ruled yet that are inappropriate. All right, go ahead.
See, so you would agree, you read in the materials that Ms. Zwerner and Ms. Kovac were in the room with a student.
Correct.
Ms. Kovac did not confiscate JT's backpack.
She did not at the time that he was in the room.
Ms. Kovac did not.
Oh, I'm sorry, can you repeat that question?
Ms. Kovac, the reading specialist, just like you, she did not confiscate JT's backpack after her investigation, correct?
Correct.
She did not remove JT from the room.
She did not.
And Ms. Zwerner did not confiscate JT's backpack, did she?
No.
And Ms. Zwerner did not remove JT from the room.
No.
And she had removed him from the room a couple days before when he had thrown her cell phone, correct?
I don't know about that. I have not reviewed that recently.
You haven't reviewed it recently?
I can't speak to that right now.
Can't speak to it right now. At that time, Ms. Kovac went to talk to Dr. Parker, correct?
Correct.
And at that time, Dr. Parker would have learned that JT had been permitted to go on the playground with the other students.
My understanding is that when she went down to the office, they were getting ready to go to recess. And she said that she would go back and check the backpack when they went out.
Right.
So I don't know the exact, was she there when he went out, or did she leave the room before? I don't know the answer to that.
My question is different.
Okay, thank you.
Based on what you read, when Ms. Kovac went back to Dr. Parker's office to report on her investigation, you read
Oh,
that
after
she
the
would have known that that Ms. Kovac had investigated, chose not to remove him from the classroom, correct?
Yes.
Chose not to confiscate the backpack,
Yes.
and that he was off to the playground with the other first grade students.
Yes.
And would you agree that that is information that tends to disprove that there's a credible threat?
No. I would not agree.
Would not agree with that. Now, Ms. Kovac goes to speak with Dr. Parker and at some point searches the backpack.
Yes.
And that was based on a discussion between Dr. Parker and Ms. Kovac, that the backpack would be searched.
Yes.
And then there were some other conversations that you talked about that day with to Dr. Parker, correct?
Correct.
But you were not there for those conversations. You have no way of knowing what information anyone specifically conveyed to Dr. Parker.
That's correct.
But what we do know is some of their actions that day. You do know that, correct?
Okay.
And then you told the jury that there were 2 staff members, that was the last opportunity for Dr. Parker, the 2 staff members, and they were teachers, I believe is what you said?
Yes.
Do you recall that being Mr. Rawls, the guidance counselor?
Yes.
And he wasn't a teacher, was he?
Okay, that's an instructional position, but it is different from a teacher.
He was a
Correct.
guidance counselor.
He was a guidance counselor.
He was on the threat assessment team,
Okay,
right? And you read Mr. Rawls' deposition?
I did.
And you read that he had not determined it to be a credible threat when he spoke to Dr. Parker about searching JT, correct?
That's what I read, yes.
Okay. And he spoke with Dr. Parker about searching little 6-year-old JT, and he not sure about what was said that day, but Dr. Parker didn't refuse that JT be searched. She just wanted to wait till his mother got there to go through the rest of his things. That's what you read, correct?
Yes, ma'am.
Now let's talk about student searches.
Okay.
You would agree that the decision whether to search a student is a judgment call for an administrator to make based on the
She's just so cocky. Look at her. I mean, what a way to act in front of the jury.
whether to body search
I mean,
a 6-year-old,
crazy.
right?
Talk about condescending, man.
Sex of a student is a factor, correct?
Correct.
And you want to handle the student with as much dignity as possible so that you don't upset them, correct?
Absolutely.
You must also consider legal issues involving right to privacy.
Correct.
And during your tenure in the Virginia Beach public school system, it was preferred that a parent be present for a body search of a student.
Yes.
And here, Dr. Parker did not deny Mr. Rawls searching the student, but wanted to wait for the mother to get there because she was coming soon, correct?
That is what I read that she said.
You were answered a few questions about Newport News procedures and documents, but you were in Virginia Beach, correct?
Correct.
You don't know anything about training in Newport News on any documents that they have.
The only things I read, there was a multi-crisis handbook that I read about Newport News procedures and the Richneck handbook, and I don't know if I can discuss either of those.
But you don't know how training is done
No.
in Newport News,
No,
and you don't
you're
know how
correct.
Dr. Parker was trained
You're
about
correct.
those documents. Dr. Shuffleberger, you came to be an expert in this case with Mr. Bright, sister-in-law, correct?
Correct.
You'd never been an expert before. You've never sat on the witness stand as an expert witness, have you?
No, ma'am.
And you're charging $500 an hour to sit here today, correct?
Correct.
And at the time you reviewed this case, you knew about the outcome at Richneck Elementary School on January 6th, didn't you?
I did.
You knew the outcome. And you yourself agree that it's unfair to judge someone's conduct with 20/20 hindsight vision, correct? You agree with that?
I can see that, yes.
And you agree that Dr. Parker, in evaluating information regarding a 6-year-old having a loaded gun at school, something that never happened to you, she did not know the outcome that day, correct?
Correct.
I have no further questions.
Redirect?
Yes, Your Honor. Dr. Shufflebarger, there was a question about standardized testing at the beginning of the cross-examination. Do you recall that?
Yes.
And I think the question was, you have the obligation of the assistant principal is to secure an environment for testing. Is that right?
Correct. Yes.
Can you imagine a circumstance that jeopardizes a secure and safe environment for testing more than having a firearm on campus?
No.
And you were also asked about other
Bingo!
disciplinary events that were taking place at the school.
Yes.
And so it's your observation, I think, that Dr. Parker was attending to some things on campus
Yes.
and not the firearm.
Correct.
Is there anything in an administrator's life that is more important than understanding and determining the validity of a threat of a firearm on campus?
I can't think of anything that would be. Being a building administrator is a hard job. You talked about wearing lots of hats, and absolutely administrators wear lots of hats and have to handle things that happen quickly. You may have a plan, I'm going to do this today, and you never get to it because it's almost like a triage situation. You have to determine what's more important, what is more urgent at this time. And a report of a firearm stops everything. You stop, you investigate, determine if it's credible, and then you can move on with your day if it's found not to be.
And you were asked about investigating. I think you were asked about Ms. Kovac's investigation. Do you recall that question?
Yes.
Whose job was it to actually do the investigation?
An administrator.
Dr. Parker.
Dr. Parker was the one it was reported to.
Whose job was it to actually confiscate the backpack?
Dr. Parker's.
Whose job was it to secure the child?
Dr. Parker's.
This is beyond the scope of her designation. None of this is designated for her testimony.
I'm going to overrule that.
Whose job was it to contact law enforcement?
Dr. Parker.
Whose job was it to search the person?
Dr. Parker.
And there was a question about the dignity of a child, a 6-year-old child.
Old Doc.
Correct.
Old Doc.
Recognizing
It was
the
her
dignity of a
job, and
child.
she didn't do it.
Is the dignity of a child more important than the safety of the individuals on campus when there's a report of a firearm?
I think you can manage both. You can handle all the things need to be handled with a student who potentially has a weapon in a dignified way and protect the privacy and the dignity of the child in a way that other children don't see it. But you can't ignore it, and we should not ignore it.
You got to get to the bottom of it.
Yes.
And
find
Dr.
out.
Parker never got to the bottom of it.
No.
Thank you.
Briefly on
Please
that.
follow up. You just testified that a report of a firearm stops everything, correct?
Yes.
Stops everything for everyone in an elementary school.
For the administrator who receives the report, they need to kind of stop what they're doing and handle that report right away.
So you're telling this jury that
She
the
just shook
report
her
of a
head no.
firearm in a school stops everything for the administrator, but the teacher, the first line responders can go about their business. That's what you come in and telling this jury.
And argumentative.
Overruled.
That's
I'm saying it's the assistant principal's job to stop and take care of it. Their job is to report, and the assistant principal's job is to act.
you would agree that other individuals involved did not stop everything that day, correct?
No.
Ms. Kovac didn't stop everything, Ms. Zwerner didn't stop everything, Ms. West didn't stop everything, and Mr. Rawls didn't stop everything, did they?
No.
No further questions.
All right. Is she going to be needed to testify again?
Not from us, Your Honor.
All right.
From the defense, they will.
So may she be excused?
She may be.
All right. You are excused. Thank you for your testimony today. Because this is an ongoing case, please do not discuss your testimony with anyone.
Absolutely.
All right. Thank you. All right. You may be excused. All right. Is now a good time to take a break?
Yes, Your Honor.
All right. Let's take our morning break, about 10 minutes if we can. I would appreciate that. You may proceed.
Thank you. And can you please state your name for the jury?
Daniel Munn.
And tell the jury, how are you currently employed?
I'm the Chief of Surgery at Riverside Regional Medical Center.
And how long have you been in that position?
About 10 years as the Chief of Surgery.
And were you there in that capacity on January 6, 2023?
I was.
Okay. And before we get to that date, can you briefly tell the jury about your medical background, your educational background, I should say, so the jury can understand a little more about you?
Sure. I'm a general surgeon by training and specialize in trauma surgery and surgical critical care. I'm the Chief of Trauma at Riverside and have been there for 14 years total. I was in the military before that. That's where I trained to be a trauma surgeon in the Navy.
And where did you go to school?
To Wake Forest.
And after Wake Forest, were you there for all of your education?
Yes, for undergrad, graduate school, and medical school.
And since that date, have you worked in the medical field?
Yes.
And do you have a specialty?
Yes, trauma surgery.
And can you explain to the jury what exactly that means?
So of the general surgery subspecialties, general surgery includes basically abdominal surgery, breast surgery, skin cancer, things like that. And trauma surgery focuses on pretty much the rest of the life-threatening injuries of the body, but we take care of all injured patients. So it might be car accidents, gunshot wounds, stabbings, things like that. Even falls from standing, falls downstairs, things like that.
And Your Honor, at this time I would like to tender Dr. Munn as an expert in the field of trauma surgery, general surgery, and surgical critical care.
Any objections?
No objection, Your Honor.
All right. So qualified.
Thank you. Now I would like to turn your attention to January 6, 2023, and the couple days thereafter. Do you work with a team of doctors?
Yes, we have 6 trauma surgeons and 3, nurse practitioners basically that work with our team. And so I think Dr. Chapp has already testified, but he was the primary surgeon on for trauma at that time. And then the rest of our team were taking care of her the rest of the time that she was in the hospital.
And when you're saying taking care, I should make it clear in the record, you're referring to Abigail Zwerner, correct?
Yes, exactly.
Okay. And you see her in the courtroom today?
I do.
And can you tell the jury, when did you care for her that week that she was in the hospital?
I would have to look at the record to see exactly when we crossed paths, but basically we all work as a team and cover all of the patients in our, on our service. So.
And so what was your role that week when you saw her?
Just supportive care, managing all of her medical issues, managing her critical care. She had a chest tube that we had to take care of, and that is a big part of the focus for our team. But all of her injuries are under our, we were the attending surgeons for her and the primary physicians for her, so we took care of all of her medical needs while she was in the hospital.
And just to help you as you're walking the jury through what you did in her injuries, I'd like to share, and if I can publish it with the jury, Your Honor, I have shared it with opposing counsel. I don't believe there's an objection. It's going to be a demonstrative exhibit. We'll be referring to it as MV13.
Any objection as a demonstrative exhibit?
No, Your Honor.
Okay. So just let me explain to you, ladies and gentlemen, demonstrative exhibit is something that you'll be able to see that assists you in understanding the testimony of a witness, but will not be going back with you to the jury room. All right, so if that helps you taking notes or not. Thank you. You may proceed.
Thank you, Your Honor. And with your permission, it can be published?
You may.
Thank you. And Dr. Munn, do you have that on your screen in front of you?
I do, yes.
And can you walk the jury through what this illustration means to you in regards to Ms. Zwerner?
Absolutely. So if you look at the left side of the drawing, it's basically sort of a mock-up of a person standing up, or maybe laying down, but basically the whole torso. And the two cutouts on the right are images that kind of reflect what we would see with a CAT scan. And so the top one is actually her CAT scan, and then the other one on the bottom is sort of a cutout of what it would look like to slice her like a loaf of bread. So in a CAT scan, her head is into the screen above us, and then she's laying on her back, and then her legs would be sticking out of the screen towards you. And so that, as the CT scanner presents images slicing through the body like a loaf of bread all the way from the head down to the feet. And so they're basically referencing back and forth between the left side of the total of her torso and the cutouts on the right are basically showing you where the bullet went in to the left chest. It went through her ribs, which are to the left of that. So if you look at just the upright one on the left, it's probably easier just to follow that course of the bullet. Yeah, sorry. Yes, that would be fine.
Ms. Douglas, any objections to having him come down? All right.
So if you would stand
Yeah,
here.
and just make sure you speak up. All right, thanks.
Okay. It might be easier if I just stand at the screen. If that's okay.
Yes. Thank you, doctor.
So again, this is the trajectory of the bullet going into the chest, going through one of the ribs, and then through the lung tissue, and then ending up behind the heart, just along the course of where the major blood vessel of the whole body is. And so again, when we're looking at this same image with her sliced like a loaf of bread, it kind of goes in through the side of the chest up here, and then ends up behind the heart, which is this area right there. So the big black areas on both sides are the lung tissue, and then all of this is blood that's collected in the chest from where the injury is. Again, the bullet is this super shiny thing with the arrow pointing to it. It is backed by her spine and very close to the aorta, which is the biggest artery in the body. So look at this image. The aorta comes off the top of the heart, it goes down to the lower part of the body, provides all the blood supply to the rest of the body. And so this bullet is positioned. If you look at this flow up here, it's about 2 centimeters from the aorta and above it her coronary spine. So, if you want me to show that 2 centimeters.
Yes, if you want, now Dr. Munn, are you done with those? Do you want to, I can.
That is pretty much it. This image here gives you a better view of what the CAT scan shows because it shows the tissue more realistically. And so this is her lung that has collapsed and shrunken down because it has a hole in it. And that hole has bled into her chest and allowed for air and blood to leak out into the space around the lung.
Thank you. Then if you'll have a seat back, we'll continue questions. So can you tell the jury the significance of the blown up image where it shows the bullet 2 centimeters from the aorta?
So there are several things about the way this bullet went in that are life-threatening. Certainly the injury to the lung, where I described that it has collapsed. Any human being can bleed to death from that level of injury to the lung. But again, where this bullet ended up, it went past the heart and just barely missed it. And then also ended up within 2 centimeters of the biggest artery in the entire body, which patients would bleed to death in seconds from an injury to that vessel.
And Your Honor, if I may, I do have a ruler just to show the jury what 2 centimeters looks like. If I could approach just so they can understand the measurement, Your Honor, I'd ask for leeway.
Any objections?
Object to the relevance if this is cumulative at this point anyway.
All right, I'll overrule it. She can show the jury what 2 centimeters looks like.
Thank you, Your
on the
Honor, I
ruler.
appreciate that. The jurors, you can see them here. Is it over to you right here?
The ruler's not going back with y'all.
Bring that back to my. And Dr. Munn, you had talked about the lung collapsing. Can you tell the jury a little bit about that injury as well?
So this is something that we commonly treat that is a life-threatening injury, but the treatment doesn't seem that significant because basically the treatment is to put a tube in and re-expand the lung by sucking out the blood and the air that's around the lung. And so we often do not have to do surgery to get into the chest and fix this problem because the body heals very well when we re-expand the lung. But it is still a very significant injury and something that is can oftentimes cause a patient to pass away at the scene where they're injured.
And the lung, when it collapsed, is that actually scarred to her chest? Can you explain that to the jury?
So the way that we get it to heal is by putting that tube in, it creates a scar that causes the lung to re-expand and stay expanded. And so over that healing process, if we took the tube out too early, the lung would collapse again and she would have difficulty breathing and we'd have to put another tube in or potentially do surgery.
And so what does that mean for future surgeries?
So now, as a result of the injury and the treatment for that injury, her lung is scarred to the chest wall. And so that means that anytime, if she had any other injury to that side of her chest, or if she needed surgery to that side of her chest for any reason in her lifetime, we would be going through scar tissue to get to whatever that is. So it limits our ability to treat her for other problems that might affect that side of her chest.
And Dr. Munn, where is that bullet that went into her body? Is it still there?
Yes, it's still in her.
And why was the bullet not removed?
So for something like this, it is actually way more dangerous to remove the bullet than it is to leave it in place because all of those structures that I described that it's so close to are very difficult to get to. And so we leave it in place, assuming that it hasn't caused any additional harm at this point, now that she's stabilized from it, and hope that it won't cause any further harm going forward.
And are there a lot of other people in situations like that where you can understand what that looks like for her going forward? Or is this a unique injury that you've seen?
Your Honor, objectives beyond the scope of his records. There's nothing in his designation about this type of testimony.
You have a response?
Your Honor, I will certainly keep it focused on her injury, and he is designated to talk about the injury of the chest and the bullet inside the chest and what that means for her. But I can narrow that question a little bit more, Your Honor, if you'd like.
All right, sustained with leave to re-ask.
Thank you. So, Dr. Munn, where the bullet is in Ms. Zwerner, what does that look like for future injuries that she could have or future needs for diagnostic exams?
So there's no way to provide evidence of what could happen over a lifetime, really, because we can't study all of the patients who have projectiles in them. But we know that they typically don't cause harm when they're in a location that is not near something that's moving. But there are certainly events that could cause this bullet to move if she was under a significant impact of some sort. And the thing that we worry about the most really is something like needing diagnostics testing for MRI or something like that, where she has metal in her and an MRI requires using a huge magnet that can cause the metal to move or heat up. And so it would basically prevent her from being able to have an MRI for the rest of her life.
So in the future, if there was a need for a diagnostic testing of some sort, if there was a concern of anything involving breast cancer or things of that nature, is she going to be able to have an MRI?
Your Honor, this is getting far afield of his. It's also cumulative. He's already tested that.
I'm going to overrule it just for this question, but this will be the last question.
Yes, Your Honor.
On that line.
Understood.
It does apply to my specialty as a general surgeon as well. And yes, that for someone her age, a female patient her age, it would be concerning that she might have to have an MRI at some point. The most common reason would be breast cancer, because it's very common in women, but also anything else that might require additional imaging. And also, just if we were concerned about the fragment moving, one of the studies that would help us with that would be an MRI, which we wouldn't use for her.
Okay, thank you. And you saw her on January, when she was initially in the hospital, and then you've seen her January 30th of 2023, correct?
Yes.
And then you saw her again February 6th of 2023, correct?
Yes.
Okay, can you tell the jury, is there any future needs for her to see you? What would that look like in the future if she needed to meet with you? For what reason?
Sure. So the initial follow-up was mostly to examine her for her recovery and make sure she wasn't having any ongoing complications, the most common of which would be pain from her rib fracture, which she did have when I saw her in follow-up. And then again, if there's anything that changes over the course of any period of time, really throughout her life, if she has complications or concerns about her breathing, then she would come to see us for that.
And Dr. Munn, were all of your opinions testified today to a reasonable degree of medical probability?
Yes.
Okay, thank you. And do all of the injuries that you discussed today related to the gunshot on January 6, 2023, the wound to Ms. Zwerner?
Yes.
And are the injuries that she has today, sitting in this courtroom, permanent in nature?
Yes.
Thank you, Doctor. You'll answer any opposing counsel's questions.
Cross-examination.
Just a few questions. Dr. Munn, if the records reflect that you have not seen Ms. Zwerner in over a year, is that consistent with your recollection?
Yes, that's correct.
Okay, thank you. No questions.
All right, may he be excused to go take care of the citizens of Newport News.
Yes, you may, Your Honor.
All right, thank you for everything you do. All right, is there a witness we can do in about half an hour, or are you ready to do anything else at this point?
No, Your Honor, I think the next one's going to be longer than half hour.
Okay. All right, do you agree with our lunch break at this point, Ms. Douglas?
That's fine, Your Honor.
Okay. All right, ladies and gentlemen, we will take our lunch break for the day. We will try to resume testimony at 1 o'clock. All right, thank you. Anything to take up after they leave? No? Okay. All right, nothing else being taken up at this time. The court will stand in recess till 1 o'clock. Thank you. You may be seated. All right, any matters to take up before we call the next witness?
Yes, Your
All right.
Your Honor, we're running a little ahead of schedule, so we intend to call Hannah Zwerner at the end of the day, who is an anticipated witness for tomorrow. We notified defense counsel at lunch. If they object, do not want her to be heard today, wish to have her heard tomorrow. It's their objection, I'll let them be heard.
All right.
Your Honor, just in terms of that, we didn't expect her today, so we weren't prepared for her today. But the other issue is, she's the one that created the GoFundMe for Ms. Werner, as opposed, in addition to a T-shirt sale fundraiser. And I would like to be able to ask her about that. My understanding from the motion in limine hearing is that the court ruled that we could not ask about amounts, but that we could ask about the creation of fundraisers. So I would like to be able to ask her about that. I think it goes to her bias.
All right, and I ruled on that already, right? Yeah.
You did, but I did not want to run afoul of the court's ruling and cause a motion for a mistrial. I wanted to make sure, because we discussed the GoFundMe in the context of just the general evidence at trial, and then we also discussed it in the context of the questionnaire, and the court was very careful to word that, so I wanted to make sure.
Yeah, as long as you're in line with what we've talked about.
They just
in
don't
order.
mention the amounts.
Yeah,
that were
exactly.
created. But I can ask her, did you create a GoFundMe?
Yeah, absolutely.
Okay, thank you, Your Honor.
Okay. All right, and I'll permit you to run your case as you see fit, and if we have time today before my normal closing time, then we'll put her on.
Yes, Your Honor.
Okay. All right, call your next witness.
We have Dr. Anderson, who is standing in the hallway.
All right, very good.
Oh, yeah. Who need, I mean.
Please stand for the juror. And jurors at the bottom.
All right, thank you, Deputy. Okay, ladies and gentlemen, we are about to begin our afternoon session. All right, please call your next witness.
Next witness is Dr. Romney Anderson. Witness has not been sworn in, Your Honor.
I'd like you to stand right here, face the clerk, raise your right hand.
Do you swear that the testimony that you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
This way.
Have a seat next to me.
Watch your step up.
Yeah, please, court.
You may begin.
Doctor, could you tell the ladies and gentlemen of the jury your full name, please?
Sir, it's Romney Christian Anderson.
And you are a medical doctor?
Yes, sir.
What is your specialty?
Orthopedic trauma.
I want to go through briefly, if I can, your resume, curriculum vitae, so the jury will understand your expertise, if I could. When did you graduate from med school and from where?
1996 from the Uniformed Services, University of the Health Sciences.
I did want to ask one question. You have a Bachelor of Science degree in what?
Nuclear physics.
And then you decided to go to med school after that?
I spent 7 years in the infantry, and then I went to medical school.
All right. Now, I want to talk to you about the different jobs you held as an orthopedic surgeon. I take it you became board certified in orthopedic surgery at some point in time?
Yes, sir.
And where have you worked in the field of orthopedic surgery?
So once I finished residency, I went to fellowship at the Shock Trauma Center in Baltimore for a year's fellowship in orthopedic trauma. Then I came back to Walter Reed during the war and helped out with the trauma there. During that time, I worked 1 weekend a month up at Shock Trauma, helping them out as well. And then I worked at a number of little various hospitals doing hip fractures and things on the weekends to help them. When I retired from the military about 11 years ago, or 10 and a half years ago, I came down here to Newport News and currently work at the Riverside Regional Medical Center.
Did you become the chairman of the Department of Orthopedic Surgery at Walter Reed National Hospital?
Yes, sir. I did that for the last 6 years I was there.
And are you the chief orthopedic surgeon at Riverside Health System?
I gave that up recently.
But you were
I
chief for
did,
how long?
I did it for a decade, then gave it up.
Have you published in the field of orthopedic and orthopedic trauma?
Yes, sir.
Without going through what appears to be a lengthy resume, could you give the ladies and gentlemen of the jury a rough idea about how many articles you have written, how many chapters of books have you written on orthopedic trauma?
I haven't reviewed that recently, but there's probably 70 to 80 peer-reviewed publications, 10 to 20 book chapters, and then there's some other articles as well, and there's probably 100 total publications.
Have you been working in the field of orthopedic surgery once you started? Basically, once you became chief of Walter Reed, since that time you've been an orthopedic surgeon?
Once I finished my orthopedic fellowship, that's what I did, yes. And during residency, I just did orthopedic surgery.
And you've been in orthopedic surgery, been treating regular patients since that time?
Yes, sir.
Your Honor, at this time, I'd like to tender Dr. Romney Anderson as a specialist in orthopedic trauma.
Any objections?
No objection.
Without objection, so qualified.
Dr. Anderson, I take it you were working at Riverside Hospital when Abigail Zwerner became a patient.
Yes, sir.
And I'm going to try to walk through what you've done with her surgery, but your primary focus, I believe, was on her hand.
Yes, sir.
And when you saw her for the first time, was that on January 6th or on January 3rd?
Can I?
Yes, feel free to review any of your medical records or notes. We had, just so you understand, Dr. Munn testified, who was the chief trauma surgeon at Riverside, who I know did see her with the other trauma doctor. At some point in time, I believe they testified that orthopedics needed to come in to work on her hand. I'm trying to determine whether you were on January 6th or on January 7th, if you know.
I believe I saw her in the intensive care unit on the 7th of January. The morning of the 7th of January.
Tell the ladies and gentlemen of the jury, if you would please, roughly what did you see for purposes, and I'm going to go general and then I'm going to show you some medical illustrations.
Yes, sir. So it was
describe it for the jury, please, if you could.
Yes, sir. It's a devastating hand injury with a significant amount of bony injury or bone fractures, as well as a number of soft tissue injuries that were associated with that.
When you say soft tissue injuries, just tell the jury what are soft tissues of a hand, not the skin, I take it.
There's skin, muscles, ligaments, joint capsules, nerves, blood vessels.
And have you seen those types of injuries in your past?
Yes, sir. This, we take care of a lot of stuff at Riverside Regional Medical Center, but on if you stratified these in a scale of 1 to 10, this was a more closely associated with a 10 type injury, which we were seeing frequently during the war.
And what war were you treating orthopedic surgeon injuries with bullet wounds?
OEF, OIF, and Iraq and Afghanistan.
All right, I have shown you and shown counsel before some medical illustrations that were based on x-rays as well as surgical reports, and you have seen them, I believe?
Yes, sir.
Without MV1 through MV9? I'm going to show them to you as a group first, and it'll help us move faster. May I approach, Your Honor? Are these the medical illustrations that were shown to you, and do they accurately reflect Abigail Zwerner's injury, and would they help you in trying to describe to the jury your treatment of her?
Yep. Yes, sir. These are the ones I reviewed.
I have MV1, please.
Now, are these going to be open to evidence?
These are for demonstrative purposes only, Your Honor.
Demonstrative as well. All right, so they're not going back to the jury, okay? Any objection, by the way, Ms. Douglas?
Not to the demonstrative.
Okay, thank you.
MV1 can be published to the jury. At some point in time, and I believe it's on your screen as well, Doctor, and at some point in time I might ask you to step over to the screen, but for now, they've got a large screen there. Could you tell the ladies and gentlemen of the jury what the upper left-hand... Let's see if I can get this done. Am I doing it right? Hold on one second. What does the this picture show us of January 6, 23? This is an actual x-ray of Abby's hand, correct?
Yes, sir.
All right, now you'll see where there are lots of white spots here. Could you tell us what they are?
So the things that are bright white, those are more radio dense, and so x-rays don't go through those and they show up white. Those are metal fragments of the bone, of the bullet,
So those are the bullet fragments that struck her in the hand?
Yes, sir.
And all of those white dots are bullet fragments?
The dark, or the bright white. The more gray dots are bony fragments.
All right, let me look at, I take it on the bottom left, that's just a side view of the exact same bony fragments and metal fragments.
Yes, sir, a lateral view.
All right, so looking at this picture of January 6, 23, the medical illustration on the right, could you help us distinguish between the bones and the bullets in this diagram?
So the gray items marked as bullet fragments, those are the bullet fragments. The kind of yellowish tan flecks are bony fragments.
I may have trouble because I don't see yellow.
Or it's a gray, tan, whatever, the rest of the bones, like the finger bones, those little fragments that are a little redder down where all the bony breaks are.
Here?
There, that whole region, or if you'd like, I can come point it out.
I'm going to save you because I don't want you jumping back and forth because we have.
But all through that region you just circled are little bony fragments as well as metal fragments.
And what did you do as the orthopedic surgeon for that hand in trying to stabilize Abby?
So the initial, when you see an injury of this magnitude, your initial treatment is not to get everything put back together right away, it's to stabilize things. So we brought her to the operating room for an irrigation and debridement. That is just to try and remove any contamination in there to reduce the infection risk over time. And then, as you can see, some of those bones have no stability at all, and some look like they're short. So we needed to bring those out to length and pin them so that when we went back to do definitive fixation, we'd have the bones out to length and they wouldn't be scarred and short.
When you say you lengthen them and then get them ready for, what are you using?
We use K-wires, just the smooth circular wires that you put in with kind of a drill, and then you cut them and bend them.
Now, I know this is surgery that she was undergoing, but you were not at this time fixing her hand for purposes of the things that you needed to do. You were just cleaning it?
Cleaning it and stabilizing it.
All right, describe for the jury, please, if you would, what are the primary injuries that Abby suffered from with initial injury January 6th that is visible, and then I'm going to show you soft tissue diagram next after the hard bone diagram.
So you can see at the base of the thumb, there's a fracture at the base of the thumb. Then if you go to the index finger.
And I'll take it if you'll let me guide a little bit. Base of the thumb is
right
here.
That's the base of the thumb. You can see there's highly comminuted fractures there. If you move over to the index finger, the base of the metacarpal there's no joint surface even left. It's completely gone with a bone void there as well. And then if we go to the middle finger or the long finger, we can see that there's a large bony defect with highly comminuted fracture.
When you say you lengthen it, what do? You just pull it out and then put wire in?
Yes, sir.
All right, let me switch, if I could, to MV2, please. Should be on your screen. Now, these are the soft tissue injuries?
Yes, sir.
All right, and you tell me where you would like me to go so that you can explain to the jury what is the soft tissue injury. Let me start with the bottom, dorsal external appearance. That's the entry wound of the bullet.
The entry and exit, sir.
And let's move to the left. And I know we just looked at the bones of the thumb. If you could walk the jury from the thumb over to the right and tell us what we're looking at.
So let's start on the index finger. We can see that there was a complete rupture of both of those tendons that extend the finger. And that's where
When you say they're ruptured, tell me what's happened to those tendons.
Oh, I'm sorry. This is looking at the palmar. The picture on the left is looking at the palm. And so that
facing up towards your face.
Looking at it like this. And so you can see that there's complete ruptures of the tendons of the index finger flexor digitorum superficialis.
Can you help us with that in terms that we may understand?
Yeah, I'm sorry.
So this is a hand that's looking straight at my face.
The tendons on the palmar side of your finger allow you to flex the fingers. Each finger has 3 separate tendons. One is called the profundus. There's the superficialis, has 2 slips to it. The profundus goes all the way out to the end of the finger, which flexes the deep part of the finger. The superficialis goes around and comes into here, which bends at the, I guess we'd say, like the first knuckle. We could see that the index finger, the one that goes all the way out to the tip, was 25% lacerated.
Which finger?
The index. And then the flexor digitorum superficialis, 10% lacerated.
All right, now let's go to the far right.
Yes, sir. So this is looking at the hand like this. Looking at the back of your hand like this.
And so her thumb would be on the far right of this right diagram.
Yes, sir.
Tell us what we're looking at.
So the first thing on the top there talks about laceration and contusion of the posterior interosseous nerve. That's a nerve that goes out from your forearm across to the wrist joint, and that's what gives your wrist innervation, or gives you sensation of the wrist.
What happened to her nerve?
It was transected and contused.
When you say transected, for our purposes.
Cut. Yeah.
That'll make sure we all understand.
Right.
Keep on moving right to left.
And then as we go to the right, we see that there's from the small finger to the thumb, as we move from left to right, there's a 75% laceration of the finger that, or the tendon that extends your finger independently. So most of your fingers have a common tendon that helps you extend all your fingers at the same time. The index finger has a separate tendon so that you can point. Like, it's very difficult to point with your fourth or middle finger. It's hard to pull that finger up by itself, but you can do it with your index finger because it's got a separate tendon, which is the extensor indicis proprius.
What happened to Abby's tendon?
It was 75% transected, which if you don't do anything with it tends to rupture.
keep on going. I take it all these great things are what?
That's bullet fragments.
I keep on going.
So as we go to the right, we see that there's a tear in the thumb joint capsule at the base of the thumb, and
Is that here?
yes, sir, right about there. And then there's a dorsal retinaculum tear. And so if you take your fingers and you go like this, the retinaculum, if you can see the tendons on the back of my hand.
See the back right there? You need a little bit higher for. And
So the tendons, you can see them kind of on the back of my hand. The retinaculum holds those down tightly here so that they pull the fingers up. If that retinaculum wasn't there, these tendons would do what we call bowstring, and it would try and go from here to here and just lift up and not lift the finger as well. So that retinaculum keeps the tendons in place so that they have a mechanical advantage to extend the fingers. That was torn.
all right, anything else here that needs to be seen?
No, sir.
All right. This is all as of January 6th and 7th of 23, correct?
Yes, sir.
Did you decide and make a plan for surgery?
Yes, sir.
And when were you going to plan to do your first surgery? On the 7th?
We did, well, the first surgery on the 7th was
To do the wires.
to stabilize it. We've already talked about, yes.
Did you decide when you were looking at Abby's injuries to bring in another doctor to assist you with the surgery that you needed to perform?
Yes, sir.
Who is that doctor?
Dr. Scott Tintle.
And could you tell the jury, please, why you brought the doctor in and where did he come from to assist?
So Dr. Scott Tintle was one of my residents at Walter Reed when I was the chairman there. He had went on to do hand surgery, but he and I did a number of the more difficult hand surgeries at Walter Reed. And so when I was looking at this, I was like, this is much more similar to a war injury than it is what I normally see. And having a second set of competent hands in the operating room is very valuable when you're taking on a problem of this magnitude. So I contacted the administration. They said, be happy to let you bring this guy in. We got him credentialed in a few days, and he came down and helped us with the case.
When did you do your first surgery post-wiring of her hand?
There were a few to my notes here.
And I'll direct you to January 16th of 23 if that will help
Yes,
you.
that's when we did the next surgery. It was the 16th of January.
MV4, please. And feel free to refer to your notes at any time to any of the issues involving.
Yes, sir.
The first issue, I believe, is a left-hand gunshot volar wound. Tell me what that means.
Volar is the inside, dorsum's the backside. So there's a gunshot wound there.
All right, let's talk about the frame A of the January 16th, 23, part 1.
Yes, sir.
Tell the jury, please, what we're looking at in A.
So oftentimes people hear about people that get carpal tunnel syndrome from like typing too much or things like that. That's that this transverse carpal ligament that you can see being cut in this picture is. Right there, right. You can also get it from traumatic injuries. We knew from the radiographs that there was a large bullet fragment in there, probably irritating the median nerve, so we needed to go get that out.
And so the purpose here is to just remove the bullet fragment.
Remove the bullet fragment, give the median nerve more room to kind of live in a traumatized hand.
All right, let's go up to B, please, and tell the jury what we're looking at here.
So we've just reflected the transverse carpal ligament, and then we remove the bullet fragments in there.
All right, C, please.
So one of the tendons that flexes your finger was lacerated as well, so we repaired that. Flexor did
So where am I looking here? I see that the skin's been pulled back, and then I see a pinching device holding it on the right there.
right where that arrow points is where we repaired the tendon. You can see the little sutures in there.
Right there.
Yeah.
All right, and so what was the primary purpose other than removing of the bullet fragment of the carpal tunnel area?
Make more room for the median nerve and repair the tendon.
All right, let me move to MV5, please. Tell the ladies and gentlemen of the jury, what are we looking at here? And I take it this is also on January 16th, 2023. We are deeper. Am I on the left-hand side? Am I looking at the top of Abby's hand or the underside of her hand?
So the left picture is looking at the back of the hand.
Back of the hand, I'll use that. Tell us what we're looking at here.
So we see that there's more bullet fragments there that we took out.
Which are all in here?
Those little gray things, yes. And then we see the laceration to the tendon that extends your finger independently.
Right there?
Yep. And the picture on the right shows us repairing
Before you
it
get there,
too.
that in the middle there, I'm messing up my little, I'm going to start again. There you go. Those are all bullet fragments that you pulled out of the hand?
Yes, sir.
All right, tell us what we're looking at here on E.
That's just repairing of the tendon that we saw lacerated on the left.
So it calls it the,
Extensor indicis proprius.
right? What is that specifically? Because I'm not sure I heard those terms.
That's the tendon that by itself is responsible for extending the finger so you can extend the index finger independently of the other fingers.
And what are you doing in this surgery here?
Oh, bringing the ends of the tendon back together and sewing them together.
Does scar tissue normally form in those areas?
Frequently.
And does the scar tissue cause problems and or future problems with someone like Abby?
It causes the inability to flex down all the way because the tendons on the back are scarred in. And on the palmar tendons that were repaired, makes it hard to extend the fingers.
Let me move to MV6, please, and tell me what we're doing here.
So,
And I'm going to go start off at F. We can zero in on F because it's real fast.
so on the back of the hand is where we fix the index and middle finger metacarpal. This is a picture of fixing the middle finger metacarpal. We put a plate over the area. You can see that there's a large bone void underneath those screws.
So this is a plate, or are those, what is that? 'Cause I see a screw being put in.
That's a metal plate and metal screws that we're putting in there.
And is that to take the place of the bone that was removed by the bullet?
And to hold it stable, yes.
All right, move to
To try and help it heal.
Obviously, it's not a final fix. It's to try to get something.
Yes, sir.
Move to the same picture, but go to G, please.
So in the picture in G shows that we've already fixed the index finger metacarpal.
Point for the jury again which one we're talking about so they can see on your hand where we're talking.
This finger right here.
All right, is this the same plate or a different plate?
That's a different plate. There's two plates in there. You see one kind of hiding out under the tendon on the left side of the screen.
Behind there?
That's one that was on the other image. This one right here is for the index finger, and this one had the index finger where you're pointing right there had such bony destruction it took out the whole joint space of the proximal part of the metacarpal. So the trapezium.
When you use those terms, proximal, could you explain to them what we're talking about in a hand? For us.
Closer to the wrist. It took out the whole joint in there, so we had to do a fusion down to the trapezium.
And when you say
Excuse me,
taking out
trapezoid.
the bullet just removed the whole bone.
It came out and spit it out across the floor wherever, when it went out. When the bullet went in and took bone with it out the backside of the wound.
All right, tell me what we're looking at here.
And this is the thumb where we had to fix the thumb fracture as well.
And again, another plate.
Another plate and screws, yes.
All right, and
we also had to do the joint capsule has gone down there as well, so we had to put in a suture anchor to sew the capsule and ligaments down there.
All right, let me focus you on that for just a second. This is a suture anchor. Where is that going and what is it doing?
It's going down into the capitate, so the tendons that extend your wrist.
Help this juror on the far a little bit.
The tendons that come from your arm down to your across your wrist and go into the carpal bones, or those are all the kind of intermediate bones in here that allow you to bring your wrist up. Those had both been completely transected. They're very difficult to sew back into bone, so we put an anchor into the bone and then sew the sutures on the anchor. So if you look at that picture where it says suture anchor, there's some suture there. Down, yep, right there. We take those sutures and tie it into those tendons. So now that when those muscles fire, it brings the wrist up.
Now, in looking at the notes, there appears to be some non-biodegradable drug delivery antibiotic spacers, I believe, what they are.
Yes,
Could you
sir.
tell the jury, please, what the purpose? What are they? What are antibiotic spacers, and what is your purpose of putting them in the hand?
So, when you have an injury this devastating with bone loss, you're going to have to come back later and do a bone grafting procedure. If you let that just all fill in with scar, it doesn't leave a nice pocket to put the bone graft in. And so we put in this it's bone cement that people use when they get a total knee or a total hip. We fill it full of antibiotics. Those antibiotics leach out over a several-month period of time, so it helps fight infection as well.
So it's basically a time-release capsule that's buried into the hand to let out antibiotics
Yes,
to
sir.
stop an infection. Let me go to MV7, please.
And in that we put vancomycin, gentamicin, and tobramycin, three pretty hefty antibiotics to try and
Keep the infection from
keep the infection from occurring.
The risk of an infection to Abby at this point in time is?
It can be devastating.
I believe I am on MV8. 7, I mean. Tell us what we're looking at here. This is, I take it, post-operative. So you finished your surgery. I'm going to start with frame I, please.
So the thumb tendon, there's a sheath that thumb tendon runs in, and that was all damaged. So we took it out of the sheath and just moved it over, so it wasn't captured in this damaged sheath.
I take it these are all these are what you've placed in there to help with the bones.
Those are the plates for the bones, yes.
And you've moved soft tissue tendons so that they can be free of the damaged area.
Yes, sir.
What is on the far right?
That's just the same thing.
All right, what
So you can see the
exception-
incision being made in the
All right, what
so you can see the
exception-
incision being made in the extensor pollicis longus tendon sheath on the left, and then
that
it being
there?
on your left picture where the knife is.
Okay.
You can see that that's taking the sheath that was damaged, opening it up, and then taking the tendon out and moving it over.
And then where is, I'm looking at here, where?
It's just a little bit more to the right of the screen than it was on the left.
Gotcha,
You can see the empty sheath behind the tweezers there.
gotcha.
See that?
Here?
There, go to that right behind the tweezers is the empty sheath.
These
Yep,
tweezers
right
or
there,
those
right there, yep.
Right there.
And then the tendon is moved over, so it's not in that damaged sheath.
All right, the next part of that slide, please. So tell me what we're, do we, I don't think we need to see it. Well, let's look at Jay real fast.
So when we talked about the tendons having a tendency to bowstring without that retinaculum, we had to repair the retinaculum there.
And that's what you're doing here?
That's what we're doing there, yes, sir.
All right, let me go to the x-ray on the same slide right here. All right, so this is post-surgery, I believe,
Yes, sir.
January 16th, 2023, and you are looking here at all of the hardware that you put in there.
Yes, sir.
Tell me what these, I think I know what they are, but I'd rather you tell me, what is all this kind of reddish area here and around there? What are we looking at there?
Those are fractured bones.
And why are they left there in that kind of condition?
Well, if they've got some soft tissue attachments to them, then they've got a chance of healing in. So it's best not to take out things that you think are viable that can help the bone heal.
I take it you continue to operate and work on her, and I believe your next surgery is on March 16th, which would be MD8.
This is still the same. This is March
still on March
16th.
16th?
Yeah. So
All right, so let's talk about A first. What are we looking at here in the upper left?
So it's she had these bone voids in her hand. In order to get bone to fill those gaps, we have to get bone from somewhere. We have to steal from Peter to pay Paul. So we go into the hip where there's good. The bone in the hip has very high amounts of bone growth factors in it. So when we take that type of bone, we get better healing. So that's why we made an incision over the hip. Made a little window in that iliac bone, went down and took out a bunch of bone, put it on the back table, and closed the wound.
How do you take the bone off of her left iliac crest?
With chisels and hammers and chisels.
And what are you left with when you do that? Just pieces of...
Well, you leave the soft tissue attached on one side, so it's kind of like a window, and then you bring it back down and sew it into place.
And what are the bone pieces that you've removed? Are they broken bones, or are they
No, it's
slices?
just
What
it's
are they?
the bone marrow from the inside of the pelvis.
All right, let's move to B, please. All right, so I see here, and so that is the antibiotic spacers that you had placed into the earlier surgery?
Yes, sir. Those
Why
are
are you taking them out now in this date?
So we're taking them out now. Now there's a void there in the ends of the bones, and that's where we pack the bone grafting.
All right, let's move to C, please, of that same. So I see this tube here, the blue arrow, and then I see what looks like something you're about to punch
Just
into.
a little-
That is the bone graft in the hip?
Yes, sir.
And tell the jury, please, what do you do with that bone graft and that tube there?
We just pack it in the void between the two ends of the bone.
And how do you keep it from coming out?
Well, that's what putting the antibiotic spacer in it kind of creates a rind around the edges of it, and it makes a nice void to contain the bone graft.
Now, I don't have graphs to show it, but there appeared to be a third surgery in February of 2023 and one on March of 23 that had to do with manipulation. Could you tell the ladies and gentlemen of the jury, what do you do and under what circumstances do you put Abby for those other surgeries?
So when you have bad injuries like this, there's oftentimes a lot of scarring that goes in and around the tendons you've repaired and things. She had kind of hit a plateau with regard to therapy, so we discussed with her and then brought her to the operating room to do what we call manipulation under anesthesia. So we put the patient to sleep so that they can't feel anything, and then push like crazy to get the joints and the tendons and the loosened up so that we can get better range of motion.
And why do you have to do that under general anesthesia?
You can't tolerate that without anesthesia.
So are you worried about damaging the bone repairs that you've done when you're doing that, or are you just focusing on the manipulation so that there's movement of the hand?
It's a balancing act. You know, certainly if you put too much pressure on it, you could bend one of the plates or break the bone and the plate. So it's, you know, after you've done this a number of times, you get to a point where you feel like I just can't go any farther. But we got good manipulation out of her without breaking any bones.
And how many times in February, March did you put her under general anesthesia? Twice for purposes of that manipulation?
We did it once, but the second time we did, we were going in to take out the plates and repair a tendon that had started to lag.
What was your plan and what was Abby's duties for purposes of your treatment between that time, February, March, up until October of 2023. What was she supposed to be doing, and was she doing it as far as
She was aggressively working with occupational therapy to work on range of motion and strengthening.
And what's the difference between what they're doing and what you did under general anesthesia, the manual manipulation?
It's similar. We know that the scar tissue fails by what we call fatigue failure. In other words, if you take a paper clip and bend it once really hard, you're unlikely to break it. But if you sit there and just bend it back and forth, back and forth, back and forth, ultimately that paper clip will break. The scar tissue does the same things. The more you can get them to move, and frequently I'll tell patients with this type of problem, you're reading a book, watching TV, I just want you to move and move and move and move. The more they're moving, the better they have of breaking up that scar tissue.
Now, my memory from looking at the surgery from this March 16th, there was something regarding the tendon itself pulling apart. Do you remember that?
Yeah, so...
Tell the jury what that means and what it meant for Abby.
So, Abby, the tendon that extends your fingers to be able to bring them up, the tendon to the middle finger had done what we call attenuated. In other words, a tendon has got a bunch of collagen fibers that are all hooked together. It had slowly pulled apart and was longer. So when Abby would try and raise all of her fingers, there would be a sag in the middle finger. So what we did is when we went in to take out the plates, we brought that tendon kind of back together, and we call plicate it, trying to bring it back, shorten it up a little bit, and then tie it to some other tendons that have the same function to give her a little better extension of that middle finger.
I take it she's not healed at this point in time, but you are still in the process of getting her better and better as best you could.
So Abby's hand is never going to be a normal hand. It's not going to be like her other side. But we've got it pretty darn close, and a lot of it's attributed to how hard she worked with therapy to do that. I mean, you can do a perfect surgery. If the patient doesn't do any therapy, they're not going to get a good outcome. So she's done a lot of work. I think she's done remarkably well with the number of injuries she's had there, but it's never going to be a normal hand.
I take it you did surgery again in October 2023?
I think that's the one where we took.
And that would be MV9?
That's the one where we found the adhesions.
It's on your TV screen, I believe.
Oh yeah, that's the one where we took out all the plates and did the tendon work for the lagging tendon.
All right, so in A, as I'm looking here, all of these plates have been put aside. And are you in the process of taking out the plate on the right?
Yes, sir.
All right, tell me why you're taking out that plate and what's that leave for purposes of bones?
So, if you've got a plate on a bone, and you can imagine this tendon riding back and forth over top of that bone over time, they can rupture. And there's a lot of stuff in there. Those were sitting right over the tendon repairs. So it made sense to take out the plates at that point in time, especially when we were going to go ahead and do the plication of the tendon.
All right, let's look at B. Same section, same slide. I take it this is the thumb plate?
Yes, sir.
And are the same issues of concerning the tendons rubbing against the plate over time?
Yes, sir.
Could you tell the jury, please, what is Abby's hand like now 10 months post-surgery once you've removed these plates? What is the condition of her the hand?
The bones are still healing. They're not healed up all the way, but we have seen union of the middle finger. But she's still got pain with motion. Still a lot of pain is related to the soft tissues.
All right, so tell me, and I think you can go back to the main slide there. Is this your last surgery with Abby?
Yes, sir.
23?
Yes, sir.
And when you saw her in 23, how would you describe her condition?
So she was having pain at the base of, kind of in this region right here. It was hard to tell whether that was from the index finger bone not healing all the way, where there was no joint and we had to fuse it back to the trapezoid, or whether it was arthritis in the base of the thumb.
And why couldn't scans, x-rays, MRIs, whatever, why couldn't that tell you?
Well, we did do a CT scan and showed there was a clear non-union there, but these are, a centimeter apart, and it's difficult to tell in physical exam which was which.
Tell the jury, please, what does non-union of that bone mean in that area?
There's fibrous tissue in there, and it's not bone that's healed all the way across the fracture.
And how would that affect Abby in using or trying to use that hand with regard to pain or discomfort when there's a non-union of a joint?
When we tend to have non-unions, it's painful. Moving things with non-unions causes just a tiny bit of motion at that area, and the tissue around the area is what causes the pain. And so anytime you'd use that, you'd feel some pain.
Now, did you decide to do something with regard to this area of her body with regard to a future surgery?
So I would have been happy to just bone graft the non-union. However, I don't do base of the thumb arthritis surgery. That's really a surgery that's done by hand surgeons for arthritic conditions, just like a joint surgeon does knees and hips, a hand surgeon does base of the thumb arthritis. So at that point, I felt that the best thing to do would be to send them to somebody that could treat both of those problems if both of them needed attention.
Once someone went in and opened up the hand, they'd be able to see what the scans may not show and then operate on whether it's arthritis or something else.
Yes, sir.
Did you have a doctor in mind when you did that?
So there's a doctor up in Richmond, Dr. James Stewart, who's widely recognized as he takes on a lot of difficult cases and referrals. And so I called him and said, can you take a look at this and tell me if you think it's the base of the thumb or if it's the index finger non-union. I'm happy to do the index finger non-union, but if it's a base of the thumb arthritis, it's something I'd like to have you take care of.
And as far as you know, he performed that surgery in 25?
Yes, sir.
And you have seen his medical report since that surgery? Do you know if you did?
I think I've seen, so Abby would come back and follow up with us, so I see, but I can't recall whether I actually read his op note or not, because I talked with him, I was like, what'd you do?
Right.
So I knew what he did, but I can't remember if I actually read the op report or not.
Now, you already indicated that Abby's hand is never going to be normal,
Yes,
like
sir.
her other hand. First of all, let me ask you whether or not all of your opinions today are stated with a reasonable degree of medical probability?
Yes, sir.
And all of your opinions today relate to her being shot on January 6th of 2023, all
Yes, sir.
caused by that?
Yes, sir.
Now, when you say that they're permanent, what sorts of problems is Abby going to have, even understanding that she had surgery in 25 for the thumb? What sort of permanent injuries does she have now and will continue to suffer?
She'll certainly never have the exact same range of motion as the other side, never the same mobility. We fused joints. There's more scar tissue in there than the hand that's not been injured. She'll probably have some component of chronic pain over time.
Does age help or hurt an injury like this?
Being young allows your body to be more resilient than if this had happened to you or I, but certainly a devastating injury is a devastating injury.
What happens when she's 50, 60 years old? What does that do to these injuries?
So she'll be at risk for having some of those tendons rupture as they rub over healed bones and things. Tendons may continue to attenuate. She's had some color changes to her skin and things based off of probably some of the nerves that were injured in there.
If I could, Your Honor, could I have the doctor just step down and point out to the jury with Abby's hand so the jury can understand where the surgery is and what's left and how it looks now and why does it look so different?
Any objection to that?
No objection, Your Honor.
All right. Be careful stepping down. Ms. Douglas, if you wanted to step up, that's fine as well.
Doctor, why don't you do it over here so the jury can see it? I just want you to point out what you've done and tell me what the hand.
So first we look at the back of the hand. Over here. So you can see that there's kind of a little divot in the back of the hand. That's where some of the soft tissue is lost. You see the entrance and the exit ones are up here. If I ask her to move the hand dorsally, there's going to be tightness in there. If I ask her to flex it, there's going to be tightness in there. You don't see a lot of color change now, maybe a little bit darker here, but as her nerves fire, they can cause blood vessels to expand or contract, and that somewhat gives her those color changes. Although this is better than it was, the ability to extend that middle finger all the way is not perfect yet. We're keeping it. And so, keep do the other side as well. So certainly see that she doesn't have the ability to bring the fingers down all the way. Then you can see on the inside here where we did the surgery there, that's where we do a carpal tunnel surgery and remove that. There's certainly, if you can compare both sides, there's a lot of thickening in there where there's scar tissue. If you bring your fingers and spread them apart, she doesn't have the muscles that spread your fingers apart, or probably interosseous muscles. She's not able to fire her interosseous. Don't bring the fingers all the way apart like she has on the other hand.
What about strength?
Oh, so grab both my fingers here. Just grab your whole, squeeze as hard as you can. This side would be considered normal. This is less than half of what I'm feeling on this side, and I think some of the occupational therapy was did some strength testing, but I don't recall exactly what those were.
Sitting here almost 3 years after the shooting, do you believe that she's going to get that range of motion or strength back to any significant degree from where she is today?
Sorry, sir. She may make some slight improvements, but I don't think she's going to make drastic improvements in half of her hand like the other hand at this point.
Doctor, you can take the stand again. I'm not certain that I have left anything out, but I want to ask before I sit, if I could, for 1 second, Your Honor. Doctor, please answer any questions that counsel may have of you. Thank you very much for your time.
Yes, sir.
Dr. Anderson, just a few questions for you.
Yes, ma'am.
So your last surgery was in October of 2023.
Yes, ma'am.
And are you aware that a few months later, Ms. Zwerner started cosmetology school?
Yeah, I didn't know how long after that she started it, but I know that when one of my appointments, we talked about that.
And are you aware that she completed cosmetology school from January 2024 to January 2025?
I did not know that she completed or graduated, but I knew she was in it, and
You had no objection to her going to cosmetology
no,
school?
no, ma'am.
And did you, or were you aware that she has become a licensed cosmetologist in the Commonwealth of Virginia?
I did not know that she's become a licensed cosmetologist, but congratulations to her.
Congratulations. And Dr. Anderson, do you, in your course of treating Ms. Zwerner, do you recall a time where she contacted you and asked you to backtrack and write work notes for the past 2 years?
Yes.
Tell me about that.
This happens all the time in clinic when people have had some injury and now they're looking to get back into doing things, and there's, maybe we didn't do that in the past, and at some point in time when she's not working and we don't give them a work note, we have to go back and amend work notes, not infrequently.
Okay, so you had not done work notes in real time for Ms. Zwerner for the past 2 years?
Yeah, I don't recall, quite frankly. I'd have to go through my notes and say whether or not we did or we didn't. It's not something that I usually do. It's something that when you take care of an injury like this, there's a large number of people that are helping take care of things. We have medical assistants in the clinic that frequently do that stuff for us, and then I'll sign it. But I oftentimes, if we miss it, we have to go back and do it later.
I'm just asking, Dr. Anderson, do you recall backtracking a work
Yeah,
note?
yes.
You backtracked a work note?
I know we had to do work notes to make up for time that we didn't have work notes previously.
Thank you, Your Honor. Thank you, Dr. Anderson.
Yes, ma'am.
I promoted you to a judge.
I'm not sure that's a promotion.
I want to follow up. After you do these different surgeries that we've talked about, what do you do with her hand? Is it wrapped? Is it a cast? What is the condition when she leaves the OR or the hospital?
So usually we put it in with dressings and a splint, and that splint needs to come off fairly quickly, because usually if you left something in a splint for 6 weeks, it's just going to get stiff again. So like when we're doing manipulations under anesthesia and we're trying to get the tendons to move and things, we'll put it into a splint just to let the soft tissues heal, let the wounds heal, and then start range of motion, usually around 2 weeks.
Did you want her to be careful about the use or damage to that hand post-surgery?
Yes, sir.
I have no further questions of this doctor.
Any follow based on that?
No, Your Honor.
Dr. Anderson, thank you very much. I appreciate your time.
Is he free to go?
He is free to go.
All right, you are free to go. You're excused from court. Just please don't, because the case is still ongoing, don't talk to anyone about it, okay? All right, thank you, doctor.
That's just strange to me that they tell people that once you're released from the subpoena, you can talk to anybody and anything about anything you want.
Jeb Stewart. Your full name, please.
James Yule Brown Stewart.
And are you an orthopedic surgeon?
Yes.
Dr. Anderson just testified and says you take on all the hard cases.
Challenging.
Could you tell the jury, please, a little bit about your medical education background?
I went to medical school in Norfolk, Eastern Virginia, and Army scholarship, and trained as a surgery intern in El Paso, Texas, at William Beaumont Army Medical Center, and did my orthopedic surgery residency at Walter Reed Army Medical Center, and subsequent hand surgery fellowship at Walter Reed, and served 4 more years in the Army. Retired in 2021 and came to Richmond, Virginia.
How long have you been doing orthopedic surgery?
Since a residency, close to 30 years.
Your Honor, without going through more, I tender the doctor as a specialist orthopedic surgeon.
Any objection?
No objection, Your
All
Honor.
right, thank you. He's qualified as an expert in orthopedic surgery, is that correct?
Dr. Stewart, I'm going to try to narrow your testimony because Dr. Anderson took us all the way up to when he referred Abby to you.
Yes.
And I take it that you took her under your care at the advice and recommendation of Dr. Anderson because of a particular problem with her thumb?
Yes.
All right, I'm going to show you, first of all, MV10, which is a medical illustration, which I believe I had sent to you, and ask you if this would help for you to describe to the jury what you did.
Yes.
All right. Your Honor, permission to publish MV10?
Any objection?
No objection.
All right, once again, demonstrative.
Yes, Your Honor.
All right.
It's on your screen, Doctor, and if I can point, and I'm going to look at slide A first. And first of all, as we're looking at A, tell the jury what you found when you went in initially to look at Abby Zwerner's hand. I think you had to open her up besides scans.
Well, what I expected, which was an unhealed bone in her left hand with a defect.
And what kind of defect?
We call it a non-union, where the bone did not heal.
Now, Dr. Anderson had indicated that she was having some pain in that area of the hand, and he wasn't certain whether it was arthritis or it was a non-union or what, which is
Correct.
What is it that you found, and what would you describe the reason that she was having pain in that part of her hand?
My initial evaluation, I was more impressed with the pain in her thumb joint, which is just underneath that device with the bone graft, even though she had movement of the non-union in her left hand. And I tried a cortisone injection to the joint right next to that area to see how she would do for both therapeutic and diagnostic reasons.
And how did that shot help for her?
She came and saw me a few months later and said it helped for about a week or two and had moderate relief. But at that time also her complaints and exam findings were more consistent with a symptomatic non-union or the problem there at that metacarpal in her left hand.
Do you know when you first started seeing Abby? Was
Yes.
that the beginning of 25, or when was it?
That was December of 2024.
And
So
is that
almost
when-
2 years from the time of injury.
Gotcha. Is that when Dr. Anderson had referred her to you?
Yes.
All right, so I take it you attempted to perform surgery to try to relieve this pain? Is that what we're looking at in April
Yes.
14th of 25?
This illustration illustrates the surgery that I recommended, which is a repair of the non-union using structural bone graft from her pelvis.
All right, so let's go to B, please. Dr. Anderson had indicated that he had taken a pelvis bone.
Yes.
Did you have to do the same thing?
Yes, from her opposite side.
So you went into the iliac crest of the other side?
Correct.
He described her moving and chipping away the bone, putting it aside.
Object to the leading.
Go ahead and tell us what you did on the iliac crest of the opposite side. I apologize.
Objection is sustained. Now you can
I'm going to rephrase it. You tell us what you did with the iliac crest of the right side.
So this type of problem requires good bone graft, and it's typically from the patient. We call it autogenous. And the iliac crest has probably the highest quality bone graft. And you basically remove a section of bone from the iliac crest or pelvis. And her original bone graft donor site was on the left, so I went on her right side to get that.
And where did you place it?
I placed the bone graft after cleaning up the non-union site in the space, and it measured about 1.5 centimeters or so in length to fill the defect.
And when you say it measured, is that the gap size for the
gap
non-union?
size, once it was cleaned up, the non-union and the devitalized tissue, yes.
All right, so what are you doing here in B of MV10?
You can see the bone graft, that little trapezoidal area of bone at the base of the metacarpal, and then the plate and screws. Correct. And the plate and screws are being used to stabilize the bone to allow it to heal.
Now, if my understanding is correct from earlier testimony, Dr. Anderson had a bone graft, a piece of like this before?
I think it was mostly cancellous, but I'd have to go back and look at his operative report, which was from the iliac crest.
And what is a cancellous?
Well, you have two types of bone, and one is cortical, which is the hard bone that we all see, and then inside that bone you have cancellous bone, which is in the medullary canal.
And so
it's
what was
spongy.
And what was the purpose of this plate here?
To stabilize this structural corticocancellous bone graft inside the defect to allow that bone to heal.
Back up to the full picture of 10, MV10. All right, looking at the far right, the post-operative surgery. So you did surgery when on April 14th?
Yes.
25?
Yes.
And if I'm not mistaken, the X-ray that we're looking at the far right is
Bleeding again.
dated when? What,
Objection to leading.
I'm asking when is the day of the X-ray on the right side?
So sustained is the first part of the question. Now the second part. Go ahead.
I'll rephrase it, Your Honor. I don't want to. When is the X-ray taken on the right side of this diagram?
Well, according to the diagram, 5 August 2025.
So that's just a couple months ago?
Correct.
Tell us what we're looking at. What do we see?
What you see is the plate in place and the bone graft, and at that visit, I felt as though there was some evidence of early consolidation or healing. These can take upwards of 6 to 12 months to be completely consolidated.
As we sit here now in October of 25, is that plate still in Abby's hand?
It is.
Do you believe, first of all, do you have any idea as we sit here whether you'll be able to take out that plate and win?
Yes, and I've spoken to her and will probably recommend taking that out within 6 to 8 months. She still has a fair amount of pain over that area, which I think is related to the plate and the screws. So probably within a couple of 3 months, we'll get a CT scan to assess for complete consolidation and then subsequently plan on removing the implants because they are so close to the skin.
Do you believe that Abigail Zwerner's injuries in her hand as a result of this shooting on January 6th are permanent?
Yes.
Do you believe that your testimony and your opinions today are based on a reasonable medical probability?
Yes.
1 second, Your Honor. I have no further questions. I appreciate you giving us your time.
Thank you. Any cross-examination?
Just a few questions. Dr. Stewart, are you aware that during the course of your treatment of Ms. Werner that she's completed a 1-year cosmetology program?
Yes.
And you know she's a licensed cosmetologist in the state of Virginia?
Yes, it's reflected in my notes.
And you don't have any objection to that, Your Honor?
No.
No, thank you.
Any follow-up based on? Okay, thank you very much.
Thank you, Doc. I'm sorry it came this far for that little bit we needed.
It's okay. Thank you very much.
Thank you very much, Doctor. You are excused and released from your subpoena, but I would ask that since this case is still ongoing, you not talk about the case.
Absolutely.
Thank you, sir.
He's released from our subpoena.
All right, very good.
Thank you, Dr. Stewart. Appreciate it.
All right.
A short break before our next witness.
Okay, and that's going to be. Okay, all right, very well.
Thank you, Doc. Appreciate it.
All right, we'll go ahead and take a 10-minute in real time break, 15-minute in lawyer time break, and we'll be back. Have Deputy Hopkins come get me. All right. Thank you.
Your Honor, minor issue beforehand.
All right.
Your Honor, there was a colloquy before we, I think, went on recess earlier about how Your Honor had previously ruled on the motion regarding collateral source, the GoFundMe, shirt fundraiser, that kind of stuff. I'm looking at the transcript, and there's, I think, a disagreement as to the scope, and we're raising an issue that we think is distinct from that, but is related legal grounds.
All right, let me get my notes.
Yes, Your Honor.
That was, I believe, plaintiff's 5 text messages and gratuitous contributions.
Correct, Your Honor.
That was the 5th motion we took up that day, and for the record, that was October the 16th of this year. All right, go ahead and tell me the issue here.
Yes, Your Honor, and for context, if it helps, page 153 of that court transcript has Your Honor's ruling, which is I'm going to deny the motion to exclude the question about whether someone did or didn't contribute, but I'm going to grant it as to any amount. So what we're dealing with now is the next witness is Ms. Zwerner's sister. And what I now learn from defense counsel, which is a different evidentiary issue, the question isn't did you or didn't you contribute, which Your Honor's already ruled upon. The question is, did you create a GoFundMe page? Did you create a shirt fundraiser page? Did you create these things? Our concern here is, of course, the sister, in the context of someone who is not related to Ms. Zwerner, has inherent bias baked into the relationship of the individual. And there is going to be testimony as it relates to things that she did to benefit the plaintiff as a result of this injury, whether it's shirt fundraisers or GoFundMes or whatever it might be. If we venture into the area of talking more detail about what was the shirt fundraiser, how much were people charging for the shirt fundraiser, things of that nature, we're getting very close to this collateral source issue.
Right, yeah, I'm not allowing that. I agree. We're not talking about money. I've made that clear. You can ask her. Yeah, I mean, I'm going to overrule your objection as to asking her, did she create these things? But that's it.
Your Honor, that was my plan. Okay. And I looked at the transcript from before, and I very clearly said I would like to ask this witness: did you create a GoFundMe, and did you create a T-shirt site? Okay. And are those still active? That's it. Okay. No amounts.
Right.
No amounts. The cost of the T-shirt, anything.
Right. And once again, I have no problem with you bringing this up ahead of time. I appreciate it. I understand your objections to that, and those are preserved from the October 16th hearing. But as long as we're clear on what we can and can't ask, and I think we are now, then I think, are we otherwise ready to proceed?
Yes, sir.
All right. Anything else you want to put on the record about that? Okay. All right. Call your next witness. And we'll bring them in. We're not going to forget them.
And Ms. Zwerner.
All right. Come on up, Ms. Warren.
Come forward. Let me get you stand right here. Face the clerk. Raise your right hand.
Do you swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I do.
All right. Sit up. Watch yourself. Set it up. Take your time.
May it please the court. Good afternoon.
Good afternoon.
Can you go ahead and introduce yourself to the jury?
Hi, I'm Hannah Zwerner. I'm Abby's twin sister.
And Hannah, I am going to show you a roadmap that I promised you. And if we can publish this to the jury. Oh, it's an old one. It's not the right one. Always technical difficulties. Well, that's up. How are you today?
I'm doing okay. How are you?
Good. You a little nervous?
Yeah.
I know that you were planning to testify tomorrow and made it over here today, so thank you.
Yeah, of course.
So, we've got a roadmap in front of you now, and this is just the 3 buckets of stuff we're going to talk about, okay?
Yeah.
And I drew 2 roads because the 2 of you kind of twinned together and you started. And then we're going to talk about growing together, and then we're going to talk about life today, okay?
Yeah.
Ready?
Mm-hmm.
All right. So, natural question for twins. Who was first? Who was second? I heard Abby's the middle child, so tell us about that.
Yeah, Abby is 8 minutes older. We do like to joke that, well, I joke it was the best 8 minutes ever, just stretching out before I was pulled out into this world. So she is 8 minutes older, but I am a couple inches taller.
And that's your balancing between the 2 of that.
Yeah.
And growing up, were you the type of twins that dressed the same? Mom put you in the same clothes to school, or how did you guys handle that?
I can confirm there are pictures of us when we're like toddlers dressing similar. However, when we grew up, I really wanted to dress alike. I don't think I understood that there's a difference between identical and fraternal twins. She did not want to dress the same as me.
And as you were growing older, you also had an older brother.
Mm-hmm.
And your older brother, as we learned, was 16 months older than you all.
Yeah.
I just object to the relevance of this.
All right, can we move on?
Sure, Judge.
All right, thank you.
And during those times growing up early in life, did the 3 of you grow a bond together where you could understand who Abby is as a person and how she changed through the years?
Yeah, I mean, we've built a lifetime of memories together. We're very close. I think she's even more than my best friend. She's my sister.
And as you all grew older through middle school and high school, tell me about your desire to stay close to Abby and Abby's desire to make a name for herself.
I think I always wanted to be more like Abby. If she did something, I wanted to do it. But yeah, as we got older, you kind of want to figure out who you are. So while we are very similar, I think we're different as well.
And when it came time to choose where to go to college, had you all gone to school together up until that point in time?
Yes.
And then what was the decision that you all made at the time of college?
I could not go to the same college as her.
And that was her instruction?
Yes.
And where did Abby decide to go?
James Madison, and she loved it there.
And where did you go?
Christopher Newport.
And did you have things in common in terms of sporting teams and things that you liked?
Your Honor, again, object to the relevance of this.
What is the relevance?
Your Honor, ultimately we're asking this jury to understand the difference between Abigail Zwerner before and after January 6th. In order to illustrate how she, if at all, has changed, we have to first get an understanding of the foundation of the witness to be able to demonstrate her knowledge of the individual, describe what life was like beforehand, and then differentiate those experiences after the fact.
All right, overruled. You may proceed.
Thank you, Your Honor. So, if we can go to what's been pre-marked as 90C. And we'll just show that to the counsel. It's already been shown to counsel before, but just in case, Your Honor. You see that up on the screen?
Yeah.
All right. And that's a picture of your sister?
Yeah. We were an Orioles family growing up. We went to games. We watched them together, and that's definitely my shirt. Yeah, she's sitting in her classroom. I helped her put some of those things up. She's very particular about the way that she wanted her decorations. Yeah.
Permission to publish, Your Honor? And I'd move it into evidence.
No objection, Your Honor.
That's your jersey, huh?
Yeah.
So, as you all were getting older and she started teaching, she moved back to town, right? Back to the peninsula?
Yeah.
And did you 2 live together?
Yeah, we did. While she was finishing up James Madison, I was in Florida, but moved back, and we were both teaching at the same time, living together. Yes.
And when you all were teaching, obviously out at work, you come back home at the end of the day.
Yeah.
Would you guys spend time together in the living room?
Yeah, every single evening. So I was a high school English teacher. She was an elementary school teacher, and she had like mountains of paperwork. She would hook up to the printer in our living room and print things for lessons the next day. And I just remember thinking, she's so dedicated, and I just never brought work home. That's just, how the 2 of us were different every single evening she would be on her laptop prepping for the next day. She went to work early. She came back after hours. Yeah, that was our life.
And when she wasn't sitting on the chair in the living room with a printer, what did Abby like to do?
Hang out with friends, go out shopping. She could never sit still. She always wanted to get out and do things.
Was she a book by the fire kind of person on the weekends?
That's me.
And growing up, was that always how she was?
Mhm.
Did you all go to amusement parks like Busch Gardens and things like that as a kid?
Yeah, and Abby was always the one to stay behind, always kind of timid. While my brother and I would, go on the roller coasters, she was fine with the teacups. If we were going to Virginia Beach, my brother and I would go into the water and she would stay behind, always observant and timid and watching, but always present.
And in your interactions with Abby, as twins or just as sisters, did you two grow to develop an unspoken bond?
Yeah.
Tell us about that.
We can look at each other and know exactly what the other person is thinking. She's agreeing right now, I can tell you that. Yeah, I mean, like I said, when you've been with somebody your entire life, like, I've never been in this world without her.
Your Honor, again, I'm going to object. We're getting far afield of anything that's relevant. Ms. Zwerner's feelings are not at issue here. It's about her sister.
I disagree, Your Honor. I think ultimately we're putting on a case tomorrow about an evaluation, a psychiatric evaluation, and to lay the foundation of the differences and the changes in her demeanor, who she is, how she shows up in this world. Who better than the person who's lived with her their entire life, but 8 minutes?
Right. Let's move it along to those topics.
Yes, Judge.
Right.
So, when you spend time with Abby and before this time, I'm going to show you a video, if you can. This is 90D.
Which number is it?
90D is in dog. Yes, please. You see that picture of her, or video, I should say?
Yeah.
What does that remind you of your sister before January 6, 2023?
Full of light and spark and just so outgoing and just silly.
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 I'm going to change gears and talk about after January 6th.
Okay.
You said that was silly, full of light. Can you tell us about that light in Abby today?
It's still there. It is very dimmed.
And it's dimmed like what?
She's just not the person that she was. I feel like she's kind of lost her sense of direction in a way. She doesn't want to go out anymore. I don't talk to her as much as we used to. We talked about the unspoken twin language, and I don't know what she's thinking all the time. And yeah, I think that she had a lot to be excited about, and she doesn't anymore. And so that light has kind of dimmed.
And are there times since January 6th where you looked at your sister and you felt like you can't read?
Yeah, yeah. She doesn't want to talk about things. She doesn't share them with us.
And in your impression of your sister, is she a people pleaser?
Yeah, she wants everyone to be happy and doesn't worry about herself, but worries about everyone else.
And when you say she's keeping stuff to herself, tell me what that looks like when you see it in the real world.
Just shutting down, becoming more reclusive. Yeah, it's like a wall is put up between her and the rest of the world.
And before January 6th, 2023, did you ever feel like that wall was ever between you and your sister?
No.
Do you feel like there is a wall, however tall it might be, between you and her now?
Yeah, we're working on it, but it's there.
You said earlier that she's sort of reclusive.
Mm-hmm.
And we talked before about sort of her demeanor to not be the person to grab a book and sit by the fire.
Yeah.
How has that changed since January 6th?
She doesn't leave the house. It's very hard to get her to go out and do things, and if she does, someone has to be with her. She's really afraid of being alone.
And when she's out and about, because she is sometimes, right?
Yeah.
And you see her, do you see that same light, that same color in Abby that you used to see?
No.
Can you tell us what you do see?
Someone who is scared but trying to be strong for other people.
Is that what you see today?
Yeah.
Thank you, Hannah. Those are all the questions I have.
All right.
A few questions.
Cross-examination.
The right thing to do would be to ask no questions.
You've told the jury that your sister has been more reclusive and withdrawn from the community.
Yes.
You have put your sister out in the community through fundraising websites, haven't you?
Yes.
You created a GoFundMe page.
I did.
And it has Abby's picture on it, correct?
Yes.
It puts her story out in
Yes.
the internet.
That's correct.
And you also have a website to sell T-shirts.
That's correct.
And again, you put your sister's story out in the universe and make her available.
That is correct. It was not without her permission, if that's...
So she allowed that. And you talk about that your sister doesn't want to go anywhere. Have you given your sister any gifts of concert tickets?
I
since
have.
that? And where was that?
I drained my bank account to take her to Taylor Swift.
So she was able to go to Taylor Swift?
Yes,
And that's
and it was not without its own challenges.
That's a pretty large crowd.
It was.
Where was it?
Philadelphia.
The Eras Tour in Philadelphia?
That's correct.
And your sister was able to go do that?
Like I said, yes, but it was not without its challenges.
Thank you. No further questions.
Thank you.
Any follow-up?
Yeah, Your Honor.
All right. Is she excused?
She is, and similar to Mrs. Zwerner, we'd ask that she be permitted to remain in the courtroom if she wished.
Is she under your subpoena, Ms. Douglas, at all?
She is not.
Okay. All right. Then you are excused from court. However, you may stay in the courtroom to listen. All right. Thank you. All right. Are you moving 96 and 90D into evidence?
It was 90C and 90D, and yes, Your Honor.
All right. Any objection to those two?
No, Your Honor.
All right. Those are admitted. All right.
No other witnesses, early release again.
All right.
We were ahead of schedule, Your Honor. We have 2 witnesses tomorrow morning on the plaintiff's side that we intend to call.
All right. And then is that who are you planning to arrest after that?
Yes, Your Honor.
Okay. All right. And then will the defense have witnesses ready to proceed in the afternoon tomorrow?
Judge, we're anticipating coordinating some potential witnesses who might be available. That's in the works, and we'll try to provide an update as quickly as possible to opposing counsel.
Thank you very much. I'd like to get as much done as we can because I do want to try to have an early release on Friday for Halloween, get everyone home to either their kids or handing out candy.
Your Honor, I don't think that'll be an issue at all because we certainly won't be able to fulfill the day on Friday, and I wanted the court's indulgence. We talked about that yesterday.
Okay, very good. I'm not going to recess court. I am going to excuse the jury, however. All right, ladies and gentlemen of the jury, we're going to take our break for the day, and we will start fresh tomorrow morning at 9 a.m. Again. So get a good night's rest, and as you've heard me 3 times already, I guess, but I will read it again. Ladies and gentlemen of the jury, we are recessing now for our evening. I ask that you be back in my courtroom back upstairs at the main building at 9 a.m. During this break or recess in this course of this trial, you are not to begin discussion of any aspects of this case. All right, I understand there's a matter to take up outside the presence of the jury.
Yes, Your Honor.
All right.
Jeffrey Bright, Your Honor, for the record. Your Honor, we advised the court, and the court urged us at the beginning of this trial to make sure that we had agreement with counsel and urging the court at 7 o'clock each evening we would provide the witness list for the next day.
And they didn't do that.
Defendants in this case have subpoenaed 42 witnesses, and they have asked virtually every one of our fact witnesses to be reserved for trial. Last night at 7 o'clock, we advised the court early and counsel that we would be finished either Wednesday afternoon or Thursday morning. No surprise. The defendants last night gave us 1 witness for today, and that's a witness who's already testified, Officer Blythe. I know that they have their own strategy to keep, but they've now told us their experts are unavailable till Monday. There are at least 35 local witnesses here in Newport News that are under subpoena. And I'm just wondering, like, what's happening with 1 witness when we're trying to do an efficient trial? I would have thought their experts would have been here no later than tomorrow, at worst. Now they've given us 1 witness and reserving 41 witnesses.
For an entire day.
The court needs to understand that.
She did say yesterday, just a few minutes ago, at the end of that day, that they weren't going to be able to fill the day on Friday. So that would be fine anyway. But 1 witness and a witness that's already testified? So what, are we talking a half hour here? An hour at most?
What are we going to do, just go home and do nothing until Monday, or are they going to wait and hold 20 witnesses tomorrow? So I'm of great concern that we are wasting a huge amount of judicial time as well as counsel time, and that is my concern. Officer Blythe, we have other issues with, but we'll bring it up after they start their case.
All right. All right, were you not able to provide a schedule for witnesses?
We did provide. I'm going to let Mr. Hogan address the issues about the fact witnesses. I want to address the scheduling. We asked months ago when we would get the case. We've been told repeatedly midday on Friday, and we planned accordingly. I made the court aware very early on that our experts were coming on Monday, so that there's nothing new here. They significantly truncated their case, and we have not heard the testimony of the day, which largely depends on, will change what fact witnesses that we call. So I'm going to let Mr. Hogan address that.
Yes, Your Honor, members of the court, with respect to the fact witnesses, I'll note Mr. Wright is correct that there are several witnesses on deck, and they may be necessary to rebut or challenge the testimony that develops today. Also, as Ms. Douglas has alluded to, this case has been fluid from the beginning, although we have received assurances throughout that it was likely that we would receive the case by Friday. To the extent that there's any inconvenience to these witnesses, I've been in close coordination with them. I've kept them apprised of the proceedings throughout, and so depending on how the evidence shakes out today, I can also confer with counsel at the end of today, and we can make a decision and give them notice about who to expect tomorrow. If I'm not trying to keep anybody on the hook and keep them in limbo without, I'm not trying to unduly inconvenience people. I'm sensitive to that fact, Judge. But these folks, we can't control the way the evidence develops or some of the calendaring issues. So.
All right, yeah, I've understood about the experts. I'm assuming they're coming from other places other than here, and that those travel arrangements had to be made ahead of time, and that was your best guess for Monday. And you've told the court that when we started that, so I don't have any problem with that. I'm just hoping that we can get in as many fact witnesses on the defense side on Friday, and I understand the need to wait to hear what the testimony is today to then decide. But I am going to ask that, by the end of court today, I'll give you some time after we're finished with the witnesses, that we talk about another another scheduling time for and how many witnesses you think you can call either this afternoon or for Friday. All right, so I'll withhold any decision on that or taking any action, I will say. Okay. All right, are you ready to call your next witness and have the jury come in?
Yes, Your Honor.
All right, very well. All right, you may bring in the jury.
Introduce yourself to the jury.
You may proceed.
Good morning, Dr. Watson.
Good morning.
Could you go ahead and introduce yourself to the jury and state your full name for the court reporter?
Yes, my name is Dr. Clarence Watson. Clarence Watson.
And you're a doctor in what?
Psychiatry, forensic psychiatry.
And doctor, you're here today because at some point we had asked you to evaluate our client, Miss Abigail Zwerner. Is that correct?
That is correct.
And you, as a result of that evaluation, have come to some findings as it relates to her psychiatric condition. Is that correct?
That is correct, yes.
And we'll get to that during your testimony. But we have to sort of check some boxes before we can get there. We can go to the IPVO. And so this is a little roadmap of what we'll be talking about today, okay? We're going to talk about you to start. We'll talk about your experiences. Then we'll talk about the evaluation itself of Mrs. Zwerner. Then I want to talk to you about this brain-body concept that may come out in that evaluation.
Yes.
And then I want to talk to you about your view and your prognosis for Ms. Zwerner's future. Sound good?
Yes.
All right. So let's talk about your experience. You said you're a doctor in psychiatry. Can you walk us through your educational background that led to that DR in front of your name?
Sure. So I started on a different path. I started out my undergrad degree at Temple University in Philadelphia, where I earned an economics degree. At the time, I was deciding between medicine and the law, and I decided that law was quicker.
My condolences.
So I went to law school. After undergrad, I graduated from Villanova School of Law. And then I decided that I was not done with this sort of science bug and the medical, my interest in medicine. And so I went into a post-bac program to take prerequisite courses to allow me to apply to medical school and successfully completed that. And then went on to Jefferson Medical College, where I graduated from medical school. After that, I went into internal medicine at Thomas Jefferson University Hospital, did my internship there. And then thereafter, switched to general psychiatry and completed my residency in psychiatry at Thomas Jefferson University Hospital. Following that 4-year period, I then went into forensic psychiatry training in New York at St. Vincent's Hospital, the New York Medical College.
And could you talk to us about the distinction or the difference, if any, between general psychiatry, the 4 years, and then what you do in the 2 years of forensic psychiatry training?
Sure. And the training for forensic psychiatry fellowship program is 1 year. And so it's a total of training in psychiatry for me of 5 years. And the general training is learning everything that you need to know about mental health disorders. And so that spans across all age groups and genders. It expands across all mental health disorders, anxiety disorders, depressive disorders, psychotic disorders, developmental disorders in children and adolescents, geriatric issues and problems as well. And so that training involves treating individuals with these mental health disorders, these populations, providing care for them and follow-up in different settings, sometimes in outpatient settings, sometimes in inpatient settings. And after completing that, I went into forensic psychiatry, and the difference there is that you learn how to apply your general understanding of psychiatric disorders in legal situations where a legal question is posed. So that might be in cases similar to the case today in civil lawsuits. It could also be involved in criminal cases around issues of mental state at the time of the offense and competence to stand trial.
And as part of those two areas of psychiatry, first we're talking general psychiatry and then forensic psychiatry, is there a board certification process?
Yes.
And are you board certified in general psychiatry?
I am.
And are you board certified in forensic psychiatry?
Yes.
And could you tell us just briefly what it means to be board certified in those fields?
Sure. What that means is that after your training, well, first you have to have all the requirements to be able to sit for a board examination, and that you've completed that successfully, and then you meet all of the standards and which is tested through examination to adequately go treat individuals in the community around mental health disorders. So there's a test you have to pass to be board certified, and there's a stamp of approval that is given to you in those specialties.
And since you received that stamp of approval, have you been applying those both general psychiatric and forensic psychiatric skills and lessons?
Oh, yes, every day.
And tell us about your clinical experience from the time of education to present.
Yes. So after my training in New York, I returned to Philadelphia, where I worked on the inpatient psychiatric unit at Thomas Jefferson University Hospital. I continued my work there, also in outpatient treatment for individuals who were not admitted to the hospital, but had mental health disorders and difficulties in the community. After that, I moved on to oversee the forensic psychiatry there's a forensic building program in Delaware, a maximum security forensic unit where individuals with criminal justice involvement they're admitted there on an inpatient basis. And so I provided clinical care for those individuals, treating those folks who were in the Department of Corrections and destabilized there and needed to be stabilized and returned to prison. Individuals who were found not competent to stand trial and then received treatment to restore their competence, and other individuals who were ordered there by the court because of mental health problems related to their case, making sure that those individuals will be able to be adequately treated and then transferred to prison to set out the rest of their services. As I continued on in terms of my clinical practice, I eventually made my way back to Pennsylvania from Delaware, where I became the statewide forensic director, overseeing the 2 state forensic hospitals in Pennsylvania. In that capacity, I handle complex psychiatric cases, overseeing the psychiatrists and physicians who treat those individuals. I also become involved in treatment interventions, reviewing those cases for efficacy of treatment, making recommendations, and then overseeing that treatment to be sure that those individuals were actually responding positively to the treatment.
And through that clinical practice, in addition to that, do you have any academic appointments presently?
Yes, I am. I've been appointed clinical professor of psychiatry at the University of Pennsylvania.
And can you just briefly tell us what that means in terms of your workload and balancing the other stuff we've talked about?
Sure. So my faculty appointment at the University of Pennsylvania allows me to train psychiatrists or doctors at various points in their training and career. So there might be medical students, it could be psychiatric residents, it also could be fellows, so folks who have completed their psychiatric training and then they move on for subspecialty training like I did in forensics. As a part of my work there, I'm also the director of the Forensic Psychiatry Fellowship Program at Penn, so I train psychiatrists to do the work that I'm doing today.
And Doctor, throughout your experience this is a presumption, but I want you to confirm it, that you've been exposed to post-traumatic stress disorder.
Yes, regularly.
And you've clinically diagnosed it in other people.
Yes,
correct?
and treated it, yes.
You've seen how it develops over time, chronic and acute.
Yes.
You've encountered anxiety disorders and depressive disorders.
Yes.
And you've encountered essentially these manifestations that we may be talking about today in Ms. Zwerner in other people throughout your both clinical, educational, and academic settings.
Yes, that's true.
I now tender Dr. Watson as an expert in the fields of general psychiatry and forensic psychiatry.
Any objection to that?
No objection.
All right, he'll be so qualified.
Dr. Watson, I'm going to ask you about the evaluation now. And as we go through it, I may be asking you for your findings or your opinions as we go through them. Will you agree only to offer those if you hold them within a reasonable degree of medical certainty?
Yes.
Okay. So, at some point in time, we contacted you in order to perform an evaluation of Ms. Zwerner, excuse me, is that right?
That's correct.
Can you walk us through the process that you followed in order to conduct the evaluation and then come to your findings that you're sharing with us today?
Yes. So the evaluation started out with a discussion with your office about the case in general, receiving a summary of the case and learning more about the complaint in the case. At that point, determining whether or not my expertise is something that I would be able to lend to the case in one way or the other after I learned more about the case. Once the decision was made that that would work, then we went about having me receive records related to Ms. Zwerner's history, her the incident that brings us here today, her medical records, and once I received those, then it was a matter of scheduling a meeting with Ms. Zwerner, and we were able to accomplish that. I met her on 2 occasions, one in person, and that was in my office in Pennsylvania in October, I want to say October 2024, and we met there for about 4 hours. And then I later saw Ms. Zwerner this summer at some point, I want to say maybe in July of 2025. And that was after receiving additional records that I did not have earlier on for issues that Ms. Zwerner had in between our evaluation times. After that, I prepared a report and then submitted it to your office.
Now, Dr. Watson, you mentioned previously that you had records that included medical records in her history.
Yes.
And when we say history, we're talking about before January 6, 2023.
That's correct, yes.
And then we're also talking about records since January 6, 2023.
That's correct.
And that included, her primary care doctor and some therapy records as well, correct?
Yes.
And you used those to gather information, and then you sat down with Ms. Zwerner, as you talked about.
That's correct.
What's the importance or significance of actually sitting down with somebody when you're performing a psychiatric evaluation of them?
Well, it's important to sit down with the individual if you are planning on reaching a diagnosis for that individual. And so reviewing the records alone is not sufficient. Sitting with an individual to evaluate them and ask them about their experiences, their symptoms, and observing their behaviors and their description of those experiences is important objective information. So part of the psychiatric examination is to observe the individual as they are sharing information about their symptoms. And the longer that you have with the individual to be able to do that, the better. And so with that, matching up whether or not what you are seeing in person and what they report to you in person is consistent with what you find in the records. And so that's why it becomes important.
And doctor, when you are going through this evaluation process for Ms. Zwerner, when you came to your final conclusions and opinions, did you have enough materials and information for you to make that clinical finding,
Yes.
that diagnosis?
Yes.
And can you share with us first what the diagnosis is, and then we'll break that down and explain how and why we got there?
Yes. The diagnosis is post-traumatic stress disorder, as well as a history of a depressive disorder and history of anxiety disorder.
So when you say history, and we sort of called on that word a little bit before, is part of your evaluation to try and determine whether somebody has had any experience in their life before the, what we'll call incident event?
Yes.
And why is that important?
Well, whenever conducting any psychiatric examination, you have to have a life course to understand where the person is today. And so to simply start off with where they are today is not sufficient. You have to start off way back to see what the source of the person's symptoms happens to be today. So the examination really begins with birth. The evaluation goes back gathering all sorts of information about developmental history, whether or not there have been traumatic experiences in that person's life up to that point, whether or not that person has a family history that makes them more prone because of genetic predisposition for certain mental health disorders, whether or not that individual has other factors that may be influencing their behaviors and the symptoms. For example, is that person using substances and addiction? Are those addiction actually more likely to be responsible for a person's symptoms than something that they're reporting? Has this person been abused in the past? How long did that abuse go? And so really diving into all of the things that might impact a person's today presentation becomes important. So looking at these historical factors gives us more ability to put into context what we see today.
And in your evaluation of Mrs. Warner's history, were there any findings or observations that became relevant to your ultimate conclusions?
Yes.
Can you explain what those were?
Sure. Well, so I will start with, if I'm thinking about well, first I will start with the very early positive factors in Miss Warner's life. And so she had a very positive upbringing, not very traumatic in terms of her history. When she was surrounded by a very positive family, loving family, supportive to her and her needs and encouraging her in terms of her career and focus. There were no issues around substance use disorders or other problematic childhood developmental disorders. So all of that becomes very important background. There was nothing in terms of growing up with domestic violence or sexual assaults, sexual abuse, no childhood neglect. So we first start with that backdrop. And then noting when there appeared to be maybe some difficulty, some emotional changes and such. And so the first time in terms of the records that I had available to me was somewhere around 2018 where she started to, I believe it was 2016, when she started to express to her family physician that she was at least experiencing some depressive symptoms. At that time, not anything that raised anything major, but she at that time had a transition in life, and that was she was in college, a freshman, dealing with the stresses of being a college student. At some point, though, later on, in 2018, the stress of college started to become a little bit more difficult, and her family physician treated her for depressive symptoms and anxiety symptoms, those symptoms being tied to the stress of her academic activities. And that was clear in the records. What was also clear in the records was that even though she was having those symptoms, she was able to continue to function and was functioning relatively well. She was pursuing her degree and completed that successfully. She was social actively. She was actively social, had friends, did things, exercised regularly. And so she was overall doing well. And was being managed well with her family physician in terms of her treatment. Unfortunately, she then had a traumatic experience, one that I think many of us could relate to, which was the loss of her father unexpectedly in 2020. And of course, that was a traumatic experience for her and her family, and there was a period of grief and some difficulty around that grief. And fortunately, she was able to receive some grief counseling to get her through that period of time. She was also able to continue to start her work as a teacher shortly thereafter. As a matter of fact, if I'm remembering correctly, I want to say that her father passed away in, I want to say July of 2020, I believe, that summer at least. And then she was starting work in that fall. And she was able to do that despite her difficulties around losing her father. And the medical records were very good in documenting her progress during that time, her treatment, and her eventual improvement around the stresses related to that. So those were the major events, including the stress of being a brand new teacher and starting career after college, those sort of things, until we come to January 6th of 2023. I should note, though, that despite some of the symptoms related to her depression and anxiety leading up to that point, and it was very clear in the medical records that she was doing well and had a lot of improvement leading up to January 6, 2023. The records show that she pretty much had mild, if any, symptoms and was doing well overall.
And in terms of the timeline as you've laid out, the loss of her father, 2020, this event, January of 2023, is it, in your review of the records, did it appear that the grief was under control?
Yes.
and that she was operating and going out and returning to her normal self, if we call it that way.
Well, yes. I mean, even with the grief of her father, closer to his death, she was still involved in social activities. She was still involved in family activities. She was still very active, was not withdrawn, not isolative. She was not overwhelmed to the point where she was impaired in her normal functioning at that point.
So I want to transition now and talk about how, if at all, in your findings that changed as a result of January 6, 2023. So we mentioned the diagnosis of post-traumatic stress disorder.
Yes.
And if we can just briefly explain to the jury so that it may help us frame it for them. The post-traumatic stress disorder is a condition that's explained in the DSM-5. Is that correct?
That's correct, yes.
Could you tell us briefly what the DSM-5 is, what that means?
Sure. So the DSM-5 stands for the Diagnostic and Statistical Manual of Mental Disorders. It's the 5th edition now, and there's a later text revision really refining the definitions around specific mental health disorders. And it is the primary text that mental health clinicians use to reach diagnoses, so that we are all understanding the same language when we meet a patient and we diagnose that patient. It guides our treatment approaches to make sure that we're able to select the proper treatment for the individual, given the collection of symptoms that they're exhibiting at the time. And so the DSM, for short, is really our guide to diagnosing and treating patients with mental health disorders.
And what I have on the screen for us to look at is different letters. So we have post-traumatic stress disorder, A, B, C, D, E, and F. Are you able to see that?
Yes.
And I've given them little subheadings. Are these subheadings sort of part, I know they're simplifications, but are they simplifications of what that guide tells you as a clinician in the field of psychiatry to look for if and when diagnosing post-traumatic stress disorder?
Yes, although there's one missing, and we can talk about that.
Go ahead and let's put it on there before I forget about it. What is that one?
All right, so let's see. We can put it between C and D, avoidance. So we can call it whatever, C and a half or something you want to call it. So that would be negative alterations in mood and cognition. And then D technically would be what we call alterations in arousal and reactivity.
All right. With those tweaks, is this a simplification of the guide that you walked through in this instance as it relates to Ms. Zwerner's diagnosis of post-traumatic stress disorder?
Yes.
So talk to us about subsection A, traumatic event.
Yes, so the DSM, the criteria for post-traumatic stress disorder, requires that there is exposure. A person is exposed to actual or threatened death, serious injury, or sexual violence.
And in your evaluation of Ms. Zwerner, obviously we've talked about the facts of this case, but was there any reporting from her to you about her perceived risk of death?
Yes.
Can you tell us about that?
Well, she believed that she was dying, that someone was trying to kill her, and that they had successfully made that attempt, and she was attempting to survive, and she was bleeding and had difficulty breathing and panicking, believing that that individual was following her and was going to finish the job.
And in your review of her evaluation, does that check the box, so to speak, as it relates to the traumatic event?
Absolutely. It's almost, I mean, that's sort of a classic trauma.
So let's talk then about the re-experiencing or re-experienced. Tell us what that means in your world.
Sure. So what that means is that a person is what we call in DSM intrusive symptoms. So either there are distressing memories, distressing nightmares, distressing re-experiencing of events that related to the trauma that are intrusive. In other words, you're not actively thinking about the trauma, but it inserts itself, it pushes itself into your consciousness, even when you don't want it to, right? And so this is when you hear folks say, they've suffered flashbacks, for example, or they say that they had nightmares about the event or something similar to the event, right, in which they are in danger, and sometimes it is very specific and a reminder very clearly of imagery around the trauma itself. Sometimes it's not that. There are times where a person is in a nightmare where they are fearing their death or being attacked, and they're running and they're trying to escape something, and maybe it's not as clear. But the clear piece about this is that those nightmares happen, or those intrusive events happen after the trauma. You don't expect to see those sort of things before. And so you look and say, okay, after the trauma, this person is suddenly having these distressing nightmares in which they're in danger. And they're related and associated with the traumatic event itself.
And in your evaluation of Ms. Zwerner, did she report having nightmares?
Yes, she did.
And you talked about some of these nightmares being specific and some of them being more general.
Yes.
How would you categorize Ms. Zwerner's reports of her own nightmares?
Her reports were more specific, yes. So she had some dreams that were related to being, feeling like she was not safe. But generally, she had dreams about the student who shot her. She had dreams about the student's expression, facial expression, as a blank stare as he pulled the trigger. She had dreams about being in the school and the student being there. No one else is in the school, and the student following her, and she tries to escape, and then he finds her in a closet somewhere while she was hiding. She had another nightmare about another student who somehow, I think, was involved in one way or the other, but that student was harmed, and so this gruesome sort of imagery in which that student was found dead. And so her sleep had been disturbed by the pressing.
It's been affected drastically.
Distress.
That's terrible.
This trauma, or dealing with this trauma, that it pushes into even her dreams, and this is how we understand those nightmares.
And you mentioned earlier.
So just by the sounds of that, it sounds to me like she didn't quit teaching by choice, per se. She couldn't go back to teaching. She wouldn't be able to. I mean, can you imagine trying to work around children like that? I mean, she's probably scared of young children at this point. You know, I mean, could you imagine a 6-year-old child shooting you and having no trust? I mean, that's crazy. That could be, I mean, that's very traumatic, let alone an adult shooting you.
Earlier that your more recent discussion and sit down with Ms. Zwerner was in July of this year.
Yes.
And in July of this year, did she report whether those nightmares were still occurring?
Yes. I want to say that I think she said something along the lines of over the previous few months, she had at least 3 of those nightmares.
And when we talk about having intrusive symptoms and these coming to her in the night, and you mentioned intrusive is, even when you don't want them to.
Right. When something's your attention's not necessarily distracted. You could be driving down the road, and then this comes to you, and you're re-experiencing having a memory of this traumatic event, and usually with that comes a physiologic response. Right, a person starts to feel some degree of heightened anxiety. Heart might be racing. In Ms. Werner's case, she felt shallow breathing, body heaviness, and racing, heart racing and palpitations. These are the sort of things that you would expect.
And we talked earlier in your roadmap about the brain and body.
Yes.
Is this physiological response part of what happens when you have a condition like post-traumatic stress disorder?
Yes. We tend to have this artificial division between the brain and the body. It's all connected, right? So all of us are sitting right here. Our brain right now is keeping us alive, right? You're not thinking about your heart beating, but guess what? Your brain is making it happen, right? You're listening to me right now. There are all sorts of things that you might feel. Something that if you have your own traumatic experiences, might remind you of something. You might feel a low anxiety and such, right? Viscerally, you can feel it. It's not just thoughts. And so for individuals who are suffering from severe post-traumatic stress disorder, this becomes a real thing that can even be paralyzing for individuals. So it feels like they have to freeze. They can't move. They're in such fear state, right? So even if rationally they say, I'm not in danger right now, I can continue, the body might respond as if there is a real imminent threat, and then your body goes into a fear response physiologically. It prepares for danger. And so this is where we talk about the shallow breathing, the heart racing, and she might be just sitting watching television and this comes to her.
And that may be, you tell me if I'm right or wrong, but is that what leads us, and let me start here, re-experiencing that in the guidebook was found?
Intrusive, yes.
Found in your evaluation?
Yes.
And when we talk about how these things can be sometimes even paralyzing, does that relate at all to the next finding as it relates to avoidance?
Yes. So because of the re-experiencing, there are times where you might not be just sitting and not doing anything, and then it comes to you. And these negative memories related to the trauma come to you. But there are situations in which they may be triggered by specific reminders in your environment. And then it takes you to those intrusive thoughts, right? So you're sitting and you have this trigger that is a reminder. Let's just say for Ms. Zwerner, one of her triggers happens to be seeing individuals with their hands in their pocket, right? What are their hands doing in their pocket? Well, the last time she was in danger, real danger, and her life was threatened, someone held their hands in their pocket for a very long time before she was shot. And so seeing individuals in the community or large crowds or something like this may be triggering to the point that you have a re-experiencing of these this earlier traumatic event. And so to avoid that, as we all try to do, avoiding things that make us feel uncomfortable or distress us, then for Ms. Zwerner, the avoidance symptoms will be, I'm going to avoid those things that will cause me psychological distress. So I'm going to avoid schools. I'm going to avoid watching television shows that have classroom settings. I'm going to avoid looking at news reports of school shootings. I'm going to avoid crowds. I'm going to avoid people who have their hands in their pockets. And so those avoidance behaviors, anything that an individual does, I'm not going to go anywhere near the school where I was once upon a time shot, right? All of those things would meet that criterion for avoidance.
And so in your evaluation, Dr. Watson, did Ms. Zwerner meet that criterion of avoidance?
Definitely, yes.
Now, C2, one I forgot, negative alterations in mood and cognition. Tell us what that means and how you observed that appearing in Ms. Zwerner.
Yes, and these two, the negative alteration in mood and cognition, and increased arousal, the alterations in arousal and reactivity, they're very important, especially in Ms. Zwerner's case, when we talk about her history. So apart from those first two criteria in the DSM, they are very clearly connected to and associated with the traumatic event itself.
And when we say first two, you're talking
right.
re-experience.
B and C, yes, exactly. So those experiences occur after the event. The negative alterations in mood and cognition and increased arousal, the alterations in arousal and reactivity, recognizes the criteria for DSM, recognizes that a person might have already had issues with depression or anxiety earlier on. And so the wording of it within the DSM goes something like the person now has increased or negative alterations in mood, like depression or anxiety or negative thinking, that begins or worsens after the event. So you don't need to be clean before you reach this particular diagnosis. When I say clean, I mean no history of mood problems. It means that those symptoms actually worsen, if you had them, after the fact. And that would include depression, that would include anxiety symptoms, that would also include ideas and thoughts about oneself and their self-worth, their self-esteem, a sense of control or losing control in one's life. All of those things would fall into C2.
And so when we're talking about C2 and D, if I were to say, let's think about it as a small campfire that me and Keith could keep us warm, and that's life's experiences before January 6th. How would you describe what happened on January 6th as it relates to that campfire?
Well, that would be like throwing gasoline on top of the fire, right? So you have a campfire that's there, maybe the campfire is under control, then someone comes along and they throw, gasoline on it, and gasoline just splashes everywhere. So now you have the fire that is spread and burning in areas that it didn't burn before. So not only is the flame itself more intense, it becomes out of control. It starts to burn areas that were not burnt before, and it makes it more difficult for that individual who is experiencing that gasoline douse to get those feelings under control.
In your evaluations of Ms. Zwerner, did she report to you any feelings of feeling like life was out of control?
Yes, Yes, as a matter of fact, that was one of the things for her that really increased her depressive symptoms, right? The idea that there was uncertainty now in her life. She doesn't know where her life is going. And, you know, there are times when we talk about the alterations in cognition, that would fall into that idea of a person's future, right? They don't know what's going to happen. Once upon a time, they could see. They could have ideas about what's going to happen. Now, they don't even trust their own thinking about what their future will hold because this traumatic experience has happened to them.
And when we talk about areas of the forest that are burnt, right, areas of their life that are burnt that weren't burnt before, can you talk to us about what those areas in your observation are in Ms. Zwerner's life now that before January 6, 2023 were untouched, unaffected?
Oh, yeah, sure. So right off, socially, she has lost the sense of being safe, something that she had not experienced before, even when she was feeling depressed or anxious. She was anxious about certain things. She was anxious about stress here or at work or at school or something like this. But she felt safe. She felt safe to go to events where other people were. She felt safe to be around other people. She now doesn't want to go anywhere. She became socially withdrawn and isolated, pulled away from friends, didn't want to be in public as much, and felt fear in places that she didn't feel fear before, like the grocery store, feeling that she has to bring family members or friends along with her, so as support. The other piece was that her occupational functioning. This event had made her deal with such overwhelming distress about being in the classroom that she doesn't feel that she can go back to a classroom setting. She doesn't feel safe there, right? And one can imagine why, right? You're sitting in a classroom teaching, first graders. The last thing you're expecting is one of the first graders is going to pull out a gun and try to kill you. And so it makes sense that, especially when we go to the earlier criterion, that she will want to avoid such situations. Well, because she wants to avoid something that's so distressful, like the setting in which she was almost killed, then in her case, it requires her not to return to the classroom and lose her occupational functioning. She can't function in the way that she did once upon a time when she had depression before she could go to work, and she did go to work, and she was successful at it.
And when you talk about these alterations in mood and avoidance, if we heard that Ms. Zwerner went to a concert with family, are you saying that this means someone shouldn't go and shouldn't be able to go at all? Or is it just that when they go, something happens to them?
Sure. So what that means is that there will be times where a person might be able to do something, but they're experiencing something that they would not have experienced before, right? So number one, if she has to go with family and friends for support, that's something that she didn't feel like she needed before. She needed that support. She is not going back to a concert in the way that she once upon a time went to a concert. Now she is experiencing symptoms related to hyper arousal, where you become more hypervigilant. You're feeling as if you are in danger, always looking, always watching, always scanning whether or not an individual near you might cause some harm. Why is this person looking different than the rest? Now you're keying in on one person in the crowd and watching that person instead of enjoying the concert. You're wondering whether or not this person is doing a little bit too much. Now I'm distracted thinking more about these negative things than enjoying whoever it is that I've come to see. And of course, depending on where a person is in treatment, that's a good thing. As a clinician, I want my patients to try. I want my patients to see if they can. I want them to try to get better, to see and test the bounds, because that means they want to get back to their lives. They don't want to just sit home and sit in their symptoms and cut their lives off. When I met with Ms. Zwerner, it was very clear to me that she wanted to get to a place of normalcy again, where she can go to concerts and such. So the only way to be able to see how she's able to do that is to be able to, have these experiences to try.
And in your review and evaluation of Ms. Zwerner, these two criterion that we've identified as C2 and D, were those met?
Yes.
My understanding of duration is that it's maybe not a whole different thing, but it talks about how long these different symptoms are going on. Is that fair?
That's correct, yes.
So tell us about how duration appeared in your evaluation of Ms. Zwerner.
Yes. So in order to meet the criteria for post-traumatic stress disorder, the symptoms, the other criteria that we talked about, have to be present for at least a month. Now, this is actually a very important point now that I think about it, is that within days of the event of her shooting, she was seen by psychiatry in Riverside Regional Medical Center through a psychiatric consultation within days. And that psychiatrist evaluated her and listed right away many of the symptoms that we're talking about here today. She was experiencing almost immediately. But the problem, it's not a problem. The proper diagnosis was reached at that point. And that proper diagnosis was acute stress disorder. Because if it's under 1 month, you cannot officially diagnose it as post-traumatic stress disorder. Even though all of the symptoms related to a post-traumatic stress reaction happens to be there, you have to be able to meet that the letter, the criterion E for duration. So she was already recognized as on her way to developing post-traumatic stress disorder at that early point. And because of that, that doctor in those records made recommendations for future treatment in PTSD because it was anticipated that she would in fact develop it.
And in your review of the records, has Mrs. Zwerner been diligent in trying to get help for what's happening?
Yes, as a matter of fact, I've been very impressed. She not only has been seeking and continue to seek treatment with her family physician, who she had been receiving treatment. I mean, he was a family physician for a very long time, so knew her when she was having her earlier depressive symptoms to now. And so continue with that. Also continue with, I want to say the therapists are through Abundant Life Partners, I think is what it is, where she's seen 2 therapists there and has received treatment interventions, not only in medication management, but also in what we call cognitive behavioral therapy, a psychotherapy counseling intervention, and also in eye movement desensitization reprocessing treatment, right? These are specifically designed to treat individuals with PTSD.
And I don't want to use the word despite, but even with those efforts that she has undergone in the last 2.5 years, when you saw her in July, had her symptoms, or were her symptoms still persisting as it relates to post-traumatic stress disorder?
Yes, they were still persisting, yes.
And was she still under medication management at that time?
Yes.
And do you recall what medication management she was under at that time?
I don't recall specifically. I do know that she was receiving a antidepressant medication and an anti-anxiety medication, I'm forgetting which one, along with continuing her psychotherapy.
And when does that, I'll ask it this way, your review and what we've talked about so far, does that establish in your mind, in your opinion, the duration requirements for post-traumatic stress disorder?
Yes, it does.
And then tell us what clinically significant distress or impairment refers to.
Yes, so the last piece there is important because if a person has all of these symptoms and they don't impact them in their functioning, then it is more difficult for you to say, okay, this is a person who's suffering from a disorder. A disorder requires that there is some impairment of normal functioning. And so the criterion F points to how a person might subjectively experience significant distress to the point that they're having difficulty in their own emotional states day to day. And that might also spill out into very clear objective loss of functioning in important areas in their life, like work, like socially, family, friends, academically, and such. So we look for an individual to have clinically significant impairment in those areas.
And when we talk about clinically significant impairment, sometimes folks think of being numb to experiences. Have you ever heard that phrase?
Yes.
And can you tell us whether that is something that Ms. Zwerner expressed to you and what significance that has clinically?
Yes. There are times where, associated with PTSD, a person can experience psychological numbness during times when they should really feel something, right? So some folks would think that's counterintuitive, but actually it is a defense mechanism in the sense where a person's emotional state, where it has been riding high for so long because you feel like you're in danger, in order to try to control it to some degree, you have to be able to feel numb as a protective mechanism. Right? So that happens sometimes. Now, this experience causes some confusion for individuals who have it, right? They don't understand why they are feeling nothing right now in a particular situation. And then there are other times where they're feeling too much and they don't want to feel too much. They don't want to feel afraid. They want to be able to go to the grocery store and not to take someone with them, those sort of things. So it could be very confusing. This is why, psychotherapy becomes important to help folks process this mental health disorder.
And as a clinician, when somebody's reporting, and we've talked about some different topics here, like being disassociated or feeling nothing, how does that appear from a clinician standpoint, and how does that differ potentially from what an average person may expect?
Sure. As a clinician, if I'm sitting with someone who is experiencing that, I'm looking for emotional flattening, right? I'm looking for the lack of expression, a lack of response, a disconnect as I'm speaking with an individual about something that might be, you would expect to elicit some sort of emotional response to, right? You can think of it as a person who has been abused for many, many years, and then they see a violent act, and then they don't even react, right? And the rest of us will say, hey, well, what's going on? We need to move. But that person who has been abused chronically, they don't react in the same way. They don't view violence in the same way. There's a numbing to things, and that's abnormal.
And we've talked about these clinically significant findings or distress and impairment. Where, if anywhere, within the PTSD evaluation does suicidal ideation come into the play, and was that involved in your evaluation of Ms. Zwerner?
Yes, so that would be, yes, there was a point where Ms. Zwerner experienced passive suicidal thoughts because of the stress that she was feeling on a daily basis. That happened after the January 6th situation, shooting. And she had not experienced that before, passive suicidal thoughts. And at least in the records, there's none of that in there until after. That falls in the criteria under negative alterations in mood and cognition.
And so when we evaluate F, was that met in your evaluation of Ms. Zwerner as well?
Yes.
I want to talk to you on our final sort of stop here about the future.
Yes.
Is there, and we talked a little bit about this in terms of duration and the persistence of her symptoms as of July of this year. Tell us, as we sit here 2.5 years after this incident, what that indicates to you of her evaluation and what that means for her prognosis into the future.
Yes. I am concerned as a clinician because despite significant efforts in terms of treatment, the symptoms persist. As a clinician, I don't know where Ms. Zwerner would be without the treatment that she's receiving now, right? If you understand my point, is that if she was not receiving the treatment that she has received, she would not be in good shape.
And keep going.
One of the very important pieces about Ms. Zwerner's case is that she has everyday reminders, permanent physical scars, reminding her of that particular day. So it's not just that she has psychological scars that she's dealing with from the trauma. She has impairment in her normal functioning, right? She had injury to her hand that has changed the way that she uses her body. That has caused her to have multiple surgeries because she continues to have complications around that. She has physical scars that she sees and she will see into the future when she changes her clothing or something along these lines, right? If she's going to the beach, I would imagine, she might be mindful or thinking about that. And then lasting, she still has a bullet fragment that she knows is in her body, right? That was not there before, right? So that's not going to go away. That's there now. That's something that was not there before. So now these physical, real physical scars and impairment and functioning, they're constant reminders. That's the first thing. The other piece is this, is that she's still having nightmares. So something that's important about nightmares is this. All of us, when we have difficult times with stress, anxiety, depression, some of us will try to escape, right? Escape to, you know what, I need to go to sleep. Hopefully tomorrow will be a better day. I can sleep this off. I don't have to think about it, right? So some of us look to that as sort of a refuge away from emotional stress, emotional difficulties and such, for some relief there. when a person continues to have nightmares, what that tells me is that that person continues to struggle with such difficulty consciously related to that traumatic event that they can't even escape during sleep, that their unconscious presses into their sleep and then influences their dreams, right? We don't have control of our dreams, when we're sleeping. And so when you have a disturbance of sleep, when you have these distressing nightmares and you wake up and you have this physiological responses, well, then you don't get refuge. And so, I hope that will continue treatment. I hope with, of course, with her, continue, and it sounds like she's been, from what I could see in the records, very active in her treatment and trying to get to a better place. But yes, I'm concerned. I'm concerned about that.
And in your professional opinion, is this post-traumatic stress disorder a chronic condition that will last throughout her lifetime?
Yes. I mean, this is, it's hard for folks to be able to understand who might not have gone through that particular traumatic experience, right? So all of us will be able to understand the loss of a parent, especially if we had a close relationship with our parents, how difficult that might be. But not all of us have had the experience of someone trying to kill us and then surviving that, right? And so it becomes a very unique situation for that individual. It's just a very significant traumatic experience.
It'll be with her as long as the fragment's with her.
Yes.
Doctor, are all the opinions that you've testified to today held within a reasonable degree of medical certainty?
Yes.
Thank you for your time.
Thank you.
Cross-examination?
Hello, Dr. Watson. We meet again.
Yes, good morning.
Good morning. Just to be clear, you told the jury you were hired by Ms. Werner's lawyers, correct?
That is correct.
And the sole purpose of your evaluation of Ms. Werner is in connection with her claimed damages in this lawsuit.
That's correct.
And you talked about being a clinician, correct?
Yes.
But you are not a clinician to Ms. Werner.
That's correct.
You're not providing mental health treatment to Ms. Werner.
No.
In fact, you don't have an outpatient practice doing or providing mental health treatment to individuals in the community.
No outpatient practice at this point. I have in the past.
Understood. And here, in deriving your opinions, you relied primarily on what Ms. Werner was willing to tell you, correct?
No.
You are you talking about the records that you reviewed?
Yes.
But those would be her self-reports in the records, what
No.
she was willing to tell other providers.
No. So, for example, in the medical records, it shows that she was shot. It shows her physical damages. That wouldn't be her self-report. That she was shot.
Understood. Understood, Dr. Watson.
and-
I'm talking about her narrative about her mental health damages. That would be self-report from Ms. Werner when you met with her, correct?
Oh yes, yes.
And then when you're looking at her records from other providers, it's what her self-report to those providers is.
Self-report plus their observations.
And you did not, let me strike that. You told the jury you met with Mrs. Werner twice, right?
Yes,
One was in person.
Yes.
And that was October 14, 2024.
that's correct.
And then you did a Teams conference in July 16, 2024.
That's right.
And that's the total encounters you've had with Ms.
Total of 6 hours. Yes.
6 hours. You did not conduct any collateral interviews, correct?
No,
And
they were not
tell the jury
necessary.
what a collateral interview is.
The collateral interviews would be reaching out to family members, gathering additional information from them about history and about current symptoms and current functioning. But it wasn't necessary in this case.
Based on your opinion. Wasn't necessary.
Based on practice, we have I had ample medical records. I have medical records dating back from with our family physicians that track. I mean, as a matter of fact, it was great because I was able to really track through her medical records years and years before this event, all the way up to her symptoms after. And so talking with the family really would have been adding expense that was not necessary in this case.
And you talk about reviewing the primary care records,
Yes.
but you didn't review her counseling records prior to January 8, 2023.
No, those were not. It wasn't necessary for me to go backwards because those records that I saw after also referenced her early treatment. So the changes in diagnoses were clear because the clinicians in at Abundant Life talked about her previous condition and then talked about her change in diagnoses.
But you did not review the Abundant Life Partners record prior to January 8, 2023.
No.
You did not review.
I did not
And
see
there's ample records prior to this event that are in the Abundant Life health records, correct?
Well, I don't know because I haven't seen those, but I saw all of her psychiatric treatment through her family practice well before that. So that would have covered that time period.
telling the jury that the primary care records would cover her treatment by her mental health providers?
Yes, because they provided mental health treatment to her through West Point Family Practice. She was receiving all her psychiatric medications through them. She was reporting all of her anxiety. All of that was discussed in there. There was a narrative. There was information about her father and what happened with her father. It's all in the West Point Family Practice records.
From the perspective of the West Point Family Practice providers?
From the perspective of a psychiatrist that does this on a regular basis. All the information that I would need to reach a clinical diagnosis, I had all the information I needed from the clinical providers who were treating a specific symptoms. West Point had all that information. From my standpoint as a clinician and what I need to reach a diagnosis, I had all the information I needed there.
I understand that, Dr. Watson, but you did not review the mental health records from Abundant Life prior to January 8, 2023.
That's correct.
That's correct. You did not conduct any psychological testing?
No, that wasn't necessary.
Okay. And you did not refer Ms. Werner for psychological testing, correct?
Again, not necessary. That's correct.
Did not look at any of her social media reports?
Social media?
Any social media postings or?
No social media.
Did not interview her coworkers?
It depends on, well, I didn't interview them directly. I had access to depositions.
And you did not observe her functioning in the community?
No, personally, no.
Didn't interview any of her therapists or healthcare providers?
No, not necessary.
Did not interview family or friends who were familiar with her functioning in the community?
No.
Did not review any of her education and training records at the cosmetology school that she attended after the shooting?
I don't believe I had those in the records. I don't recall that.
Did you ever seek verification of her self-report about not using recreational drugs?
That was replete there was plenty of information about that in her medical records throughout. All of it was consistent. Everything that she said to me was consistent in medical records going way back until 2016.
But those were her self-reports.
Right, but there was no testing from any clinician, from the family practice or anything that indicated that she has ever had any substance use problems, that there was any concern, that there was any need to treatment, that there was any urine, drug, or blood tests related to it. That's just not in the records.
I understand that, but I'm asking you, did you seek verification about her self-report about whether she had used recreational drugs?
Seek verification other than the medical records?
Yes.
Do you mean, I don't know what you mean verification.
Did you review any text messages?
Whose text messages?
Ms. Werner's text messages.
Text messages about whether or not she uses drugs?
Yes.
No, I didn't.
And you told the jury about Ms. Werner having a dream about a student on the day of shooting other than the student who shot her, correct?
Yes.
Did you ever gather more details about that student to determine whether he was the student who on the day in question told her that JT had a gun?
I'm not following your question.
You talked about the student who she mentioned dreaming about on the day of the shooting other than JT.
Okay.
And I'm asking you, did you gather any additional details to determine whether he was the student who had told her earlier in the day that JT had a gun?
No.
And you never interviewed her boyfriend even though they lived together?
That's correct.
And he came to your office in Pennsylvania the first time when you met her in person, you didn't interview him?
No.
Did you ever review the school security video in the moments immediately after the shooting?
No.
And you never reviewed, again, any text messages or social media postings?
That's correct.
And you've not met with Ms. Werner in person since October 15, 2024?
That's correct.
And you've not reviewed any of her counseling records since June 10, 2025, is that correct?
Whatever is there in my report. So I think that was the last set before my last meeting with Ms. Zwerner.
And you addressed the tragic loss of her father, correct?
Yes.
And that was something that you said she had worked through?
Yes.
Okay. And that was, but you didn't review the Abundant Life Partners records prior to January 8, 2023, correct?
Objection asked and answered.
Do you have any response to that?
I can try to rephrase.
All right,
So
it's sustained.
you did not see in other records where she had been treated for PTSD symptoms related to her father's tragic death?
No, I didn't see anything like that.
Didn't see that because you didn't review the Abundant Life records.
Sustained.
And you talk about Ms. Werner being reluctant to be in the public or having a public presence, correct?
That's correct.
But did you review any of her media reports or media interviews that she's giving?
No.
And that would be a public presence. Would you agree? If someone's on the
That she's
Today Show,
appearing in public?
public presence.
So I think that we might, I'm not sure what the circumstances were and what sort of measures were put in place for her to make that appearance.
Did you review the GoFundMe site created by her sister?
No.
And that putting the story out that way?
No.
That's all I have, Dr. Watson. Thank you.
Any regret?
One clarifying. There was a question earlier from Ms. Douglas about meeting on Teams in July of 2024. That meeting actually took place July 2025.
That's correct. Thank you.
That's all I have, Your Honor. Thank you.
Okay. All right, may he be excused?
You may be.
All right, you are released from your subpoena. Thank you for coming and testifying today. All right, good time to take a short break. All right, and who's going to be your next witness?
It'll be Ms. Zwerner.
Okay. All right, we'll go ahead and take a 15-minute recess, and then we will bring the jury in.
Please stand for the jury. And jurors in the box.
You may be seated. All right, ladies and gentlemen of the jury, we had to handle some matters. Those are taken care of, and we are now ready to proceed with the plaintiff's case. Call your next witness.
Abigail Zwerner, Your Honor.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Yes. Thank you, Your Honor. And Abby, can you tell the jury your name, please?
My name is Abigail Zwerner.
And Abby, how are you feeling right now?
I think nervous is a big one. Nervous, anxious, a lot.
And Abby, the jury's already heard a little bit about yourself from your mother and your sister. So just tell the jury, how long were you a teacher?
About 2.5 years.
And where did you teach at during that 2.5-year period?
Richneck Elementary.
Tell the jury what grades you taught.
I came into 4th grade, my first year of teaching. That was when we had the virtual hybrid year. And then the following 2 years, I taught 1st grade, all at Richneck.
And how did you enjoy teaching?
I liked it. I do remember it was stressful a lot of times. Being a new teacher, a lot of new experiences, a lot of ups and downs, I remember. Yeah.
And now, Abby, I'm just going to ask you a few questions about January 6, 2023, okay?
Okay.
So tell the jury, when on that day did you first hear about JT might have a gun?
It was before recess.
And do you remember who told you that?
Amy Kovac.
And when Amy Kovac told you that, why did you not go to Dr. Parker?
I knew that she was going to tell Dr. Parker.
Did Amy tell you she was going to tell Dr. Parker?
Yes, she told me that she was going to tell Dr. Parker.
And did Amy tell you that 2 girls had advised her of the fact that JT might have a firearm?
Yes.
Do you know who the 2 girls were?
I did not.
So she didn't even tell you which kids in the class had told her that?
She did not tell me.
And no other kids told you?
No.
Okay. So you heard it from Amy, and Amy said she was going to tell Dr. Parker at that time?
Yes.
Were you told to keep an eye on JT by Amy?
Yes.
And is that why you were texting and communicating with Amy during recess?
Yes.
And Is that why you texted Amy about what you observed JT doing before recess?
Yes, because I knew that once Amy had informed me of the information that the students had told her, I knew that Amy was going to then relay the information to Dr. Parker.
And again, no one else had told you anything about a gun besides Amy?
Correct.
And, Your Honor, I would like to publish and pull back up what's already been submitted as Plaintiff's Exhibit 3, if that's okay with Your Honor.
Which is that?
That is the picture yesterday of Abby wearing a shirt. Oh, 90C. Is it 90C? I'm being corrected that it's Plaintiff's Exhibit 90C, Judge.
Okay. Any objection to that?
No objection.
Right. It's already been admitted, correct?
Yes, it's already been
All right,
admitted,
got
Your
it.
Honor.
Yep.
And Abby, do you recognize that photo? It's on the screen in front of you?
Yes.
And what year is that from? Do you know?
I have slightly orange hair. Looks like it's washed out, so it would have been the 2022-2023 school year.
Okay. So you're in your first grade classroom, room 11?
Yes.
And if we can zoom in on the orange sheets that are behind your head, do you see those?
Yes, I do.
Can you tell the jury what is that?
That would be our handbook, our school's handbook. I believe it was titled the Crisis Management Plan. I may be wrong on the title of it, but it was the Tier 1, Tier 2, Tier 3.
So that's the school, that's a handbook that you would reference?
Yes.
And why would you reference that sheet?
For the behaviors, it was like a left and right side.
And why would you look at that, the left and right side?
The like possible displayed behaviors on the left, and then on the right side, actions to take as a teacher.
And Reed, if we can only display to council, please, Exhibit 108, and it would be date stamp 9074 and 9075. Thank you. And Abby, do you see two documents in front of you?
Yes.
Do you recognize those two documents?
Yes.
And what are those two documents in front of you?
The on the left and the right side, it looks like the three. I don't know how to explain it. It's like the combined on the one sheet of paper that I had on the orange sheet of paper, like the level 1 behaviors, and then on the right side of the screen, level 2, and then level 3 behaviors. I had that all on one sheet of paper, the orange paper on the wall.
So the exhibit that we just showed to the jury, the box that you had of the 3 tiers, is from this document?
Yes.
Your Honor, at this time, I would move to submit this document as Plaintiff's 108, and we would mark it as 108.
All right, any objection?
Object, Your Honor. This witness can't authenticate. This is a handbook from Richneck Elementary. She's not an employee. She can't authenticate the document.
No, she's identified it. That's overruled.
Thank you, Your Honor.
All right, so admitted.
Thank you.
Plaintiff's 108.
May I have permission to publish it to the jury, please?
You may.
Thank you. And Abby, we're now sharing this with the jury, so can you tell them again where this Section 3 came from?
The Richneck Elementary School handbook.
And the chart that the jury is seeing on those 2 pages, is that what was combined into one chart in the photo that we had just previously showed the jury?
Yes.
And can we publish to the jury Exhibit 90C? Is it 90C? Thank you. And if we can zoom in, that orange piece of paper behind your head is what has the chart on it with the Tier 1, Tier 2, and Tier 3 behavior.
Yes.
And then if we can zoom in on the Level 3 behaviors on the second part of the screen, please read. And do you see what's on the screen at this time?
Yes. At the top it says level 3 behaviors immediately reported to the school security and/or an administrator.
And in the student behaviors, is there a possession of a weapon listed?
Possession of a weapon.
And then next steps, that's for the administrator to do, correct? That was your understanding?
Next steps.
And if we, on this date, Amy Kovac went and reported it to Dr. Parker, correct?
Yes.
Thank you. And we can take that down from the screen now. Thank you, Reed. So Abby, now tell the jury, what did you see right before you were shot that day on January 6, 2023?
The moment went by very fast. I remember Dr. Watson touched on it briefly earlier. The look on the student's face is a large memory that I have. I do remember it was like a very blank look, but it wasn't a blank look at all on his face.
And is that why you lifted your hand? Did you know what was about to happen?
Yes. Yep.
And what is the last thing you remember that day at the school?
The last thing I remember at the school. Obvious, I thought I was dying. I thought I had died. I thought I was either on my way to heaven or in heaven, but then it all got black, and so I then thought I wasn't going there, and then my next memory is I see two coworkers around me, and I process that I'm hurt, and they're putting pressure on where I'm hurt.
And Abby, can you describe for the jury a little bit about how you're still feeling physically and emotionally? I know that's a big question.
Physically.
Can you describe how it is with your left hand still? The things you can and can't do, even to this day? So Abby, can you tell the jury, when we have lunch together, are you able to open your potato chips, or do I open your potato chips for you?
I asked you, we catered sandwiches in a box, and a small bag of chips and cookies were catered, and I was trying to open the bag of chips on my own multiple times, different ways, trying to hold it different ways, and I eventually asked you to open it. It's the same thing with water bottles. Overall, I would say I do struggle with doing things.
And for example, we heard from your sister yesterday, and she described a change in your relationship with not only her, but friends. Are you able to explain a little bit to the jury about how you feel maybe those relationships have been changed?
The best I can explain it, it's like I still feel connected and close, but it's also that feeling of distance, a little numbness, and it's like I know I trust the person I'm with, I love them, I know them, but there's something that's just different. I can't necessarily put it into words.
And what about, we heard from your mother about the movie Hamilton. You were planning to go to it that day. What happened that changed your mind when you had already purchased the tickets and made those plans?
It was a Saturday. I remember waking up. I woke up and I remembered that there was a scene where two characters had dueled with firearms, and when we had started making the plans to see the movie, when the Saturday was coming up to see the movie, it just never flew through my mind. I had seen Hamilton before, but for some reason when I woke up that day to go see the movie, it just flew right into my head, and just overwhelming sense of, I felt like everything just came over my body. And I remember I called my mom. I don't remember if I was crying on the phone to her. I don't remember if it was afterwards, but I remember crying a lot. And I remember that afterwards, they were asking me what else would I want to do instead that day. So, okay, we can't go to the movies. What do you want to do instead? Where else would you want to go instead? And I remember telling them nowhere. Like, I can't go anywhere. I just want to stay home. I'm not going anywhere today. I can't. And I remember that it was my mom and my sister. So it wasn't just my mom and I planning to go. It was my mom, my sister, and I. All three of us planning to go. And then they proposed to come over to my place. And even that still, I didn't want. Like, no. Like, just leave me alone. I don't want to go anywhere. I don't want to see anyone. I don't want to. No. To my mom and my sister.
Well, Abby, I know this has been difficult for you, so that's all the questions I have. I appreciate it, okay? Thank you. But stay there. Maybe other questions.
Thank you. All right, cross-examination.
My course may take a little bit of time. I don't know if you're going to try to get through before lunch.
I'm sorry?
My course might take a little bit of time. Let's get it started.
Yep.
Ms. Zwerner, I have a few questions so that we can make sure the jury understands the whole picture. You've been working as a teacher for a few years at the time of the incident, is that correct?
Yes.
And you had a number of children in your class with some academic issues?
Yes.
You had some children in your class with behavioral issues, is that correct?
I faintly remember.
And when you were dealing with student misbehavior, you would start by talking with the student, is that correct?
Most likely, yes.
And if you needed help, you would ask for guidance or coworkers or administrators to help, is that correct?
Yes.
You would go to Dr. Parker at times, correct?
At times.
You would email her, true?
Yes.
You'd walk in her office.
Yes.
And if necessary, we'd get the guidance counselor to take the student to Dr. Parker's office.
At times.
And Ms. West was another first grade teacher. She was across the hall from you, correct?
Mm-hmm. She was.
Lead first grade teacher. Sometimes go over there if you needed to speak with her.
Mm-hmm.
You had a phone in your room?
Mm-hmm. Yes.
And you could call a parent on the phone in your room?
I don't think I've called a parent during the day.
But you could if you needed to?
Yes. Yes, I had a classroom phone.
And you could call the office?
Yes.
Mr. Coleman, can you please show to the witness and counsel Exhibit 90A? Yes, sorry, Defense 90A.
That is plaintiff's 90A, is that correct?
Yes.
All right.
No. She said defense 98 to me and then plaintiff to you, so I just want the record to be clear.
Oh, Defense 90A.
All right. Is that in evidence?
Not yet.
Okay.
Ms. Werner, I'll give you a minute to look at this document.
Are these from me or someone's messages to me?
Is your phone number 804-424 or 804?
Yes. So they're from me?
That's a text from you.
Okay. Yes.
Have you had a chance to look at the?
Yes, I read them.
Is that a text you sent on October 15, 2021?
If that's what it's dated, yes.
And you sent it to Rosalie List?
Yes.
And Ms. List taught with you at Richneck, correct?
Yes.
Was she another first grade teacher?
Yes.
Your Honor, I'd move to admit Defense Exhibit 90A and publish to the jury.
Any objection?
Your Honor, I would just object. I don't see how it's relevant. This is from October 2021. And it's not regarding JT or the year that this happened or the date of the offense.
Yeah, how is this relevant?
It's relevant. If the court will let me explore with her, we can sidebar and I can tell you, but I don't want to obviously do that before I question her about it.
I need you to state why you believe it's relevant.
The text is a text about evacuating the classroom when she felt that she was in danger, that she had done that before.
That's quite what it says, but you can read it, Your Honor.
I think the bottom one is relevant to that, but the top one isn't. So, I mean, I'll overrule the objection as to the bottom one if we redact the phone numbers and then redact the top text.
In your understanding, whatever ruling you make, can we ensure that this remains published known to the witness because it does have private phone numbers that I don't think have to be
Correct. So if we could just post that as it's highlighted there, I'm okay with that.
Yeah, I was not aware of any pre-court ruling about redacting text messages.
Well, phone numbers.
Or phone numbers.
Yeah, phone numbers from the text. Yeah.
We can redact it before it's submitted.
Okay.
Am I allowed to publish it to the jury before?
Yes. It goes up exactly like that.
Okay. Ms. Werner, do you recall an incident the year prior with a student named Q?
I don't.
Do you recall you had a student in your class named Q who you felt in danger of and you had to evacuate your classroom?
I don't. I remember a student with the name Q, but I don't remember any of this.
Okay. So if you've looked at the text messages where you talk about evacuating the classroom because of student Q and feeling in danger the year prior, you would disagree with that?
Yes, but I also know I've never have officially, technically done an evacuation procedure. I don't know what that... I've never performed a school classroom evacuation.
So, Ms. Werner, if you see on the text, had to evacuate my room early for lunch.
Yes.
And that was because of Q, wasn't it?
Yes, I read that.
Do you recall? Does that refresh your recollection?
I don't recall what happened.
Mr. Coleman, can you publish to the witness and counsel Defense Exhibit 91B? Have you had a chance to review? Is that also a text message from your phone that you sent?
Yes.
And you sent it on December 15, 2022 at 5:22 p.m.? And that was a few weeks before the events that bring us here today. Is that correct?
Yes.
And you sent it to Jen West, Anissa Miller, and Kristen Ayers, correct?
Yes.
And they were other first grade teachers.
Yes, they were.
And in this text, you told them that you were sorry for crying.
Your Honor, I'm objecting at this point. There was pretrial rulings about prior acts pursuant to Rule 404, Your Honor. This isn't relevant as well. If you can look at the text that's on the screen for Your Honor, we would be objecting.
All right, so there are two separate texts, so let's just start with the top one. All right, how is that relevant?
It's relevant to credibility of the witness in terms of statements about, the jury's heard evidence that Dr. Parker didn't look at her, so this is probative of that evidence that's in court from this plaintiff's own mouth.
From December 15th of 2022?
A couple weeks before the shooting.
No, I'm going to sustain that objection. All right, and then you have a separate argument on the bottom one? Or is it, I'm sorry, let's start with the objection first. Is that irrelevance as well? Or have you even gotten to that second one?
I had not gotten to the section.
Okay, so on the top one, I'm going to sustain the objection. All right, are you going to go to the bottom one, or did you just want the top one?
I want the bottom one.
Okay, all right, let me see that. Same objection?
Yes, Your Honor.
And is it the same date? I couldn't see the date.
It's the same date, Your Honor.
All right, thank you.
Again, it's about a completely separate incident.
Your Honor, the jury's heard testimony from Ms. Kovac and others about Dr. Parker not looking at her on January 6th, and Ms. Kovac made comments about Dr. Parker not doing certain things. This is a text message from Ms. Werner discussing feedback from Dr. Parker. It's directly relevant
To what?
Credibility of the witness. It's probative of actions taken on the day of, which they've been able to place in evidence.
No, I'm going to sustain the objection. It's not relevant. This is on December the 15th. All right.
Ms. Werner, there was an incident with your cell phone on January 4, 2023, correct?
Yes.
And it involved the student JT, correct?
Yes.
And he threw your phone in the classroom?
He slammed my phone to the ground.
And it broke the screen protector?
Yes.
When he did that, you took him by the hand, correct?
Yes.
And you removed him from the classroom?
Yes, I brought him to Ms. West's classroom across the hall.
And you asked her to call guidance, correct?
Call for, yes.
And Mr. Rawls came?
I asked her to call for help on her walkie-talkie, and Mr. Rawls and Miss Palladini came.
Okay, so Ms. West could call for help on the walkie-talkie?
Yes, she had a walkie-talkie. I did not.
Okay. And Mr. Rawls came?
Yes.
And he removed JT from the classroom?
Yes.
And he was suspended for 1 day for that, correct?
Yes.
And he returned to school on January 6th?
Yes.
His mother brought him into class?
Yes.
And she apologized for what JT did?
Yes, he did as well.
He did as well?
Yes.
And he offered to pay for the screen protector?
Yes. Casual conversation.
You didn't notice anything off about JT when he first arrived at school on January 6th?
I did not.
Now, your class went to lunch around 11:15 to 11:45, is that correct?
Yes.
And we've heard about an incident with JT in the lunchroom, and you personally went to Dr. Parker about this incident, correct?
Yes.
And to be clear, when you went to Dr. Parker about this incident, you did not report to her anything about JT having a weapon?
No.
You went back to your classroom after you left Dr. Parker's office?
From my memory of that day, yes, but throughout this week I have learned some things.
Do you recall going back to your classroom at some point before recess?
Yes.
And Ms. Kovac was in your classroom?
Yes.
And you learned from Ms. Kovac that 2 of your students said JT had a gun in his backpack?
I don't remember if Ms. Kovac told me who. She did not tell me which students. But yes, Ms. Kovac did tell me that students told her that the student brought a gun with him to school.
Did you ask Ms. Kovac who the 2 students were who had reported this?
I don't remember if I did or not.
Did you take measures to speak with the 2 students who had reported this?
No, I knew that Ms. Kovac spoke to them.
They were students in your class?
Yes.
And you didn't feel the need to speak to them yourself?
I knew Ms. Kovac had spoken to them, and I trusted Mrs. Kovac.
But you don't know what Ms. Kovac said to those students, do you? Or if she said anything to the students?
I trusted Ms. Kovac. She has 20, 30 years of teaching experience over my 2.5 years.
So Ms. Kovac stayed in your room for a while, didn't she?
Yes.
About 30 minutes?
Yes.
And she spoke to JT about what the student said, right?
I don't recall specifically.
You were in the classroom when this happened.
I was.
And Ms. Kovac was loudly talking to JT.
I could not hear what she was saying.
Did you, knowing that you'd gotten this information that your student might have a gun, did you go speak with him?
I did not. Ms. Kovac was with him.
Ms. Kovac was in your classroom? So you had coverage in your classroom? Because Ms. Kovac was in there and she had 20 to 30 years of experience, right?
Was that a question?
It was a question.
Could you repeat that, please?
Ms. Kovac was in your room when you found out that JT might have a weapon. You had coverage in your classroom. Did you go back to Dr. Parker and say, oh, there's been a change. Now there's a report that he might have a weapon?
At that time, no. Ms. Kovac was in my room investigating the situation. She was observing the student sitting next to the student. And at that time, I'm trusting Ms. Kovac.
Did you remove JT from your classroom as you had done 2 days prior when you took him by hand and took him out?
No.
Did you remove his backpack from the classroom?
No.
Did you search his backpack?
No.
Did you go back to the security officer in the lunchroom?
No.
Who had left a little bit after this time. Is that right, about 12 o'clock?
I don't know.
Instead, you proceeded to teach a lesson before recess. Is that right? And Ms. Werner Ms. Kovac team taught that lesson with you.
I don't remember.
So Ms. Kovac has stated that she taught a lesson on Pocahontas with you. You don't remember that?
No.
And eventually Ms. Kovac left the room, correct?
Yes.
And did you say, don't leave, please stay?
She left to tell Dr. Parker that there was a potential of a gun on the student.
But you don't know what she said to Dr. Parker, do you, Ms. Zwerner?
I knew that she left to tell Dr. Parker what the students had told her.
But you don't know what Ms. Kovac told Dr. Parker?
Her specific words? No, ma'am, I was not there
You were
with
not
her.
party to that conversation.
Correct, I was not.
And when she left, did you ask her to stay or to remove him from the room or to remove his backpack from the room?
No.
Now, we've heard that you saw JT go to his backpack at some time before recess. And did you go personally convey this information to Dr. Parker?
I texted Ms. Kovac.
My question is different. Did you seek measures, did you yourself convey this information to Dr. Parker?
No.
So you took your class to the playground, correct?
Yes.
And you were out on the playground with 2 other first grade classes and teachers?
Yes.
Jen West and Kristen Ayers?
Yes.
Ms. West, she's the one with the walkie, right?
Yes.
When you got out there, did you tell Ms. West, get on the walkie, we've got a student who might have a weapon?
I don't remember.
You don't remember?
No, ma'am.
So you shared with Ms. West and Ms. Ayers what you had learned about JT, correct?
Yes.
And you observed him on the playground?
Yes.
And Ms. Kovac came out on the playground at some point, correct?
I don't remember that. I
Don't remember? And you had left the playground before while the other teachers were out there. We talked about that in your deposition. So did you leave the playground to go back in the building to personally provide information to Dr. Parker?
No.
Did you question JT about anything that you had heard?
No.
And at some point, Ms. West left the playground.
Yes, right before we went inside.
And why did she leave the playground?
To my understanding, something with one of her students.
And did she ask you to shepherd her class and your class into the building?
Yes.
And how many students would that be?
Around 40, maybe.
Because Ms. West needed to go deal with another student discipline issue.
Yes.
Did you say to Ms. West, hey, I can't take your class in. I've got my own problems here. I've got an issue with a student who might have a weapon.
No, because at that time I knew that Amy had told administration, Dr. Parker. I honestly didn't think twice. It was my understanding that administration wouldn't think twice as well
Ms. Zwerner,
when alerted about a potential gun in school.
but you could have taken measures yourself at that time, correct?
Yes.
And you don't know what Amy Kovac said to Dr. Parker, do you?
The exact words, I don't.
So you shepherded 40-some students in the building.
Yes.
JT was in the midst of those students, correct?
Yes.
You had the children line up on the wall out of your classrooms?
Yes.
And you went into the class?
Yes.
And you did small reading group?
Yes.
You still hadn't removed JT from the classroom?
No.
And you recall that his backpack was next to his chair?
Yes.
Ms. Werner, at some point on January 6th, did a student named R tell you that JT had a gun?
No.
Do you don't recall saying, save it for later, or sit down to that student?
No.
That didn't happen?
No.
And the first time you saw JT with a gun, he was at his desk, is that correct?
Yes.
The first time you saw a gun that day?
Yes.
And when you saw that, you were shocked?
Yes.
Because you didn't expect to see that, did you?
It was a real gun. Yes.
Was there a point where you didn't think he might have a real gun?
Well, the whole day I was contemplating it could be real, but it also could not. When you hear the word, he told students he brought a gun with him to school. There is that possibility.
Ms. Werner, you were asked about the staff handbook. Can you pull up, it's, what exhibit is this? Is it
108.
108? 108? Zwerner 9074, Mr. Coleman, the top paragraph. Ms. Werner, do you see the third paragraph? Can we publish to the jury? I think it's in evidence.
This is just a cover. That's all we can see.
.108. Appears to be page 7, I think.
I can see it, yes.
Your Honor, may we publish it to the jury since it's already in evidence?
But this is your version, right? Your copy of it? Or
No,
it is the plaintiff's?
It's the
very well.
plaintiff's, Your Honor.
Yes.
Ms. Werner, looking at the third paragraph, it says discipline is the initial responsibility of the teacher. Is that correct?
Yes.
You agree with that?
It says that.
And let's look at the next page. The boxed behaviors. You spoke about that with the jury a while ago. Ms. Werner, student behaviors on the left is possession of a weapon. Do you see that?
Yes.
And the next steps are secure students and ensure safety. Did you do that when you got a report that JT might have a weapon?
I did not.
And the next step is immediate notice to administrator. Did you yourself notify an administrator?
Amy CONVICT did.
I'm asking.
I did not myself.
Did not yourself. Ms. Werner, the jury's heard a fair amount about your physical damages from your treating doctors the last couple of days. You eventually resigned from the Newport News Public Schools, is that correct? And you worked for a few months at a gym, Burn Boot Camp, is that correct?
Mm-hmm.
And you and your sister Hannah also worked out there pretty frequently, is that right?
Beforehand, yes.
Before?
January 6th.
You would disagree you were still working out at Burn Boot Camp after?
Oh, I did go work out afterwards when I had started working there at the front desk in the fall of 2023. My doctor had cleared me to do light work, light exercises. So I tried my best to work out the best that I could with the weights, best I could.
And the jury has heard testimony about your emotional damages, correct? We heard from Dr. Watson today.
Yes.
You started seeing your therapist at Abundant Life regarding emotional problems back in March 2021. Is that correct?
That sounds right.
That was about a year and a half prior to January 6th.
Yes.
And you've been taking an antidepressant daily since 2021.
Yes.
And you told your therapist that you've been diagnosed with depression and anxiety for a number of years. Is that correct?
Yes.
You've been treated for generalized anxiety disorder?
Yes.
And a major depressive disorder?
Yes.
And Ms. Werner, you felt a lot of stress and burnout from being a teacher. Is that right?
Yes.
And you had also tragically lost your father in June of 2020?
Yes.
And you had worked with Ms. Gonsalves on recovering from PTSD symptoms related to that event, because that's an event you witnessed. Is that correct?
Yes.
Mr. Coleman, can you show the witness-only defense exhibit 109 at 83?
Let me. Okay. All right. I know you all have.
I've read it.
Hold on 1 second. All right. objection is, state your objection for the record, please.
Your Honor, her introduction of this text message is irrelevant.
Relevance is the objection. Your response?
Clearly, it's relevant, Your Honor. She said multiple witnesses parade in here and say that she has social anxiety and cannot even leave her home. This was produced by Ms. Zwerner. This is actually an Instagram post, and it's directly relevant to her ability to function in the community following this incident, which she's placed at issue here.
All right, I'm going to overrule the objection. We can also issue a limiting instruction if necessary that it only goes towards the testimony to contradict the symptoms.
Yes, Your Honor. Thank you.
All right.
Ms. Zwerner, is this an Instagram post you made on September 13, 2023?
It's a private message I sent to Taylor Swift.
Move to admit it into evidence and publish to the jury.
Over over plaintiff's objections noted.
Would you like me to read it out loud?
No, is it posted on that? I can't see that.
It's posted.
Oh, okay.
They'll read it.
We'll let the jury. Have you had a chance to read it, Ms. Zwerner?
Yes.
Ms. Zwerner, you just told the jury this is a Instagram post?
It's a private message to Taylor Swift.
Private message to Taylor Swift. And you gave that message on, or sent that message on September 13, 2023. And you let Ms. Swift know that you were the teacher from Richneck Elementary School who had been shot.
Yes.
And that you had been to the Eras Tour in Philadelphia. And that was in May 2023, correct? That you went to the Eras Tour concert in Philadelphia?
That seems around that time? Yes.
That was a few months after the tragic shooting, correct?
Around summertime of 2023, I remember.
It was
Yes.
a few months after you recovered from your physical injuries. Is that correct?
4 months.
And you told Ms. Swift that you were involved in a long court case from the shooting and asked her not to post the message.
Yes.
And you state that you're trying to keep your personal life out of the media. Is that correct?
Yes.
Mr. Coleman, can you please show the witness-only defense exhibit 109 at 82?
Just have the same number, or?
Yes, it's 109 at 82, and that was 83. So it's a page number. It was produced in discovery by the plaintiff, a series of social media posts and text messages.
So now we're going to label, so I've admitted that, so that's defendants 109-82, and this is going to be 109-83.
10983 is the Taylor Swift.
At this point.
Yes, and
Okay.
10982 is a different.
Your Honor, I think the record's a little confused.
Okay.
The
Yeah, let's try to-
83 was the one that we just looked at.
Okay.
82 is what I believe she's.
That's what I just said.
One of us had it switched. Okay. All right, so this, we're going to, defendant 10982 is what
Correct.
you're showing her now?
Yes.
Okay, thank you very much.
Ms. Werner, I'll give you a minute to read through this document. Is this a private message you sent to the band Odessa?
Yes.
And you sent this message on September 13, 2023 as well?
Yes.
Move to admit exhibit 109 at 82 into evidence and publish to the jury.
All right, any objection?
I'm not going to object, Your Honor.
What's that?
I'm not going to object.
No objection. All right.
And Ms. Werner, in this message, you let, Odessa's a band, correct?
2 producers, yes.
And you let 2 producers, it's a music show, is that
Yes.
correct? And you let this band or producers know that you were the teacher from Richneck Elementary School, is that correct?
Yes.
And that you had been to their show in Bristow, Virginia, the night prior?
Yes.
And they're an EDM band, correct?
Yes.
And EDM is an immersive sensory experience where they use strobe lights and visuals during a concert, is that correct?
Yes.
And you told Odessa that you had had so much fun at their show that you were in awe and hoped to go back again.
Yes.
And then you also told Odessa that you were involved in a long court case from the shooting and asked the band not to repost the message.
Yes.
Because you were trying to keep your personal life out of the media.
Yes.
Ms. Werner, you've given interviews about the events at Richneck on numerous occasions, correct?
Yes.
You've been on the Today Show.
Yes.
Your sister's also created a GoFundMe page.
Yes.
There are t-shirt sales that benefit you. Now, Ms. Werner, you went to cosmetology school, correct? And that was in January 2024, is that right?
Yes.
And this was something that you had considered for years prior to the events of January 6th, is that correct?
Not realistically.
Mr. Coleman, can you please show the defense exhibit 96B to counsel and to Ms. Zwerner?
I can't see the date on that. Can you bring that up?
Your Honor, I think context would be helpful for counsel as well, so that we can understand the correct scope.
All right. Are you going to lay some foundation?
Yes,
All
Ms.
right.
Zwerner, is this a text you sent to Rosalie List? And Rosalie List was a fellow teacher with you, correct?
Yes.
Now, that was on September 11, 2021.
Yes.
And in the text you said, "Ugh, I'm not ready to teach. If I quit, I'd go to cosmetology school." Is that right?
Yes.
That was a couple years before the events that we're here for today.
Yes.
Ms. Werner, Mr. Coleman, can you please pull up Exhibit 96, P1?
96B, Ms. Douglas?
I think it's just 96, Your Honor. Plain 96.
Text message about cosmetology school
Yeah,
has not yet been
oh, I'm
sent.
sorry. I thought it had been, yeah. We'll go ahead and pull 96B up. I apologize. I thought it was up. So that was a text that you sent to Ms. List a few years before.
Yeah, I think I also joked about stripping as well.
Ms. Werner, I didn't include that text. I didn't include that text. Apologies for getting the numbers wrong, but Mr. Coleman, can you please pull up Exhibit 96?
Are we admitting 96B?
Yes, admitting it.
Okay.
I have no objection, Your Honor.
All right.
Have you had a chance to look at the text?
Yes.
Is this also a text you sent to Ms. List on October 17, 2021?
Yes.
May I move to admit Defense Exhibit 96 and publish to the jury?
Let me see what you was able to bring up there. All right, so that's what you're at. I guess you can't see?
I can't see, no.
Okay, why don't you take a look at that, make sure that's what you want to publish. All right, any objection to those three parts of that exhibit?
Just want to make sure, Your Honor, when we're getting these snippets up on our screen that are being shown to the jury, that's not the full document that's been disclosed. So as long as whatever Your Honor's rolling on is screen.
Correct.
Okay.
At this time, and then if you need any follow-up or whatever else you want to, I'll let you redirect.
Understood, just want to make
Okay,
sure.
so we can publish this as shown on my screen.
That's fine.
All right.
Have you had a chance to look at it?
Yes.
And did you find an Aveda school for cosmetology and send it to Ms. List?
Yes.
You told her that they had a school in Arlington? Mr. Coleman, can you please show the witness Exhibit 96J? Ms. Werner, is this a text you sent to Ms. List on October 18, 2022?
I'm not sure who I sent it to, but yeah, it's a text I sent.
Okay. It says to Rosalie List. Is that correct?
I can't tell from here.
Can you see?
Cover that.
Yes, I did.
And that's about a year later, correct? The fall before the events that bring us here today.
Yes.
Any objection?
Move to admit it.
Okay. All right. As shown on my screen.
And Ms. Werner, in the text, you told Ms. List that you didn't even know if you wanted to teach anymore, but you didn't want to waste all the money that you had spent going to school. Is that correct?
Yes, I said that.
And you said that you would love to go to cosmetology school.
Yeah.
You went to cosmetology school, correct? About a year after the events that bring us here today.
Yes.
Mr. Coleman, can you please show the witness only and counsel Defense Exhibit 127? Page 3. Ms. Werner, are these your records from Empire Beauty School?
Yes.
Your Honor, may I move to admit and publish to the jury?
Are you just doing one page or both pages?
I think it's going to be several pages of that document.
Okay, so it's one document?
Yes, sir.
All right, any objection to the entire document?
All right, has her address on it.
Okay.
We can redact that before
Yeah,
it's
we can
submitted to the court.
redact the email, address, and phone number, please.
Ms. Werner, I want to focus your attention to page 4 in the personal background section. Can we publish it, jury, Your Honor?
Right, that mirror.
Your Honor, again, I understand the relevancy of all of this, but
All right, your responses to relevance.
Ms. Werner has told the jury that she can't use her hand, and she's become a cosmetologist. Clearly, this is relevant.
Okay, I'll allow it. Overruled.
Ms. Werner, I'm looking at the personal background section. Question 4. Ms. Werner, in that question you were asked, is there anything that might prevent you from achieving your dream of starting or completing school, meaning cosmetology school, correct?
Yes.
And your response was part-time job at gym.
Yes.
Mr. Coleman, can we move to pages 20 to 22 of the same records? Focus on page 21, and that is physical requirements of the industry. May we publish the heading physical requirement of the industry to the jury?
Any specific objection to that, besides your continuing to relevance?
Judge, I would object to this based on hearsay in the document.
All right, you have a response to that?
It's not offered for the truth of the matter. She certified that she had no issues with these.
And she's identified the document itself, so I think she's familiar with it. I'm going to overrule the objection.
Ms. Werner,
If you, I guess you need to, I will say, you need to lay a little bit more foundation as to this page. She wrote the other pages. This is not a writing, so.
we can jump ahead and then come back. Let's go to page 22, and I think that will take care of the issue.
All right.
Mr. Coleman, can you go to page 22? Ms. Werner, do you see page 22 with your signature on it? Is that your signature?
Yes.
Can we push that to the jury?
All right, I'll overrule it. That is her signature, and she signed it. She understood the agreement. All right.
Go ahead and pull up the signature. Okay. Jury's looking at it now. Ms. Werner, that's your signature on this document, correct?
Yes.
And if you go back to the prior page, it discusses the physical requirements of the industry. On page 21, we'll go back to that.
Yes.
When you signed the document, you acknowledged the physical requirements of the industry of cosmetology. Is that correct?
Yes.
And let's go through them. The first one is arm-hand steadiness, the ability to keep your hand and arm steady while moving your arm or while holding your arm and hand in one position. You not acknowledge that you were able to do that, correct?
Yes, I signed the document.
Second one is manual dexterity, the ability to quickly move your hand together with your arm or your hand to grasp, manipulate, or assemble objects. You signed that as well, correct?
Yes.
Finger dexterity, the ability to make precisely coordinated movements of the fingers of one or both hands to grasp, manipulate, or assemble very small objects. You acknowledge that as well.
Yes.
Trunk strength, the ability to use your abdominal and lower back muscles to support part of the body repeatedly or consciously over time without giving out or fatiguing. You acknowledge that requirement, correct?
Yes.
Multi-limb coordination, the ability to coordinate two or more limbs, for example, 2 arms, 2 legs, or 1 leg and 1 arm, while sitting, standing, or lying down. It does not involve performing the activities while the whole body is in motion. You acknowledge that requirement, correct?
Yes.
You completed the Empire School cosmetology program, correct?
Yes.
And to become licensed, you successfully completed the 1,500-hour education requirement.
Yes.
You passed all practical examinations prior to earning your license in July 2025, is that right?
Yes.
And to do this, you had to complete subject matter instruction at the school?
Yes.
And you also had to complete practical performance examinations.
Yes.
And this involved hairstyling, hair cutting, and hair coloring.
Yes.
And in fact, you were quite good at school, weren't you, Ms. Werner?
Was I good at school?
You had a 97.4 GPA.
On my tests, yes.
And you have provided photographs of your work as a cosmetologist to salons, is that correct?
Yes.
Mr. Coleman, can you please pull up Defense Exhibit 112, page 6? Do you recognize this document, Ms. Werner? Move to admit and publish to the jury.
Any objection?
No objection, Your Honor.
All right.
There's several pages if you want to take your time going through them.
I see these three.
Mr. Coleman can move to the next pages so that you can look at them all and the jury can see them. It's page 7.
Faces in any of them, correct?
I don't believe
No
so.
faces, Your Honor.
Okay.
Are they, Your Honor, they have different stamps.
I was just going to get to that, yeah. Pages 6, 7, we're now at 8.
Yeah, we
All right.
we don't have an objection to them, but for the record's purpose, we were shown 6, and now we're looking at 7 and 8. I just
Correct.
want to make sure it's clear.
Yeah.
It's all Exhibit 112, pages 6, 7, and 8.
That's how they'll be referred to. I guess we don't need to black out those faces, right?
Ms. Werner, have you had a chance to review all of these? And is this a composite of your abilities and work as a cosmetologist? Is that right? And no doctor's ever told you that you cannot work as a cosmetologist?
Correct. I will say, flipping through the photos, can we go back to the first one, please?
Sure. Page 6.
Yes. All of these three right here, I did have assistance pretty much throughout with an educator or at least one classmate.
Understood. But you've put these photographs out to salons in order
One
to get
salon.
One
Yes.
salon in order to get a job.
Yes, one job that I applied for.
Ms. Werner, we heard Dr. Watson testify that the use of recreational substances would change his findings. Do you recall that?
Objection, Your Honor. Misstates the testimony.
Can you re-ask the, I guess, ask the question again for me?
Ms. Werner, you heard Dr. Watson discuss whether you had reported a history of using substances. Is that correct?
Objection, that was also not part of the testimony, Your Honor.
Yeah, I don't recall that either. So I'm going to sustain it on misrepresenting the testimony unless you can prove otherwise.
Ms. Werner, you heard Dr. Watson say that part of his evaluation was to determine whether someone had any experience in their life before what we call the incident event. Is that right?
Could you say that one more time?
Do you recall Dr. Watson, you were sitting here for his testimony, say, when considering someone's history, part of his evaluation was to try and determine whether somebody has had any experience in their life before what we call the incident event. Do you recall that?
Yes.
And do you recall him saying that whether or not that individual has other factors that may be influencing their behavior and their symptoms, for example, is that person using substances? And you reported to Dr. Watson
Your
that...
Honor, it's an incomplete statement of the transcript. It talked about addictive use of substances.
What are you reading from?
The transcript of Dr. Watson.
Okay, I just wanted, obviously I can't see what you're looking at. I mean, did you read it exactly as it's...
Yes,
See?
for example, is that person using substances an addiction? Are those addictions actually more likely to be responsible for the symptoms?
Right, so your question is, did you hear him say that? Overruled any of that? Withdraw the objection to that?
No, that's been read in full, yes.
All right, very good.
And Ms. Werner, when you reported to Dr. Watson whether you were using substances prior to the event, you didn't report truthfully to that, did you?
No.
don't have any further questions, Your Honor.
All right, how long do you plan for redirect?
Short, 10 minutes, John, 15 minutes.
Right.
So Abby, just a couple more questions. I know you've been sitting there for a little bit. First, tell the jurors, are you proud of your work as a cosmetologist thus far, getting that certification?
I am.
How hard was that for you to do?
Really hard. I had a lot of pain. I had a lot of help. But I did it. I did it.
And is that something that's brought you joy in the past, hair and makeup? You've seen your previous text messages. Is that something you enjoyed as a hobby prior to
Yes.
teaching?
Hair, makeup, yes.
Did you ever think you were really going to give up teaching to be a cosmetologist?
No, that's figure of speech. I joked about stripping.
Were you really going to do that?
No.
And tell the jurors, you're not able to get a job right now as a cosmetologist because of your hand, correct?
Yes, my previous surgery this April, it's still healing. I was wearing a brace until earlier this month and was just recently being able to take it off earlier this month. So it's still a little bit more, I guess, raw, if you will, still getting warmed up to move again.
And when you were getting certified, did everything take you much longer than everybody else to do the hair? Without help, if you didn't have the help?
I wasn't fast at hair. I remember that. I remember I felt like I took a very slow time completing tasks, completing people's hair.
And after you've done that, how is your right hand, the hand that was not shot?
The past multiple months, I've noticed pain in this area, overuse, and now my wrist as well.
And is that from overuse of your right hand?
That's what I have been told.
And tell the jury, when you got that part-time job at the gym, why did you get that job?
I remember, when I think about that, it just makes me remember I just wanted to feel like a person again. It was a familiar place, the gym my sister and I were a part of. We went to almost every day, not all the time.
Before the shooting?
Yes, before January 6th. So very comfortable with the place, very comfortable with the people there, the workers there. And it came to my attention that they needed an extra person at the front desk just for a little bit of time, early in the mornings.
At that time, were you having a hard time getting out of bed?
Yes, but it was something like I just felt like I needed to be pushed to do that. I had to start feeling like a person again. Try to.
Thank you, Abby. That's all the questions I have.
All right.
One follow-up. Ms. Zwerner, you talked about being able to go to burn boot camp before January 6th, but not after. Mr. Coleman, can you please show...
That wasn't the testimony.
Well,
I'm going to ask you to rephrase that.
Ms. Zwerner, you were going to burn boot camp 4 times a week in August 2023, is that correct?
to work or to work out?
To work out.
I don't know off the top of my head how often it was.
Mr. Coleman, can you please pull up Exhibit 122, P1, so that the witness can familiarize herself with the record? Just publish it to her and counsel.
Which part am I looking at?
Looking at the record to see if you can identify this record.
Yes, it's from my family practitioner.
Okay. And what is the date of the record?
August 2023.
Mr. Coleman, can you go to page 2 of the record under the heading Depression?
Your Honor, I am going to object to this document coming in based on hearsay or authentication.
Yeah, she hasn't moved it in yet, right? I think she's just, at this point, you're just asking her whether or not she did or did not say this, correct?
Yes, Your Honor.
All right.
I have no intention of moving this into evidence.
Very well.
Just want to ask Ms. Zwerner about it. Ms. Zwerner, do you see the heading Depression?
Yes.
And it says 8/5, is that August 5?
Yes.
Went back to gym with sister 4 times a week mostly.
4 times a week, mostly. Yes.
Mostly. By August.
At most 4 times a week.
No further questions?
All right, you can step down and sit back at council table. All right, I think now's a good time to take a lunch break, and then I'll hear motions. I'll give you a chance to talk, and at that point, over lunch, I would appreciate you making sure there are no other witnesses or any motions that you want to make at that time.
Yes, Your Honor.
That's what we'll start off with, and then I'll hear any motions that are appropriate at that time as well.
Yes, Your Honor.
All right, and then we will see where that goes. Okay. All right, ladies and gentlemen, it is lunchtime. We will take our hour lunch, and you are excused. Please do not talk about this case or anything you've said or heard. All right, you may be seated. Do you want to go on the record, Mr. Bright?
On the record of that, I just mentioned to council the fact that we're going to be resting in an hour, maybe short for them, and we'll be sitting back there. If you want to give them more time, it may be the best time to give them a longer lunch instead of getting stuck in. The sun finally came out after.
All right, well, we'll check on them at my plan. No, I'm not going to take you up on that. 1:45. I want to get. 12. I'm sorry. Yeah, 1:45. I want to get going again.
Yes,
Okay.
Your Honor.
All right. Court is in recess to 1:45.
you ready to see it.
All right, good afternoon. All right, kind of want to go over, I guess, the plan for the afternoon. It's still your intention to rest?
Yes, Your Honor. We have just the exhibits ready to be tendered to the clerk that have been already moved and admitted by Your Honor during the pendency of our case. They've all got the stamps and stuff on now.
Right.
Once we do that, we're resting.
Okay. Is the defense calling any witnesses after motions?
Yes, Your Honor. In the event that there was an adverse ruling, I would intend to call Deputy Blythe as the sole defense witness for today, and then I would ask for additional time after that to confer with counsel about any additional witnesses that we may call, depending on how everything checks out and how this motion proceeds.
Okay. All right. So what I've done before is I've let the plaintiff rest outside the presence of the jury. We've done the motion so the jury's not up and down, and then I will let you officially rest in front of the jury, and then I'll ask you to call your first witness. Does that make sense to everybody?
Yes, Your Honor.
Okay. All right. You have a... Yes, Ms.
There's a
Bright?
motion about the first witness before we get to that witness.
All right, but after you rest.
Yes, yeah.
Okay, right, okay.
Just schedule it.
All right, very well. All right, you have exhibits you'd like to tender?
Yes, Your Honor, I have, and I'll just go through them in Ms. Douglas's presence. We have 3A, 3C, 3E, 3F. Those were all during the testimony of Corporal Blythe. Then we have 90A, 90B, which were admitted during the testimony of Ms. Julie Zwerner. And we have 90C, which was admitted during the testimony of Hannah Zwerner. Then we have 108, which was admitted, the sections of 108 that were admitted during the testimony of Abigail Zwerner. And then on a flash drive, Your Honor, we have Exhibit 4, 110A, 110B, 9A, and 90D.
Okay. Madam Clerk, does that match up? All right, very well. Any objection besides everything already noted?
No, objections reserved on.
Correct. And 22 was previously admitted and provided to the clerk.
Okay. All right, with admission to those objections preserved, do you have a motion?
Yes, Your Honor, we rest now.
All right.
We do wish, and it's to Your Honor's preference, we wish to raise that motion for reconsideration on Your Honor's ruling as it relates to the existence of a special relationship duty owed by defendant Ebony Parker to Miss Abigail Zwerner as part of a class of individuals, if we may be heard on that at this time.
All right, I mean, is it anything outside the briefs that you've already filed? Or it is?
It is, Your Honor.
All right. All right, so you have rested, or no, do you want to make that motion before you rest, I guess?
Yes.
All right. All right, go ahead.
Judge, can I say, the defense would object to this argument being heard, just because I think I would rest on the prior arguments that I already raised for the defense of the motion and need to limit their theory of prosecution. There are some overlapping arguments here. I would just contend that this is not an appropriate time to attempt to revive a prior theory, alternative legal theory. This court has already heard it and considered a motion for summary judgment and dismissed with prejudice.
All right, I'll hear the objection at this time.
Yes, Your Honor.
Your Honor. Sorry, the motion at this time.
Your Honor, ultimately, when a claim is pled as a duty for the special relationship was pled in this action, which was count 3, it remains before the court, and it is the province of the court to reconsider or reevaluate its rulings at any point in time before the case is dismissed. And specifically, the courts have observed in circumstances involving motions for reconsideration, if there's been a ruling as it relates to a motion for summary judgment, which is a mixed question of law and fact. In other words, facts were provided to the court at that time, which may not have been wholesome or complete as it relates to what has now been preserved or presented at trial. It is appropriate to renew the motion, and then ultimately Your Honor will rule on it as Your Honor deems appropriate and fit. So the legal position here, Judge, is grounded in the court's decision, the Virginia Supreme Court's decision in Burns v. Gagnon, which was, as we've cited before, 283 Virginia 657. And specifically, it is a special relationship that was first recognized by the Virginia Supreme Court in the Burdett case. The Burdett case involved a case involving a sheriff's deputy who came across an individual on the side of the road. And the observation of the court in that case, and this is a quote from the Burns case, which is quoting the Burdett case, which says, when a negligence claim is made against a public official, a distinction must be drawn between the official's public duty owed to the citizenry at large and the official's special duty owed to a specific identifiable person or class of persons. And then the court goes on to say in Burns, not quoting Burdett, only a violation of the latter will give rise to liability, quoting Burdett again, because it is not in society's best interest to subject public officials to potential liability for every action undertaken. He goes on to say that in determining whether a special relationship exists under the present facts, that is the facts in Burns, it observed that here it is important to consider whether Burns reasonably could have foreseen that he would be expected to take affirmative action to protect, in that case, Gagnon, from harm. What we have here, Your Honor, is a duty that reflects exactly that, in our view. which is that the assistant principal, based upon the documentation that's been submitted, that's Exhibit 22, Exhibit 109, the testimony of Farish and the testimony of our expert, as well as the others, who all were under the understanding of a protocol that the assistant principal had a special relationship as it relates to each of them to handle circumstances specifically as it relates to the possession of a firearm, but certainly when there's a foreseeable risk of a firearm on campus. And under those circumstances, the court has recognized that while Ebony Parker did not owe a duty to the public or the citizenry at large, there was an identifiable class of persons at Richneck Elementary School who were under or subject to reasonably foreseeable harm to which she did owe a duty. That is a special relationship separate and apart from the assumed duty of care that we've talked about previously. And as a result of that relationship, Your Honor, we believe that the evidence sufficiently demonstrated, A, that it existed, that is, there is a distinct special relationship between her and individuals, which Ms. Zwerner is a class member of, as a teacher, as a staff member of that school at the time, and then also that there was reasonable foreseeability in the circumstance in light of the fact that there were repeated multiple reports that reached Miss Ebony Parker, Dr. Ebony Parker, excuse me, as it relates to the firearm on campus and in the possession of JT. And I bring that point out because one of the foreseeability analysis in this case and other cases is, do we know who might have something that's dangerous? And it was Nina Farish's testimony that specifically quoted Dr. Parker in terms of her interview that identified it. A, Dr. Parker was aware of the gun. B, Dr. Parker was aware that JT was reported to have the gun. And C, through the testimony of both Nina Farish and Mr. Rawls, as late as 1:40 p.m. that afternoon, 2 hours roughly after her first notification of a firearm, there was still understanding that there was a firearm present on the campus in light of the fact that they said, let's wait and see once mom gets here. It wasn't, we don't need to, there's no firearm. It was, let's wait and see. And so in light of those circumstances, Your Honor, we believe that it is appropriate to instruct the jury when we get to that point as it relates to a special relationship first recognized in Burdett, affirmed in Burns, and then demonstrated through the evidence today.
Thank you. Now the court's going to deny your motion to reconsider and relies on its opinion previously published in this case on that issue. All right, now having made that decision, any other motions? Oh, now you're resting, right?
Yes, Judge.
Okay. Plaintiff now rests. All right. Mr. Hogan.
May it please the court. Your Honor, for convenience, I've shared some case law with opposing counsel. I'm sure he's familiar with it. If I may pass this up to the court as well. I'm sure Your Honor is very well familiar with this. We have litigated this many times, these issues, but I think it will still benefit the court. Thank you. And Your Honor, let me note as a threshold matter, there will be two components to this motion. The first, I intend to proceed on a ordinary motion to strike based on the elements and whether or not the plaintiff has established a prima facie showing necessary to survive a motion to strike. In addition, after this, my colleague, Mr. Alex Bennett, will approach the podium and make a renewed motion to dismiss based on workers' compensation. I'd ask the court to consider that as well.
Nothing to hear argument on that.
I understand, Judge.
You can renew it. Now, I don't know that you need another associate to do it, but that'll be a real quick decision.
I understand, Judge. I just want to make the court aware of that.
All right.
With respect to the motion to strike, Judge, the standard's well established. Even the purpose of the motion to strike, it is proper to grant one where it is conclusively apparent that the plaintiff has proven no cause of action. The court has to require and accept as true all the evidence favorable to the plaintiff and grant the plaintiff any reasonable inferences that may be drawn from the evidence. This is a very favorable standard. We can view the evidence in the light most favorable to my opponent. Nevertheless, Judge, given the binding and unequivocally clear Virginia case law when it comes to the assumption of a duty in the specific context of third-party intentional or criminal harm, the steep threshold evidentiary showing that is required to trigger that obligation, combined with the steep evidentiary showing that is required to establish gross negligence, I would contend that they have failed to make a prima facie showing. To give a quick overview, in this case, plaintiff needs to establish that, number one, Dr. Parker voluntarily and expressly assumed a duty to exercise reasonable care to protect Abigail Zwerner from third-party criminal harm. I understand my opponent will dispute that this is criminal harm. The same doctrine under the assumed duty applies equally to intentional harm, so it is immaterial. For purposes of this hearing, I'll just reference it to as third-party harm. That's number one. Number two, they need to establish that Dr. Parker breached that duty under the relevant standard of care to a degree amounting to gross negligence. In addition, they need to establish that that gross negligence was proximate cause of the alleged injuries. And then, in addition, they need to establish the three potential prongs under the restatement second of torts, as recognized in Burns versus Gannon. And under Section 324A, there are three potential avenues for liability there. In conjunction with the elements I've just identified, they need to establish either that Dr. Parker, her gross negligence increased the risk of harm to Ms. Warner, or Dr. Parker undertook to perform a duty owed by another person to the plaintiff. Or yet, alternatively, number three, that Ms. Zwerner suffered harm because of her or a third person's reliance upon Dr. Ebony Parker's alleged undertaking. And I'll talk about reliance and emphasize it in the course of this argument, Judge, because case law has shed light on what is required to establish reliance. So focusing first, Judge, on the duty element. First and foremost, two pieces to this, Judge. It's got to be express, and then number two, there's authority establishing that a promise alone is insufficient as a matter of law. It needs to be combined with an affirmative act in furtherance of actual performance of the undertaking. Regarding the first point, Judge, the Supreme Court of Virginia has held unequivocally that an assumed duty to protect another from third-party harm cannot arise unless there is an express undertaking. An express undertaking, that means an express communication of a, quote, specifically described undertaking to take on a legal duty to exercise reasonable care to protect another from third-party harm. It has to be clear, unambiguous, it has to be talking, saying something. The case law is established that an implied undertaking is insufficient. And the case law has also established, it has defined an undertaking. In general, it is referred to, it equates to a promise or agreement. So what this means is that in the context of third-party criminal harm, in order to be on the hook for that, they need to establish that there's an express communication of a specifically described undertaking that's essentially a promise or agreement that Dr. Parker said to the plaintiff or to another person in the course of the day on January 6, 2023. A promise or agreement specifically to protect the plaintiff from the criminal harm or intentional harm that befell her. And the record is devoid of that, Judge. We've heard no testimony whatsoever that Dr. Parker made any express promise to anyone. At most, it has always been a reliance on implicit or implied tacit assurances. In fact, that was expressly pleaded in the plaintiff's complaint. In paragraphs 41 and 42 of the complaint, they allege specifically that Dr. Parker, quote, expressly assumed a duty to protect Abby Zwerner by making certain assurances that were, in essence, assurances that JT was unarmed, and then failed to fulfill those assurances by taking additional steps to ensure that they were true. That was their allegation. But we haven't heard anything about any express promise or agreement to say, I'm going to protect you, Abby Zwerner. At most, it has been implied. And there's good reason for these principles, Judge. The reason is because, in general, third-party criminal harm, those acts are unforeseeable. Generally, as a matter of law, they are unforeseeable because you cannot control the volition of other individual actors. That is all the more so in this case, Judge, where you've heard evidence from the plaintiff's own witnesses repeatedly acknowledging that no one would have expected a 6-year-old to bring a firearm from their home into an elementary school and shoot a teacher. This is as unforeseeable as it gets, Judge. And the rationale for why these rules exist, for the express undertaking requirement, are particularly acute in this case. It has got to be express. It cannot be left to conjecture or implication. It has got to be verbal from Dr. Parker, and that is not here in this case. There's no evidence whatsoever of that. The court has repeatedly reinforced this principle. First, it was articulated in Terry versus Irish Fleet, which the court is familiar with. There's a copy for the court's reference. But that's when they first came out, and the Supreme Court was at a fork in the road. They had to decide, look, we understand that for ordinary negligence cases, you can raise your hand and take on a legal duty that doesn't otherwise exist under the law through your conduct alone, through your voluntary conduct. And they gave examples. They cited the Nold case and the Pullman case. These are all cases dealing with a motorist who's traveling down the road. They see a pedestrian on the sidewalk. They signal over. They have no obligation under the law to signal to the pedestrian that it is safe to proceed. Yet by doing that, they have assumed a duty, or arguably have assumed a duty, to exercise this duty safely. You can't wave someone across the street without exercising reasonable care. And in Nold, they said, yes, that can happen. And whether or not that you have undertaken a duty to protect someone based on those gestures or implied conduct depends on objective reasonableness. But in Terry, the question was whether or not does that same general principle extend to the third-party harm context, third-party criminal harm, third-party intentional harm context. And there they said unequivocally, no. The Supreme Court put its foot down and drew the line there. And the reason they said that, they provided a rationale. It was not arbitrary. They said that if we did not require an express undertaking, to leave this to implication would be too ambiguous. It doesn't define the scope of the responsibility. It doesn't define how long someone undertakes this duty. It's too ill-defined for someone to be subject to liability for these unforeseeable third-party acts. And that's what's happening in this case, Judge. You've heard from their own witnesses. No one could have foreseen that the 6-year-old child would have come to school and brought this weapon and perpetrated this act. It is unprecedented. I acknowledge, Judge, that in the case law under AH versus Church of God in Christ, there is language. Church of God in Christ came in 2019 after Terry, 1 year after Terry, and it acknowledged Terry's holding, but it said, look, conduct that is tantamount to an express communication of a specifically described undertaking may be sufficient to trigger an assumed duty to protect another from third-party harm. And they cited specifically to the case, the portion of the Terry cases cited the Knoll cases. I would emphasize, Judge, that did not alter the standard. Terry is the standard. Terry has always been in the law. It is the precedent, and it was unequivocal that an express undertaking is required. An express promise or agreement. Implied conduct alone is insufficient. And the Court of Appeals has repeatedly affirmed that principle, recently in Good versus Huguenot Springs. That was 2024 VA App Lexus 441. That is a 2024 case, Judge. And that one, they said, noting that under Terry, a duty to protect another person from third-party criminal harm can, quote, arise only after an express undertaking, meaning an, quote, express promise. It has to be explicit. And when they applied it to the facts of that case, it's very similar. It's informative to what happened here. In that case, there was a landowner who owned property. He allowed and authorized someone to come onto the land for recreational purposes. He did not inform that party that there are tenants that occupy the premises and might become upset. Nevertheless, his guests went onto the property, and unbeknownst to him, the tenants came out. Of course, they became upset, and an assault occurred. He turns around and sues the landowners. He argued that by authorizing them to enter the land, he tacitly assured, without saying it, he tacitly assured that it was safe to do so. And the Court of Appeals rejected that. They said, Terry is the law. You cannot have tacit assurances when it comes to third-party criminal or intentional conduct. It has got to be expressed. It has got to be explicit. And that's as recent as 2024, Judge. This is binding established precedent. Independent of that, Judge, there's another problem with the duty element, and that has to do with the fact that under Kellerman versus McDonough, which I did not provide that in the materials here, Judge, but we have, I'm sure the court is familiar with it. It appears on our briefs. In the concurrence by Justice Kinzer, he notes that how they use the term undertaking under Virginia law is somewhat ambiguous. Some hold that it's a promise or agreement. Some say that it requires an affirmative act in furtherance. Some jurisdictions apply an amalgam. Here, he was emphasizing that, look, an express promise or agreement alone is insufficient. Even if someone promises another that I'm going to protect you, you cannot be liable in tort for that. And part of that has to do with the fact that in Virginia, it is well established that nonfeasance, basically liability for not acting, does not impose tort liability. You cannot be on the hook for tort liability generally based on contract. Contract and tort, church and state, generally separate and independent. And that's what happens when if all you have is a promise or agreement to do something and there's no follow-through or performance, then that you're seeking to impose tort liability for what amounts to basically a contract. And in Kellerman, they noted that even though the assumed duty doctrine seeks to kind of reconcile these principles, at the end of the day, what is required to trigger tort liability, there must be an affirmative act in furtherance of the promise. And that's why in Kellerman, that was a case where there were parents who dropped off children at another parent's house, asked them, it's fine if they do a sleepover, but do not take my daughter on a trip. Do not allow my daughter to be driven by inexperienced male drivers. And they promised. In response, in that case, they replied, I promise we'll take care of her, or words to that effect. That is the language that appears in the opinion. And in addition, the mom not only promised that, but she then allowed the children to go to a mall and be transported by an inexperienced male driver, which resulted in tragedy. There was a collision. There was a combination not only of a promise or agreement, but an affirmative act in furtherance, because the mother actually assisted in transporting the children, authorizing their transport by the individual that was prohibited by the other parents. And in Kellerman, they said, look, this is the law. You need an affirmative act in furtherance, not a bare promise alone. How does that relate to this case, Judge? In our case, the plaintiffs have repeatedly asserted, and their witnesses have claimed, that Dr. Parker was indifferent. They argue that people were banging on the door saying there's a firearm here, and she's not acting. And several witnesses have testified that she did not look up or respond at all. If that is their evidence, there cannot be an express undertaking to protect Abby Zwerner. There cannot be. The absence of action is the complete opposite of what this doctrine is all about. It's about making promises and then failing to fulfill them, or making promises, acting on them, and then ceasing your voluntary undertaking that results in harm. And we have none of those things here, Judge. At best, the critical moments, you've heard counsel in opening statement and during the evidence in this case emphasize that there are repeated reports, 4 reports. Those are the critical moments where the jury needs to consider the evidence and see what evidence was exchanged at that time. And what we've heard is that there's no one who's come into court and said, Dr. Parker has responded, yes, I'm going to get right on that. Yes, I will take care of this. it is all implied. It is all left to their subjective interpretations of her demeanor. You've heard Amy Kovac testify that she went into the office, and Dr. Parker didn't respond when she was talking about searching the backpack. You've heard Abigail Zwerner testify that when she entered the office, Dr. Parker didn't look up. That is their contention. And if that's the case, there cannot be an expressly assumed undertaking to protect another from third-party harm. Additionally, Judge, I want to focus on the restatement. We have these prongs. There are 3 prongs for avenues for recovery here. There's reliance, there's increasing the risk of harm, and there's also assuming a duty owned by another to the plaintiff. I'll just be very quick on this, Judge. The theory dealing with liability based on assuming a duty that another person owed Abigail Zwerner, that is not inapposite in this case. It has nothing to do and has no application here. Generally, that type of that doctrine applies where there's a company that by contract has agreed to render a service for another entity. So it's usually like a security service that by contract agrees, I'm going to carry out this business's safety obligations. We've got none of that here. It has no bearing here. The other component here is increasing the risk of harm. They would have to establish that in addition to an express undertaking, by promising to protect someone, it actually left Abigail Zwerner worse off. It exacerbated the risk of harm. And we don't have that in this case, Judge, because again, their evidence was that Dr. Parker did not act. Not acting cannot amount to an express undertaking. Not acting is their theory, and if that's their evidence, it's insufficient as a matter of law. Finally, Judge, when it comes to reliance, the restatement itself just uses the term reliance, but the case law interpreting it, AH versus Church of God in Christ and several others, Terry versus Irish Fleet, it's actually 2 components, at least. It has to be justifiable and detrimental. Detrimental reliance requires that by promising or agreeing to protect Abigail Zwerner, it induced her to rely on that and forego taking additional safety precautions she otherwise would have done. The record is silent on that, Judge. We've heard no evidence from Abigail Zwerner, despite the opportunity to testify to this. She never testified that if Dr. Parker had done X, Y, or Z, I would have done this, I would have exercised reasonable measures for my own safety. We have no inducement, we have no detrimental reliance. In addition, Judge, independent of the detrimental element, it has got to be justifiable. Justifiable meaning reliance fails as a matter of law if it's not reasonable. It has to be objectively reasonable. And that's where those motorist cases come in. The Nold case, the Ring versus Pole case, those are all about, look, if somebody knows the true facts, if somebody knows there's a threat and reports it up to somebody, and the administrator or executive says, look, you're safe, there's no need to be alarmed, but you have independently, through your own investigation, with your own eyes, seen there is an imminent threat. If that's what your theory is, that's what your evidence, it would be unreasonable as a matter of law to rely on that. There can be no reliance as a matter of law. This is well established in a variety of contexts, Virginia law, Judge. It's in fraud, it's in the assumed duty context, it appears in judicial estoppel. This is a well-established principle. It must be objectively reasonable. And especially where the party that's asserting reliance investigated the facts themselves and tried to identify what's going on here, what is the threat, they can't rely on somebody else. And that is what happened in the Nold case, Judge. Well, let me say this. That is what happened in the Nold case, where there was a pedestrian who they could see, they were crossing the street and they looked and they could see that the driver or motorist to determine accessible to the pedestrian versus the driver themselves was not in a position to see if there's a threat. And the pedestrian could see. It would be unreasonable as a matter of law to rely on somebody waving you across the street when you can see there's a truck coming down the highway. That's what it means. And so here, taking their evidence, viewed in the light most favorable to them, we dispute this, but under that standard, if they're saying there's a fire, there's a fire, there's a fire, they're watching the fire happen, there's a train crash coming, and then they're reporting to a party who's not present, who's not on scene and witnessing this firsthand. They can't then say, oh, well, we relied on this person who wasn't present. We know true facts, we know what's going on, but we're reporting to this person who's off scene, and I'm going to rely on what they're telling me that we're safe. That would be unreasonable as a matter of law. Finally, Judge, I just want to emphasize that independent of all of these arguments, at the end of the day, this is a gross negligence case. That is a demanding legal standard, and what it amounts to is they need to establish indifference, not inadequacy. The case law is well established that if the evidence shows that there was an exercise of at least some degree of care by Dr. Parker, this doesn't go to a jury. And this is crucial, Judge. We have heard from Amy Kovac testified, and on day 2 of trial, She, in essence, testified that Dr. Parker assented to a search of the backpack, that Dr. Parker directed her to search the backpack. She would dispute that, but in the transcript, it appears on page 199 of the Day 2 trial transcript, she was asked, and so then, Ms. Kovac, did Dr. Parker respond to you or give you any direction? And she responded, she kind of nodded and acknowledged that that's what I was going to do. And Ms. Toscano asked her, you let her know that I'm going to check the backpack? And she said yes, and she nodded her head. That is a subordinate going to an administrator, telling them, I'm planning to search a backpack, and looking to them for guidance, for direction, was the question. And in response, Dr. Parker nodded her head. What does that mean? That means that is not indifference. That is not someone disregarding reported threats. That is acknowledging the threat, looking to her subordinate, who is requesting assent and authorization to search a backpack, and she's giving it. That is an exercise of at least some degree of care. And just because there was a bad outcome, or some jurors might disagree with the decision that additional steps might have been required, that demonstrates that there was an exercise of at least some degree of care. And it's not just that. There's the searching of the backpack, and there's also the directing other staff to tell Ms. Zwerner, you can call the mom. You can call JT's mom. If you are uncomfortable, I'm trusting your judgment and discretion. You are someone who is on scene in the position to see whether or not this threat is imminent or not. And I'm authorizing you to act.
So if you agree that that's what the evidence is, aren't those express undertakings as well and undermining your first argument?
I would actually argue two things, Judge. I think these are, we can argue in the alternative, and they can't have it both ways.
Okay. All right, go ahead.
So I think that's astute of you to pick up on that, Judge, and I think it makes sense. I think their evidence establishes the exercise of at least some degree of care, and alternatively, they fail to establish the assumption of a duty. Thank you.
Thank you. Right. I mean, you can stand up and renew your motion on the workers' comp. I'm denying it based on what I ruled on before. So if you want to put that on the record, that's fine. I'm not listening to any argument.
Your Honor, we would just place on the record our continuing objection to the court's subject matter jurisdiction to even hear this claim based on the workers' compensation law, Virginia Code 65.2-307.
All right, court notes your renewed objection to my previous ruling that this was a personal injury and not workers' comp. All right, I don't need you to respond to that. You can rely on everything we've already said in my written opinion. Okay. Yeah. Yeah, absolutely.
Yes, Your Honor. Your Honor, I just observe for the record that I think the understanding of what is well established in the law in Virginia is in high dispute here. And in fact, at one point in time, opposing counsel told you that there is binding authority from the Court of Appeals from, I think it was the Good case, and I think cited another Court of Appeals case, both of which are unpublished, which means that you actually doesn't bind you. And so I think it's important for us to recognize that all of the rhetoric surrounding the argument about what is and what is not the law is not what guides this court, of course. It is what the law says it is. And when we talk about an instance such as this one, and the framing of it from the defendant's perspective, which is that this is an act of third-party crime, or the pivot that we hear today, intentional act, the law says it cannot be. It cannot be either of those things, no matter the evidence before the court. And it cannot be those things because a 6-year-old does not have the capacity for an intentional act or a criminal act. And that's been recognized in the criminal court decisions. We've cited to this in a footnote in one of our motions in limine oppositions. And in fact, it's reflected, at least implicitly, within the Virginia model jury instructions, which talk about the fact that anyone under the age of 7 doesn't even have the capacity to be negligent, let alone gather the mens rea, if we use the criminal term, to actually form any form of intent that is recognizable under the law. And it's important to distinguish that because Terry versus Irish Fleet and the progeny of cases in which they are now citing all stem from this presumption and assumption that it is an intentional crime committed by an adult. We're talking about sexual abuse crimes or crimes of criminal assaultive behavior, all from an adult, never a minor in those cases. And how we can distinguish that is in the Burns case, when it doesn't involve an adult, there is no discussion of that area of the law in regards to this express undertaking. It was before Terry versus Irish Fleet, but in terms of these criminal assaultive behavior contexts. I say that because it's indicative of the applicable law here, which we believe it allows an implied undertaking under 324A, although we don't think that our evidence requires an implied undertaking in order for this to survive a motion to strike and ultimately go to the jury for decision, and largely for the observation that Your Honor just made right before the close of their argument, which is to say that during the course of this day, and I will hold their feet to the fire on this, if their position is that by nodding her head, Dr. Ebony Parker acknowledged a threat, and acknowledged a threat such that there was a joint action taken by Ms. Kovac as her subordinate, that is an undertaking. That is an undertaking specific to a firearm on the campus at Richneck Elementary, beginning at 11:40 in the morning and ending at some point that afternoon when the school is out. When school's out. And why I make that point is that if we were to even look at Terry versus Irish Fleet, the citation that was read to the court as it relates to that implicit or implied criminal undertaking talks about how in that circumstance, the alleged undertaking, this is a quote, is necessarily ambiguous and there is no designated beginning or end to the undertaking. That's not true here. There is a specific undertaking. There is a gun on campus. There is a specific time frame. It is 11:40 and this child's going to leave school at 2:30. That's when mom's coming. And repeatedly from that moment, the evidence has demonstrated that she acknowledged the threat, counsel's words, that they repeatedly failed to act, which is a choice, not nonfeasance, it's misfeasance. And why is it misfeasance? Because the protocols and the policies that have been admitted into evidence said that this is actually what you're supposed to do. You are supposed to do these things in this circumstance. And it is misfeasance not to comply with those protocols. It's not a nonfeasance circumstance. And ultimately, when we get to this issue of is this surviving a motion to strike, which is our narrow issue before the court at this moment, I would point the court to the footnote in the Terry versus Irish Fleet case, which observed that when the issue is not whether the law recognizes a duty, but rather when the defendant by his conduct, in this circumstance, her conduct, assumed a duty, the existence of that duty is a question for the fact finder. And even the Burns case observed that it was inappropriate to make a decision on that case involving an assumed duty of care before it was actually provided to the fact finder to then make a finding as it relates to an assumed duty and then render a verdict or a decision as it relates to that finding as well. And so on the issues of an assumed duty of care, when we look at the Burns case, which cites to 324A, we believe that all three of the prongs are applicable in this circumstance. A, her failure to exercise reasonable care increases the risk of such harm. Everyone in this school was waiting on the cavalry, and the cavalry was Dr. Parker, because that's what the protocols stapled to the back of Ms. Zwerner's classroom told her would happen. And that's what she understood based on the questioning of Ms. Zwerner, even in cross-examination, was going to happen. And then this argument, as Mr. Hogan points out, which is, well, there's no, it's inapplicable to talk about an undertaken duty to perform a duty by the other to the third person. My question to the court then is, why are we talking about all the things that the other teachers were supposed to do then? If you want to talk about all the things that the other teachers were supposed to do, they've practically demonstrated the assumed duty of care in that regard. And then third, the harm is suffered because of reliance of the other or the third person upon the undertaking. I point out to the court, this is where, there's a difference between how you cook your steak, well or rare, and they say it's well-established law, and I'd say their arguments are rare. And the reason I say that is they're citing to cases that are inapplicable in this context as it relates to reliance. When you're talking about fraud claims or in the context of a case involving a pedestrian on the corner of a road and whether or not to cross the roadway in the Knoll case. It's not about reliance. It's about a question of contributory negligence in the context of crossing a roadway. And the motion that's being made in this moment is not a motion that they've met their burden on contributory negligence. The motion is that we haven't put enough evidence before the court for a reasonable fact finder with all inferences in our favor, and viewing the light of the evidence in our favor, could not reasonably conclude that the issues in the case at bar fall in our favor. And so, as it relates to the duty, I think it's well established, quote from them, and I'll move to this issue of gross negligence. On the point of gross negligence, Your Honor, and just because I think that this is an issue that will obviously turn its head again if we argue jury instructions, there's a pertinent case from the Virginia Court of Appeals, which is the Howard versus Harris case, that came out in 2024, where the court essentially observed that the evidence at the trial court level was actually sufficient for a gross negligence finding. And they observed sort of this circumstance in which an officer had cuffed somebody and therefore exercised some care, but that in and of itself didn't amount to this scant care requirement or scant care language within the Elliott case, which preceded or predated this. And I point that out because it has a great recitation of circumstances in which gross negligence may still be found in circumstances if the jury were to even interpret the conduct as exercising care in the beginning. And that's a jury question of whether what Dr. Parker did was a demonstration of care in any regard. And I'd point out to the court that there's a case, Chapman versus City of Virginia Beach. It was Mr. Bright's case. He'll tell us about it later, in which the question was, and the instructions I think will be appropriate to the jury, about you can have multiple instances of simple negligence that amount together to gross negligence. And if nothing else, even our view is each act of a firearm on campus, which they claim is unforeseeable, and yet their handbook says weapons on the property, meaning they're foreseeing a weapon on the property. Each instance in which it wasn't addressed and gotten to the bottom of by Dr. Parker is evidence of gross negligence and indifference. But as Dr. Shufflebarger testified to our expert, ultimately, in culmination, it is absolutely shocking. It's absolutely shocking, the facts of this case. And she used those words, which are words that are parroted by the Supreme Court and the courts as it relates to instructions, whether the conduct shocks the conscience, but is somewhat less than reckless indifference, which is sort of how the courts quote that language. And so, for the reasons stated, Your Honor, I think we've demonstrated sufficiently at this stage for a jury to determine the finding of the assumed duty of care. The assumed duty is recognized under the law, as Your Honors previously articulated, and that the evidence before the court is sufficient to demonstrate that there's gross negligence.
Thank you. All right, the issues that have been raised are issues for the fact finder, which in this case is the jury to decide. At this time, the court finds that there is sufficient and credible evidence that the defendant assumed a duty of care, breached that care in a grossly negligent manner, and that breach was the proximate cause of the plaintiff's harm. That will be all for the jury to decide. I deny the motion to strike. All right. Yep. All right. Having said that, you said you have one witness ready, or did you need to check it out?
Let me check to see if they're present. They should be here. It would be Deputy Thomas Blythe. Let me check right.
He's here.
He's here? All right. All right. Bring in the jury.
Your Honor, before you do that, I have a motion with regard to Blythe.
Oh, that's right. Okay, I apologize. You did warn me. All right. Go ahead.
I thought you do it before the jury.
Yes, sir. That's fine.
Corporal Blythe.
I've received notice of this.
He's
Just
a
got
trial.
to call him as a witness. Yesterday, he represented to the court that he wanted to call Officer Corporal Blythe for purposes of impeachment of a witness who has testified to an inconsistent prior statement. That's what he said yesterday. He did not release Blythe. He's now bringing Blythe back. He represented to the court that the purpose of this corporal testifying was to say that Amy Kovac had said something differently to him. As the court is full aware, Rule 2-613, prior oral statements, and I have seen this in a number of cases, the only way you can impeach Ms. Kovac from a prior inconsistent statement is to have presented under 613 that statement to her, let her explain it or not, and then if there's an inconsistent statement, then you can question her credibility. That was not done, and therefore we don't believe, if that's the purpose of Blythe, then he cannot testify because they did not follow the process or the rules. Hearsay, one, secondarily, but 613 would specifically bar it, as would the Rule 403, 8.01
All right, so is that your intent?
There's twofold intent, Judge. There are some statements that would otherwise qualify as hearsay, if not for their truth. One purpose would be for impeachment, but I understand the arguments are well taken.
Thank you.
By Mr. Drake. But the evidence, the law in Virginia, you can also use third-party witnesses to impeach by contradiction. They can testify to what another person said. They can then call Ms. Kovac again in rebuttal. They just need an opportunity for cross-examination. That is all that the rules require. So I would push back on that. Secondarily, Judge, I think there are additional statements on those videos that show her state of mind. And it is relevant for the jury to see that, because although she makes statements, they would not be offered for their truth. They can show and demonstrate to the jury what she was thinking at the time she was investigating the events leading to the shooting. The jury needs to see this to determine how to assess the material facts in this case. It would be fundamentally unfair to deny them this opportunity. I would suggest that the court, these are like 11-second clips, 20-second clips. Can I show them to the court? We can view them, and you can make that call.
Well, I think we, as we talked about previously, allow him to voir dire the witness. I think I've got to hear everything that they want to try to do, and then I can rule on it question by question. So,
Live in front of the jury?
no, right. We'll do that before we call the jury
Well,
in.
procedurally, we have a problem. Can't impeach your own witness. Can't do it. And two, obviously the purpose, as he stated yesterday, before he read the law, was I want to impeach her for a prior inconsistent statement. So now to come forward with a new theory, we've got to understand the context and her state of mind. The state of mind is to ask her on the stand, not to ask a videotape of Officer Blythe.
Right. Well, I've got to see it first, and then I'll hear arguments. So I think we need to proceed in that fashion.
Thank you,
All right.
Judge, you want me to just direct the council table or the rostrum?
No, from the the middle there.
Pardon me.
No, he remains sworn in. I'll ask him that first thing. Blythe, you remain under oath.
Yes.
Thank you.
Just a moment, Your Honor. Let me just retrieve my notes. Good morning again, Deputy Blythe.
Morning. Or afternoon.
Afternoon, rather. Deputy Blythe, you recall yesterday you offered testimony about your response to the Richneck shooting on January 6, 2023, correct? And you recall you testified that when you arrived at the school in response to the reported shooting, you encountered some of the staff and teachers there, including Dr. Ebony Parker, as well as the reading specialist, Amy Kovac. Do you recall that? And I believe your testimony yesterday was that in the course of your encounter with those folks, Ms. Kovac spoke to you and told you about what happened leading to the shooting, right?
She did.
At the time you were speaking to Ms. Kovac, were you equipped with your body-worn camera?
I was.
And did it record your conversation with Ms. Kovac?
It did.
And would you recognize that video shown to you again?
Yes.
Brian, if you could please display Defense Exhibit 57A8 for Mr. Blythe.
He had something in his pocket. I said, keep him in your eye. You know, and I went to hold my AP.
Your Honor, can you see the recording?
Yeah, I can see it. I couldn't really hear it great.
So I would just start back from the beginning, and could you please play it for the benefit of Deputy Blythe in the court, please?
He had something in his pocket. I said, keep him in your eye. You know, and I went to hold my AP. And, you know, as we were just watching him and thought if anything was a toy.
So, Judge, from an evidentiary.
So hold on one second. Is there any objection to that?
Yes, Your Honor.
Okay, and what is the objection? If it's the same one, I just want to make sure we're all on the same page.
Well, first of all, he secondarily indicated that it was for state of mind. Amy Kovac's state of mind is not relevant for purposes of her statement. I stand on 613 in that she was not presented with a statement, and so if she wasn't able to explain her statement, it is an extrinsic evidence to impeach, which is not permitted under 613(2), and her state of mind as to what she said is not relevant for her understanding.
Do you have a response to that?
And the other comment, when I missed it, she said, "We thought," in that statement that we just heard. We don't know who we thought and what the timing was for purposes of the we and who said what to who. And so for multiple reasons, it's not proper, it's speculative.
All right. Do you want to argue?
Yes, Judge. First, with respect to relevance, Amy Kovac's state of mind is relevant because we will have an expert that will testify for the defense, and it will be well established in the evidence that in assessing whether, how, and when to respond to a reported threat, an administrator needs to consider the subjective independent assessments of their subordinates. And so if Amy Kovac has come here and told the jurors that I was banging on this administrator's door, I was telling her this is a gun, this is a legitimate threat, you need to act now, and yet she has denied, she's maintained that, look, I was telling her and she was not acting. This is someone who's the crux, a crucial link in the chain of conveying the information from the people on the front lines to the administration. It's not just a credibility issue. It's not just offered just to impeach her. It does impeach her. It is inconsistent with what she testified to previously. She denied in her testimony. She said that I subjectively thought that this was a toy gun. Yes, but I never told that to Dr. Parker. And here, number one, she does on this video say, in fact, she heavily implies, if not expressly says, I told Dr. Parker, quote, he had something in his pocket. I said, keep him in your eye, you know, and I went and told my AP, you know, this and this, and we were just watching him. And if anything, we thought it was just a toy. She's saying in the context of reporting to the assistant principal, she told her that they thought, if anything, was a toy. The jury, seeing that evidence, can put two and two together, and they can infer, it's a fair inference from that evidence, that what Kovac was saying to them at the time of the incident was, me and Zwerner, or another third party, were watching JT. I went to report what we saw to Dr. Parker, and I let her know, we thought, if anything, it was a toy gun. That is significant evidence. That is something the jury should hear. I understand that ordinarily, oftentimes, when you impeach with a prior inconsistent statement, it is typically done right there on the stand when you confront that person, but all they need is a fair opportunity for cross-examination. There's nothing here where they have an opportunity to call her as a rebuttal witness, to bring her up on the stand and explain it herself. There is a risk there. She could be subject to cross-examination again, but that's not my problem. And also, the defense has no obligation to disclose the purpose for which it's offering its evidence in advance. We can offer it for multiple purposes. It is relevant. Her state of mind demonstrates that this is a lady who's banging on the door saying gun, 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 and now she's telling there on the scene in clear digital evidence that the jury can see that she's saying otherwise. She's saying, I thought this was a toy gun. She minimizes the threat. If we take that away from the jury, we don't know what the outcome is going to be. This is significant. It would be prejudicial. It would not be harmless error to exclude this.
But can't you call her yourself? She's still a subpoenaed witness in the case. And then I think for impeachment purposes, you'd have to ask her if she said that or not. So I don't think it comes in under impeachment at this time. Did you have a state of mind response to that?
Well, what he just said proves why it can't come into evidence.
At this time.
Period. First of all, he's failed to give the opportunity for the witness to explain herself. But what he now wants to use is the jury can infer that this video statement that was done after the fact to the officer must be what she told the defendant, and they should be able to infer that. Let the defendant take the stand and explain what she heard or she didn't hear. You don't get to put on an officer in a videotape when you failed to do it in the proper cross-examination process to allow her to explain herself, and then use we and inferences without the defendant taking the stand and say, this is what CONVICT told me or didn't tell me. Now they're trying to infer stuff from a hearsay statement. Can't impeach your own witness. If he puts her on the stand to ask her, he cannot impeach his own witness.
No, I completely agree. I'm not
And
going
so
to
how does he come up now with another officer with a videotape to try to impeach her with extrinsic evidence, which is not allowed under the rule, then try to come up and say, hey, you get up on the stand, I want to impeach you by your prior inconsistent statements, which you can't do. Put the defendant on the stand and ask what was said.
But
That's how you do it.
But doesn't the exception for hearsay, which it is, state of mind, that can be for both witnesses, plaintiffs, and defendants? Isn't that true?
But trying to keep Mr. Benioff from knocking me over. But the state of mind here is not the state of mind of the discussion with the defendant when the evidence was coming through as to whether or not there was a gun threat. That's what you said on the stand. And this is 2:18, so we're way past the shooting and way past, hours past, when she spoke to the defendant.
All right, so I'm going to sustain the objection on impeachment, but I'm overruling it as to the existing mental, emotional, or physical condition state of mind. Rule 2, 803, subsection 3.
Your Honor, may I just address that for a moment?
Huh?
The then existing state of mind exception, which is 803.3, applies to the then existing state of mind of the individual making the declarant statement. The issue here is that there is case law that demonstrates that if the declarant is attempting to demonstrate the state of mind of someone who is not the declarant, it is inadmissible for that purpose. This comes up in circumstances where people opine or testify that we had a plan to do X, Y, Z, and that is offered in those contexts. Say we had a plan, as in that's our state of mind, to do something in the future. But the issue here is the we, as is reflected in the statement, is an attempt to reflect the state of mind of the other in this context. If it was I, Miss Kovac, thought it was a toy gun, different. We agree. 803.3 might apply in that context. But they've told the court that the only relevant purpose is not whether Amy Kovac thought it was a toy gun. It's that we can infer from the statement that somebody else thought it was a toy gun because it goes to their state of mind. And that is explicitly impermissible in 803.3.
Well, we can give the jury an explanation, if there's no other way that this comes in, that this statement only goes to Ms. Kovac's state of mind.
And in that case, I think the exception might apply, but the question then becomes, if this is only being offered for the state of mind of Ms. Kovac at 2:18 p.m. on January 6th, what is the relevance of her state of mind at 2:18 p.m. on January 6th? If this was a recorded statement of Ms. Kovac, using their words, hindsight 2020, if this was a recorded statement of Ms. Kovac at 1:40, at 1:45, at 1:55, before the shooting took place, and she's expressing her state of mind in those contexts, then her state of mind may be relevant to what ultimately occurs. What we're now talking about is trying to say what her state of mind was at 2:18. Let's then say and infer what it was from that based upon an undisclosed period of time. And then the question is, how is that even relevant if it's at 2:18? Here's the statement. Correct. As pointed out, the rule by title is then existing. Then as in 2:18 p.m. In the evidentiary book, this is when they make fun of me about my nerdiness of evidence rules. Ultimately, it's all about reliability. And the issue with reliability when we talk about people talking about prior states of mind is that we've lived life for 2 hours. And it is speculative, even Your Honor sustained an objection earlier in this trial when we said, well, you would have done or you could have done different. And that's because we would have or we could have are all questions of speculative time frame, even if it's our own being. And so the then refers to then, 2:18 p.m.
Such as motive, you can have a plan. That's beautiful.
Joseph, I could just respond to a few quick points.
You may.
Just revisiting the relevance issue briefly. I know this is not the crux here, but the fact that opposing counsel is vehemently opposing the introduction of this highly probative evidence demonstrates its relevance. They don't want this to come in because the jury needs to hear about it. Regardless of that, in addition, I think that the jury, when they watch this video, they can assess Ms. Kovac's demeanor, they can see how she's responding to the deputy's inquiries, and they can assess and weigh her credibility just by watching the video and seeing how she reacts and responds. This is the crucial witness that the jury needs to decide her credibility. Yes, prior inconsistent statements is one piece of that, but it's also just watching her demeanor. They talk about that in appellate law all the time. You can't do that just from a cold record. The jury has to do it, and the jury can't do it without watching the video.
But you're saying it's trying to impeach her. I'm not going to allow you to do it this way. So I'm going to agree with plaintiff's counsel that her state of mind, I would allow it in as a state of mind, but her state of mind isn't relevant at this time. And so I'm going to grant the objection, sustain the objection.
Well, Judge, I wanted to be clear. I was addressing the impeachment argument, but I will offer it for a dual purpose. That is why I offered it. I had two bases to offer this. One was to impeach and one was to show her state of mind. I agree with the court that it is relevant, especially it's conditionally relevant at a minimum, because we'll have an expert to explain this to a jury, that Ms. Kovac's subjective state of mind mattered for the expert to assess, for Dr. Parker to assess.
But I haven't heard that testimony yet. I haven't heard your expert yet. So maybe it comes in at that time. It just as the beginning of your case. I'm not going to do that.
Then I would ask the court to reserve ruling on this.
At this time. I mean, you have other ways you can try to introduce it. I'm not disagreeing with you that way. It's not forbidden. If there are other ways to introduce it, I'll allow you to do that. Or if it becomes relevant.
Thank you, Judge. I appreciate it.
All right. So objections noted with leave to try to get it in later. All right.
Judge, for purposes of expediency, let me just proffer, if I may, the contents of the other video. I think these are similar issues that we would grapple with.
Yes,
Is there any
any
objection?
objection?
Is there any objection?
I object to everything about this witness and all the video tapes.
Okay.
I think we should play the tape.
Okay.
Brian, please queue up Defense Exhibit 57A. A8, excuse me. Oh, pardon, A10.
But we did check his bag, like what we thought, you know? And she didn't say anything back to me, like he moved something back from his pocket. Like, I mean, again, so that's 6-year-old.
So you can see clearly, Judge, going in reverse order. Again, it's a 6-year-old. That goes to the heart of Amy Kovac's state of mind. At the time, shortly after this incident, she's telling law enforcement, someone who has authority, someone who you don't want to mess with, that you want to be candid with, especially when she's taking ownership of investigating this and saying, I was the first one in the room. She's talking to this person. The jury can see this is her live when she's telling people for the first time what happened. And she says, it's a 6-year-old. It's a 6-year-old. That's showing her state of mind, and it will be conditionally relevant at a minimum when we put on our expert to explain, yes, the demeanor of the reporting parties is a factor for the administrator to assess whether, when, and how to respond. Let me just make this concrete. If Kovac comes into the office and says, there's a gun in the building, we saw it, you need to go right now, get up right now, get out, get over there. It's materially different from going into the office and saying, I think it's a toy gun, he's a 6-year-old. Her demeanor is what matters. And that's something that Dr. Parker had to consider. And it is part of the heart of this case. So I think it goes to the...
There's just not enough. You haven't put on enough of a case to make it relevant at this point in time. I'm not denying that at some point it could be relevant, but at this time it's an improper impeachment, and at this time it's not relevant. Did you have anything else you wanted to add?
I don't, but
Okay.
there's someone at my table that might.
Your Honor, I think it is flawed from the outset. And the reason it's flawed is the argument now that the demeanor of the witness is pertinent to the jury because it goes to the administrator's state of mind of how they subjectively interpreted the demeanor of that individual when they made the report. How are we to say that her demeanor at 2:20 p.m. is the demeanor at 11:40 p.m. or 11:50 p.m.? And so, in fact, it is the opposite is true, which is that if Your Honor permitted this for that purpose, which is to demonstrate the demeanor of a witness, so that defense counsel can argue that that demeanor reflected the demeanor at the time that the reports were made, that is flawed, ab initio.
I understand, but they may be able to put on a case where it does either become relevant or impeachment, and we'll take those up separately if we ever get there. So I'm going to grant the motion on those grounds at this time.
Thank you, Your Honor.
Okay. Any other questions for the corporal at this time?
Thank you.
Okay, and obviously he's to remain under subpoena, correct?
Yes, but I'll be in contact with you.
Okay. All right, so obviously the jury's not here, so that's why we did this. So I'm not permitting your testimony on those grounds right now. However, you are still under subpoena and subject to recall, so please don't discuss your testimony. And until then, or someone tells you that you're released, you can't talk about it, okay?
Yes, sir.
Thank you very much for being here again. All right. Do you have any other evidence you can present this afternoon?
This was our sole witness. We did our best to try to recruit some others, but we've also consolidated our case. I will confer with the lead counsel on this and we'll make a decision.
All right. So you want me to release the jury and then you talk and then I'll come back out, or we're just ending for the day once?
Well, you had indicated earlier this morning that the 7 o'clock, I read your comments to suggest the 7 o'clock rule of exchanging witnesses would apply since we came to court today, having advised them on Monday that we'd be finished Wednesday afternoon or Thursday morning with only one witness. So we don't want to wait and find out what we're doing tomorrow until 7, since we waited last night to find out there was one witness who wasn't even going to get on the stand. So we'd like to know if there's a time that we could get it 5, 4, or wait right here and do it and say, tell us who your witnesses are tomorrow.
All right, so you're asking for some more time, is that correct?
Just confer with counsel.
Okay. And as I said, I can bring the jury and release them, then step out, and then I can come back. I'm fine with that. Me getting up and down isn't a problem, it's them.
Yeah, I would let them come and go.
Right.
My only concern with that, just to flag it, is if they're released and they have no evidence tomorrow, and they're being asked to come back, and then we just release them again tomorrow.
Right.
That would be my only hesitation. That's your honors. This is your courtroom. This is how you handle it. But if their position after conferral in 20 minutes is we don't have any fact witnesses, and we have no evidence, I mean, we take issue with that administratively.
I understand.
But we understand that the experts were scheduled for Monday. I wouldn't want the jury to come back tomorrow morning and
nothing.
Yeah, let them wear their costumes and be with their family if that's what's going to happen.
Right, I understand. All right, I appreciate that approach then. How long are you going to need to discuss strategy, I guess, or figuring out if we can call witnesses tomorrow? And I want to say, I am sympathetic to you having set up your experts on Monday. I have no problem. We discussed that the whole time getting ready. But I would like to do something, if we can do anything tomorrow, and whether or not we need the jury. I certainly, if we don't do anything tomorrow, I want jury instructions worked on. That would be, okay.
I think we got about 15, 20 minutes.
I'll grant you that, and then I'll just go address the jury that they're not going to be needed for the rest of the day. We're determining the schedule from this day forward, and we ask them to be patient with us. Okay. All right, court will be in recess for hopefully 15 minutes. All right, thank you.
Propose we reserve tomorrow. We release the jury tomorrow. We can handle jury instructions. Come back Monday and address experts. But I also ask, given the court's ruling, leave to potentially call Deputy Blythe. To establish the requisite foundation necessary to get that evidence in.
Okay. All right. Did you want to work at your offices or on the jury instructions or here?
It's a good question.
Okay. I try to ask good questions, I promise.
That's a great question, honestly. I'd be comfortable doing it by remote with the court and with counsel. The thing that I will sort of flag is that there are going to be issues as it relates to the substance of the experts, obviously, which were motions in limine. So we may, if we have time, do that tomorrow, and to the extent that maybe they're available. I haven't talked to them about this, so I don't want to put them under the gun. To the extent they're able to appear via Zoom so that we can have that proffer, that may be helpful too.
Okay.
Other than that, we would take issue with fact witnesses being called Monday in light of the delay, and we would ask that anyone that is under subpoena, that is not being called, be allowed to be released. There are folks that wish to be in the courtroom to observe some of these proceedings, and they haven't been able to do so because they're still under subpoena and haven't been notified that they're going to be called.
Your Honor, I don't know if my experts are available tomorrow for a proffer. My understanding is the issue with Dr. Klinger, who matches Dr. Shufflebarger's, we've worked that out. I can't represent to the court that there's only one other expert at issue, and that's Dr. Means, and I can't represent that he's available tomorrow.
Yeah, I mean, it's going to make for a frustrating Monday, but I understand.
Yes.
We could, and I'll alert the court that there's forensic psychologist, I think, is something that we could take up without a proffer. We don't think that the witness should be permitted to testify in toto, but we don't have to take that up today.
Right.
That's
I think it's going to be a Monday problem, the way that we had planned this. And as I said, we did the best planning we could. So
I'm not aware of any motion regarding Dr. Hagan, the forensic psychologist.
It wasn't challenged. It was not challenging the motions in the meeting.
It is being challenged.
All right. Well, I guess we'll just have to take that up when we can on Monday. I think. I don't know how else to do that. All right. So I can be available by Zoom, obviously, or WebEx tomorrow up to a certain time, seeing as it's Halloween, and to take care of any disputes. But I would appreciate a set of agreed upon instructions, one set of plaintiffs offered and objected to, and defense offered and objected to. For at least I can get myself and my law clerks who have abandoned me to there you are, to start looking this weekend at some of those issues. So I would appreciate that.
We need to rest in front of the jury.
Okay. Yeah, because we got to bring them in and talk to them anyways. All right, so agreement that will all be available by WebEx tomorrow. I'm going to release the jury for today and tomorrow to report Monday at 9 a.m. And jury instructions, hopefully the three sets of instructions by 1. Is that a possibility? All right. All right. Is that agreeable? All right. Very well. No. Or give you that's one too. I'll just text you my numbers.
Not jurors in the box.
Thank you. All right, ladies and gentlemen, we have a motion that's going to be made by the plaintiff in your presence, and then I'm going to address you.
Your Honor, plaintiff at this time rests their case.
All right. The plaintiff's evidence has now concluded, so we are going to move on to the defendant's case, but we are not going to do that until Monday morning at 9 a.m. So you are done for the day. You are also done for Friday. You can get caught up with your families and or work, whichever order you want to put those in. I leave that up to you. And also enjoy Halloween as well. So, as always, and it is very important because I'm not going to see you for 3 days. Ladies and gentlemen of the jury, we are now recessing for our break until Monday at 9 a.m. when I ask you to be back in the main courthouse to check in. During this recess of this trial, you are not to begin the discussion of any aspect of this case. Upon your return, you are requested to go immediately to the main courthouse, and then you will be brought down here. You are not to engage in any conversation with any of the parties, the witnesses, the attorneys, or any of the spectators, including the media. You are not to go to the scene of this case or undertake any independent investigation, including the internet or other electronic means. No one should approach you and discuss this matter, and you should not remain within hearing distance of anyone discussing any aspect of this case. That includes your family members and loved ones, and tell them you are, by order of this court, not allowed to discuss or be within hearing of any discussion of this case. Of course, as I've indicated, this includes viewing any newspapers or television or listening to the radio. Watch a lot of sports or scary movies. Those are your 2 choices. You must also leave your notepads and any notes that you have taken with my deputy. He will make sure no one looks at them and they remain solely in our custody. If you are approached by anyone concerning your jury service during this trial or this recess, make that fact known to my sheriff or me. We will take it up at Monday at 9 a.m. Thank you for your patience with us. You are excused.
Please rise for the jury.
All right, then any witnesses you are able to release, I would appreciate you doing so that they can either come back or be released from their witness list. Anything else to take up?
We okay to leave technology and stuff
Absolutely.
up as it is?
Yep. No problem at all. Anything else from the defense? All right, I will hear from you tomorrow. Thank you all very much. Court is in recess.